Oh, good morning, everybody. Thanks for agreeing to start slightly earlier this morning. This is day 3 of the application by Willowbank trustees for 2 resource consent applications to the Porirua City Council and a series of water and discharge permits to the Greater Wellington Regional Council, all in respect of quarry applications that seek 2 durations, a short-term consent of 5 years and a longer-term consent of 35 years. So as I said, we're into day 3 and we're going to hear shortly from Waka Kotahi. Welcome, Ms Jenkins, Mr Chair, and I think Ms Kelly is present also. Welcome. I have just 3 housekeeping matters, and I'll also invite any other procedural matters before we kick off. Firstly, Mr Matheson, for some reason I've ended up with a condition set that's undated, and it says that the condition set is based on that provided by Greater Wellington Regional Council on the 22nd of July, and the same for the Porirua set. I'm going to bin this, I think, because I'm working off the hearing condition set dated the 12th of August, and I encourage everyone else to do the same. So, unless there's any violent objection. Okay. I've also, this is more about document management, I've received these plans which are largely blow-ups of the bund. Can anyone tell me where they might have come from? Are they part of the landscape set?
They were in the updated project description, but they're part of wider plan sets.
Yes, that's probably where they come from. So that would have been from Mr Walsh?
Attached to Mr Walsh's project description.
It was attached to Nathan Baker's evidence.
That makes sense because the staples come adrift on that.
Oh, yes, that's where they've come from.
Yes, thank you. So Mr Baker's pile. Okay, thank you. The second matter is I made a few observations at the beginning of the hearing on day 1 about protocols and the like, and I just want to reiterate a couple of those, and I guess the main one being just when other submitters and presenters are presenting, please demonstrate some courtesy and respect to those. I don't expect any chatter in the background or any comments. As I said, the rule of thumb is treat those as you would expect to be treated when you're presenting also. So just wanted to reiterate that. And thirdly, and this is something I should have mentioned on day 1, and I will make an official note of it because it's on the record in other forums, and that is as a member of the Porirua City Council Hearing Committee on the District Plan Review, I've reclused myself from those provisions relating to the rule zone relating to quarrying. And that was a sensible thing to do, but I was reminded of perhaps the need to do that through some correspondence from JEPS some months ago. So what that meant in practice is that I'm still a member of the rural chapter hearing panel, but when it comes to hearing and deliberating and deciding on evidence relating to quarries, I won't be present and won't take any part whatsoever. That was seen to be the easiest and most cleanest option to deal with that matter. So, just not sure who's online. No one. Okay. Well, it's on the record, and as I said, it's on the record for the district plan review also. And I apologise for not mentioning that on Monday. Well, that was all from me. Did anyone, before we go to you, Ms Jenkins, did anyone have any other matters they wanted to raise at this point? That's a good sign. Thank you. Ms Jenkins, we're in your hands. What I can tell you is what we have in front of us is 6 pieces of work. We've got a primary piece of evidence from yourself and Mr Chow, a summary statement from yourself and Mr Chow, and an updated summary statement. We've read the first 4, but we haven't read the last 2, which have just obviously come in this morning. So we're in your hands as to what you want to do. But if it assists in any way, there are 3 issues or 3 particular pieces of information that we would like to focus on. That's the presence or otherwise of acceleration and deceleration lanes. The status and nature of works associated with stages 2A and 2B of the State Highway 58 program. And including timing, funding, authorisations, and you touched on some of those matters yesterday. And thirdly, any particular comments you've got on the condition set. In particular, whether Waka Kotahi has a position on two of the key matters in the condition set relating to duration, that's the Greater Wellington one, and hours of operation, which is the Porirua one. And when I talk about hours of operation, both the extended morning period and the extended evening period. So hopefully that sort of précis is of some assistance in terms of focusing your presentation today.
O morena, tēnā koutou katoa. I will ask Mr. Chow to address the first point around deceleration and acceleration changes. As you've noticed, we do have Ms. Kelly here from Waka Kotahi. She has provided me with a little additional information about the State Highway 58 safety improvements. But with your indulgence, it might be best for her to provide you with, I guess, from the horse's mouth information about this rather than relayed through either Mr. Chow or myself.
Very sensible.
And then I will comment on conditions as requested. So I'll ask Mr. Chow if he could go through the points that you're talking about. In his summary statement, he was just going to cover things off generally, and I think it's probably of benefit to
that's
just
fine.
close things out, noting your observation around the interest in the lanes themselves.
Welcome, Mr. Chair.
Good morning.
Now, which document would you want us to go to?
I think the easiest will be the updated summary statement.
Of this morning. Yes.
So I acknowledge that we haven't given you enough time to read that. So I'll go through that, hopefully slowly. And it's my preference to probably talk it through or go through the whole document before, welcome any questions after that.
That's right. We can take your first two paragraphs as read.
Okay, great. Yeah, so just referring to my updated summary statement in in section 2. So I just want to say a few clarifications. So at paragraph 6.31, line 3 of my evidence in chief, I stated that the post-transmission gully opening peak hour traffic volume provided by Greater Wellington Regional Council is higher than Mr. Rose. And there I wrote 1,200 vehicles per hour. And just to clarify, that number should be 1,000.
So you'd like us to make that change now?
Yes. Yep. I've also considered, when I prepared this updated summary, that the applicant's reduction in maximum of 45 truck movements per hour to 30 movements per hour. I support this reduction and consider that as an appropriate response to concerns about vehicle movements. It has not, however, changed my recommendations as discussed at paragraph 7.3 in my evidence.
Yes. And just to be clear, you're referring to the long-term consent there where you're referring to that reduction?
Yes, that's right.
Yes.
Yeah, so the purpose of the updated summary statement really is, I've considered the evidence presented by Mr. Kelly and Mr. Wanty yesterday and have updated my summary statement to focus on those issues discussed. So hopefully there'll be some clarifications and also my position regarding those items. So issue 1, regarding the State Highway 58 westbound volume threshold. So I still consider that the maximum number of turning trucks, that is right turn in, under the long-term pre-State Highway 58 upgrade should be reduced when that threshold reaches 1,400 vehicles per hour.
Yes.
Following the long-term post-State Highway 58 upgrade, i.e. with the roundabouts, etc., and wire ropes, I consider, or I rephrase that as a medium barrier, I'm not sure what type exactly, I consider that the maximum number of turning trucks, which is left out, also be reduced when that westbound traffic exceeds that threshold of 1,400. On the assumption that the vehicle movements per hour being reduced from 45 to 30. Issue number 2, regarding the extent of camera coverage and hand in hand regarding the monitoring.
Should we just pause there, Mr.
Yeah.
Chair? Did you want to do this on an issue-by-issue basis, or are you happy to do it at the end?
Issue by issue.
Yeah, we might just do this on an issue-by-issue basis, might be more efficient.
Yep.
So we'll just see if we've got some questions from the rest of the panel.
Commissioner, can I just confirm, I'm sure there's not a misunderstanding here, but a reference to 30 movements normally means in and out. The proposal was 30 exits or 30 entries.
Yes,
So it's 60 or 90.
Yes.
So just the reference to 30 movements per hour is 30 entries or exits, so a total of 60.
yes.
Just want to make sure that was clearly understood. Yeah.
That's paragraph 3.2.
That's my understanding. I agree with that.
Yeah, sorry, it's just movements normally applies to in or out total, so I'll just...
So when you refer to 45 to 30, it's really 90 to 60.
That's right.
Thank you.
So just you're saying that 3.2, you're having the same position in terms of the proposed condition as marked up in Ms Jenkins' attached to her main evidence. Just trying to find that condition.
63.
It's condition 64, isn't it?
Yeah. So on the markup of Ms Jenkins' conditions, that still stays the same in your view, Mr Chow?
That's correct. I just want to clarify that we're referring to the same condition, condition 64.
64?
Yeah, that's right. So because of the reduction from 45 to 30.
To 30, which the applicant has
Uh,
offered.
Yes, that's right.
So that needs to change in the condition.
Yes, so in terms of that, 64AA, yep, that clause will be have to be deleted. Yeah, because that doesn't apply anymore.
Yeah, sure. Don't need that.
Yeah, but the rest stays the same.
Right, okay. Right, thank you.
Just hold there for a moment.
Yep.
Okay, there's just a slight difference in numbering between the hearing condition set and Miss Jenkins' set. I think you've referred to AA, but I think that would be A1, I think, in the condition set. Is that correct? A Roman numeral 1. And just so we're clear, the applicant's position is that that should be deleted also. So there's a matter of agreement there.
Correct.
Okay, thank you. Just trying to recall Mr. Wanty's position yesterday, and I think he was saying that he didn't think with the reduction from 45 to 30 or 90 to 60, that what followed was necessary. Certainly he didn't think that the reference in A2 or AB to 1400 was necessary. Was that your recollection, Mr.
I think
Chow?
my recollection is that it's only not necessary if the acceleration lane is available.
Thank you.
That accords with my recollection. What he didn't say was what his position would be if there wasn't an acceleration lane.
Thank you. Just trying to get the ducks in a row.
And later on, I will comment on the acceleration lane. So
I
hopefully
understand that, yes.
will address
Yeah.
concerns.
The reason for the interruption, Mr. Chair, is we're balancing about 5 documents in front of us, so
I understand.
comparing the conditions here, and unfortunately my one from Ms. Jenkins not in colour. That's my fault. I printed it. Right. So now, if anything further on that first in issue 1, no, I think we can move to issue 2.
Yep. So regarding issue 2 and hand in hand issue 5 regarding the monitoring, so I consider that the conditions specified in conditions 67 to 72 with the amendments recommended by Ms. Jenkins are satisfactory in ensuring monitoring and reporting of this intersection.
Okay. Well, that automatically raises a question: is how does that compare to what was discussed at the joint witnessing conference and reflected in the JWS?
Yeah, in the joint witness conference, the discussion was that we agreed that with what is already in the conditions, as well as increasing the crash extent to 400 metres, that is sufficient.
Okay. Has that, the JWS wasn't accompanied by any further updates to the conditions, was it?
No, not yet.
No, but it will be.
Yes.
Yes. Okay, that's fine.
And Commissioner, I intend on just going through those conditions in my
Okay.
summary, just clarifying our understanding of where
Right.
each one is at,
Okay.
drawing on the outcome of the joint witness statement.
Yes.
Because the set that we've got, there are some changes to that. Oh, hang on, I'm looking at the wrong one. Sorry.
Okay. Issue 3.
Yep. So there were discussions regarding the truck gap acceptance. So in my opinion, as outlined in paragraph 6.29 in my evidence, that has not changed.
Still minus what that is.
Yeah, so that's 7 to 8 seconds with that sensitivity check of
Yeah,
the
right.
10.35.
7 to 8 seconds, yes.
Yeah.
So that would indicate some alignment with Mr. Kelly on that and Mr.
Yes.
Rowe.
That's correct.
And some disalignment with Mr. Wanty. And I think he preferred the higher, was it the 10.95?
From my recollection, yes.
And I think that's reflected in the JWS.
Yeah.
And Ms. Fraser, sorry, too, yes. Yes, sorry. Okay. Thank you. Any questions?
No.
The next issue,
Yep.
4.
Issue 4 regarding the maximum delay threshold. So in response to Mr. Kelly's disagreement to the necessity to ensure the entry movement to be less than 120 seconds for the pre-State Highway 58 upgrade, I would like to emphasize the need, in my opinion, to condition the average delay to be less than 120 seconds. I disagree that this is academic. Based on Mr. Kelly's evidence yesterday, as this perimeter, as he highlighted, is determined by a combination of variables. So these include the opposing flows, the spread of the delays due to human nature, as demonstrated in the model, and the sensitivity of the gap acceptance. So having this 120 seconds is one straightforward mechanism to determine when mitigation is needed, which is highly critical in the function and operations of State Highway 58.
Okay. Well, there's two questions that automatically arise there, Mr. Chair. The first one might be answered by Ms. Jenkins, and that is, how do you condition that? That aside, I guess the second question is, how do you police it? How do you monitor it? How do you enforce it?
Yep. So that is part of, I mean, to my understanding, in the conditions for the, I think it's part of the TMP as well, that they need to, the applicants need to determine a method to work this out. In my opinion, there are methods available. So with the video, just recording it perhaps cannot give you that information straight away, but there's definitely ways to analyze it through some digital means to determine whenever that delay is more than 120 seconds through those camera footage.
Yes.
But of course, the methodology is part of the applicant's TMP submission, which needs to be approved by Waka Kotahi. Yep.
Yes. So let's just jump to the case, to the chase on that one. Are you saying that needs to be a specific condition dealing with the 120 seconds pre-State Highway 58 upgrades, or are you saying that's a matter that should be dealt with through the TMP?
I understand that has to be part of the conditions that needs to be used to tackle this specific point.
Yep. But the TMP is part of the condition framework also.
That's right.
So it's whether it needs to be a bottom line condition stipulated, or whether it's a matter that the TMP needs to address, analyse different methods to achieve it, and land on one and ensure monitoring of that method in case it's not working.
I could give a quick point of clarification. We have had just this morning a bit of an update and agreement, so it will be both.
Okay.
We've just agreed with Ms. Jenkins that it will be part of the TMP, as currently worded in Ms. Jenkins' conditions.
Okay.
And we also think, as long as that's sitting there and we can determine the methodology to do it, which I think will be review conditions, it should also be a bottom line sitting there. So I think, Ms. Jenkins, you'll update once you go through your condition list.
That's useful. Thank you. Just in terms of the practicality, Mr. Chair, I mean, at 30 exits, that's, I mean, I think Mr. Wanty made this point yesterday, that's, one truck every 2 minutes, isn't it? Which is your 120 seconds. So, I mean, it doesn't become self-regulatory in that sense? Mm-hmm. Potentially?
Yeah, potentially. I mean, my opinion based on it is really about keeping the functionality of State Highway 58. Okay. Whenever it's more than 120 seconds, that could impede on drivers or truck drivers in this case doing the likelihood of doing more irregular movements. So that's why I think it's a good mechanism to insert into the conditions. If they don't ever experience it, then good. Yes. That's the perfect scenario. But if it doesn't, if it does happen, I think the impact is quite serious and quite, So that's why I've conditioned that.
Yes. Did you hear Mr. Lukic's evidence yesterday, just before the lunch adjournment?
I haven't arrived for that, but I've read his evidence.
Yes. The position that he advanced was that truck drivers are professional drivers,
Yep.
are trained by him, that they are perhaps, in his view, the more I don't know, sensible drivers on the roading network because their livelihood depends on it, and they don't want incidents that a delay of greater than 120 seconds isn't really something that will phase them, in his view.
I mean, I'm not a truck driver. I totally agree with that the tolerance will probably be a lot higher. But it is about risk, and also there could be instances where it is irregular or out of the ordinary. Because, for example, yesterday I recall, I may be wrong, correct me if so, we can't control the arriving of the trucks into the quarry. So there's that potential that it will happen. And given that the Highway 58 is such an important route for the Wellington region, we can't even put that into risks of it basically blocked off, etc.
Okay, I think what the panel heard yesterday was that not that it's impossible to control trucks entering, but it's less easier to do that than trucks entering because they have more direct control over the leaving. But that's not to say that it's impossible to control trucks entering also. And I would like to encourage some line item in the traffic management plan to deal with trucks entering. And when we talked about different methods in terms of radio control and that sort of thing, particularly where the drivers are not Fulton and Hogan drivers, are other firms. So, okay, but it seems to me that based on what Mr. Baker just said and what Ms. Jenkins is going to tell us, that looks like there's been an agreement on a combination of bottom line and management plan approach to that issue. So we can probably move on to the next one.
Yep, issue 6. That's the last item that we discussed in our joint witness conference regarding State Highway 58 volumes for the use and analysis. So I consider my position on the basis of a number of parameters, i.e. impacts of free-flowing traffic, impacts of State Highway 58's operations and safety aspect, and delay to all users, resulting in the likelihood of risks and hopefully the mitigation of risks. On this basis, the key is to determine the triggers which would cause these adverse effects. And my conclusion is based on the threshold of the delay being less than 120 seconds, and when opposing traffic flows become 1,300, which now becomes redundant, and 1,400 vehicles per hour respectively.
So the 1,300 is now not relevant, it's just 1,400, Okay.
And presumably that goes to condition 64A, B or A2, Ms. Jenkins? Yes.
Correct.
Okay, thank you. Okay.
Yep.
3.7.
Acceleration and deceleration lanes. So in my evidence in paragraph 6.3, I stated that I support the applicant's concept design, including the lack of acceleration lane or deceleration lane, on the basis that these would not be critical in either safety or efficiency perspective. I would like to clarify that when I say deceleration lane, I actually am considering both the deceleration lane for the left turn in from the east and the right turn in from the west. And my greatest concern is actually on the right turn in, which my understanding, I don't think was placed in a lot of focus when we had that discussion yesterday. When a truck is actually wanting to turn right, needing to wait beyond the right turn bay and the flush median, and the following vehicle hitting the back of it. The severity of this type of crash is a lot worse. Hence, my support of the right turn bay design and principle based on the concept that we have.
That bay would hold two
Yeah.
truck and trailer units?
Yep, that's right.
And we're just talking about the short-term consent, aren't we, here? Because,
It will be both short-term and long-term
Pre-upgrade.
yeah, pre-upgrade, sorry, yes.
Yeah.
In regard to the acceleration or deceleration and the acceleration lane westbound, I agree that there are benefits to both of them, but there are also adverse effects, i.e. left-turning trucks slowing down could result in a perceived safe situation for vehicles to pull out and now effectively crossing two opposing lanes. Similarly, the acceleration lane could also result in an unintentional consequence of vehicles, and this could be trucks or just normal passenger vehicles, needing to merge unsafely. Other knock-on effects, like the increase in footprint of the corridor when the acceleration lane and the deceleration lane needs to be built, perhaps land take, road widening, etc. To me, selecting an appropriate gap, having a simple layout is preferred and outweigh the potential safety impacts. Hence, my position of the lack of an acceleration and deceleration lane as part of my evidence.
Yeah. Can I just ask a couple of questions on that? So the first point about left-turning trucks slowing down could result in a perceived safe situation with vehicles pulling out and then not really seeing what other traffic might be coming. I mean, presumably if you had a deceleration lane that took quite a bit of land and was quite separated, started early on and separated out, that would not be an issue. But then you're talking about quite a major change to the intersection, aren't you? But I mean, that would solve that problem?
In theory, yes, I believe so.
Yeah.
But in order to not have that impeding on that sight view, sight line of the turning vehicles coming from the quarry,
Yep.
I don't have any design tools with me, but I would say that sight distance will need to be way longer, and the width needs to be a lot wider.
And is your view that that's not justified? Necessary?
Yeah, I think that's the right word. In my view, it's not necessary, because I feel that in the situation that we have now, having that actually outweighs the to just having a simple intersection of what they're providing now.
I mean, you're probably not the right person to ask this question because of your relative youth, but I just wonder whether, with time, Mr. Wanty is keen on the deceleration lanes, and he referred to comments by a policeman, I think it was some time ago, about the big thing about lanes is to minimise that difference in speed between cars.
Yeah.
So can you comment on that in terms of what he was saying?
Yeah, from my recollection, I do agree with that.
Yeah.
The relative speed, if that can be differentiated, that will be obviously good.
It's beneficial,
Yeah, beneficial. But again, it's about the outweighing the need versus the effects. And in this case, I do believe that the applicant actually, sorry about my language because of my youth, but just taking the hit of actually reducing the capacity of their need to turn to make the turning movements. I feel that the deceleration lane is not necessary. Like I said, I'm not disagreeing that there's
it would be a benefit.
there's benefit. There's no benefits. There's definitely benefits. But in terms of the cost benefit of the two, I would say that is safe enough.
Yeah. Okay.
And I guess that's my
I just want to reiterate the comment about your youth was nothing to do with your experience or expertise. It was more probably what Mr. Wanty was referring to was some time in the past before you were a traffic engineer.
Yeah.
And I guess that's another question. Do you know whether there's been an overall change in safety? So perhaps back in the day, these lanes were seen as, you know, a good solution, and things changed, you know. They obviously cost a lot, they take a lot of land, so there's lots of things to take into account. Would that be true, do you think, from your experience? Or perhaps you can't comment.
Can you just repeat your question once more time?
Wondering whether the attitude, Waka Kotahi and the consultants that work for them, including you, their attitude to the safety benefit of deceleration and acceleration lanes has changed with time. In other words, Mr. Wanty might be saying that whenever that police officer he was referring to said that minimising that change in velocity was the most important thing, therefore lanes were the way to go, and Mr. Wanty's still saying that. I'm just saying maybe with the greater body of engineers that are involved in this, including yourself, that there has been some change in focus, and that perhaps lanes were seen to be a solution, well, you know, the best solution, but now things have changed.
The quick answer is no. I actually don't believe the need of deceleration or acceleration lanes is an old view. I actually think that there is the need in some cases in context. So that view hasn't changed. The engineering view hasn't changed. So I concur with what Mr. Wanty has said. But in the context of this intersection, my opinion is that the deceleration and the acceleration lanes actually outweighs the safety benefits of just having a simple intersection.
Yep.
When you say it outweighs, do you mean the cost of it or the?
No, I wouldn't say it's just the cost. I think it's just benefits of perhaps saving lives, benefits of just the overall operation of the intersection, because we are basically effectively we'll be making quite a big, complicated intersection for the number of I'll say users, and the number of users as well as the type of users. So that's my position.
Anything would be unnecessarily complicated in your view.
Yes, I agree.
Okay, thank you.
Mr. Chow, what I think what the panel's hearing there is that there's no one-size-fits-all situation here. There's not necessarily an industry view or a Waka Kotahi view. It's a case-by-case situation based on prevailing situation.
Yeah. Just to, I think, hopefully this coming answer answers a question. If that quarry is an interchange, for example, with, I don't know, trucks coming from, I'm not familiar with the Wellington area, but I don't know, from the like a huge arterial road, then because of the volume, you would design the intersection differently.
Yes.
And hence maybe acceleration and deceleration lane.
Yes. And if it was a cross intersection, it'd be a different scenario again.
Yeah, exactly. Maybe it will be a roundabout, in my opinions, right off the top of my head.
Yeah, just out of interest and complete this quite interesting discussion, Mr. Wanty referred to the 1965 Highway Design Manual and that which was the second edition, and the preceding edition was
I used the fifth edition.
Yes, that was my question. What is there a current Bible?
That is still the Bible, and or the level of service, or that is still part of it. In principle, that hasn't changed. And in principle, that's why the level of service discussion I had in my evidence have been highlighted and raised.
Sure.
And I guess hence why the 120 seconds.
Yep.
Yeah.
I understand. Just for the completeness, what's the date of the fifth edition?
Sorry, I can't. I can't comment on that.
Okay.
I mean, I can't recall. Sorry.
Okay.
Yeah.
That's a Gladys Knight question. Okay.
Shall I continue, or any other?
Some of us would have picked that up. Or was it Kenny Rogers? Anyway, that probably takes us to your conclusions.
Yeah, that's right. So in my conclusions, short-term consent application. So just to be clear, this is a short-term consent application. that's like this is regarding the 64 in and out. I support the short-term consent as long as the intersection upgrade, as referred to in the application, is accepted by Waka Kotahi as road controlling authority, and any audit recommendations and design changes arising from the road safety audit are addressed unless otherwise agreed with Waka Kotahi. In terms of the long-term consent application, in my opinion, it's acceptable as long as the applicant demonstrates that the maximum number of right turn entry truck movements per hour under pre-State Highway 58 upgrade and the maximum number of left turn maximum number of the left turn entry truck movements per hour under the post-State Highway 58 upgrade to be managed on the basis that the queue lengths being less than 50 meters, the average delay being less than the industry accepted practice of 120 seconds, and the maximum number of turning trucks right turn in under long-term pre-State Highway 50 upgrade is conditioned when the westbound traffic exceeds 1,400 vehicles per hour. And finally, the maximum number of turning trucks, which is the left turn out, under the long-term post-State Highway 58 upgrade are also reduced when the traffic exceeds a threshold of 1,400 per hour based on the reduction of vehicles from 45 to 30.
Okay. The reference in 4.2 on the third line, that was intentionally left turn entry, was it?
The third line, is it under C or?
No, it's on the third line of 4.2 before you get to A, B, C, D.
Okay.
You did mean to say left turn entry there?
Yes.
Okay. Okay, just see if there's any questions. Commissioner Burge.
Yeah, but this might be more towards Ms Jenkins, but so you're saying that for the short term that you agree as long as the audit recommendations and design changes arising from the road safety audit are addressed. I'm sort of looking at the conditions and they're not quite the same as the applicant's conditions there. So the applicant is saying that any safety concerns categorised as serious or significant shall be addressed. What I understand, Waka Kotahi saying that unless otherwise agreed, Waka Kotahi all identified operational safety concerns shall be addressed by the consent holder. So I guess I wanted to understand that difference and how that plays out.
Just to clarify, you want to know the difference of the serious and the significant, was it?
Yeah, I want to understand the difference between operational safety concerns, which is what Waka Kotahi is saying, and serious or significant concerns from the applicant.
And just further to that, Mr Chow, that probably goes to the language that safety auditors use in their recommendations. My understanding of these processes is that they are categorised in terms of high, very serious or serious, through to low and even desirable versus necessary. So I think what Commissioner Burge is indicating is and the applicant's position is a difference between a whole package of recommendations being implemented and those that are in the serious and significant category.
Yep.
If that helps with your answer to Commissioner Burge.
Yep. So in a safety audit, there are serious, which is the worst scenario. There will also be significant, which are still quite serious, and then there are minor concerns. So what we try to reflect, well, what I try to in the conditions also is that all the serious and the significant needs to be addressed definitely before the intersection can be commissioned, because that will impact on the safety overall. But there could be minor concerns that, for example, and I'm not talking about in this case, but maybe there's vegetation on the side of the road, not regarding the sight lines, but let's say vegetation on the side of the road, or maybe material that was left behind. So those could be considered as minor. It doesn't affect too much of the operations, at least from a safety point of view. So that's why regarding if Waka Kotahi believes, unless agreed upon, those needs to be all addressed before it can be commissioned. So does that answer your question?
Sure, that clarifies it. So the wording that Waka Kotahi are saying is all identified operational safety concerns.
Unless Waka Kotahi agrees otherwise.
Yeah. So you would obviously prefer your wording as opposed to the just serious and significant. Yeah. Thank you.
Mr. McMahon, you asked me a question just earlier regarding my 4.2. I replied incorrectly. That should be left turn out, which I've left off. Sorry.
I thought that might be the case. So could we change that now so that should be left turn exit, or what's the term? Left turn out.
I'll use left turn out to be consistent with
Yes.
the rest of my document.
Yes. Thank you. That should be left turn out. Okay. Anything further? We are jumping around a little bit, but I'm following proceedings. What do you want to do now, Ms. Jenkins? Do you want to go to your Waka Kotahi witness and then you deal with this wrap up on conditions?
Yes, that was my thinking, to provide you with the opportunity to ask Ms Kelly any of those clarification questions around the State Highway 58 upgrade, and then I can take you through the slightly dynamic set of conditions, bearing in mind the conversation that Mr Baker and I had just before we started this morning.
Ms Kelly, would you mind coming up to the front? It's probably more cosier up there. Just while Ms Kelly's getting set up, Ms Jenkins, just on that last matter about your answer to Mr Burge, unless Waka Kotahi otherwise agrees, the panel might have a concern with that phraseology and that it reserves a discretion. So you might want to just giving some advance notice when you come to talk to your condition set.
Yes, and I would also just want to check that question with Mr Chow, as I'm not myself familiar with the road safety audit process.
Yes.
That's his area of specialism, so...
Why don't I just ask Mr Chow a direct question now? Regardless of the road safety audit, and is it a pre and post intersection design issue? Was it both?
In this case, it's a post construction. So that means after it's constructed, but before it's commissioned.
Yes.
So it's quite critical. That's the
Yeah, I'm aware that sometimes there's a design.
Exactly. Yeah.
That would have been not in this case.
Not in this case.
No. Why is that? Not necessary.
So previous discussions between Waka Kotahi and the applicant before Mr Chow and I got involved had resolved that a pre-construction road safety audit wasn't required, and the scope of Waka Kotahi's submission confirmed that. We have looked at it in our own expert view, and the fact that Waka Kotahi needs to approve the final design layout for that intersection as the road controlling authority, means there is the opportunity for them to pick up any particular issues that they might have.
Yes.
Noting, of course, that they have been talking with the applicant for
Yes.
some time about that design as well.
Well, yeah, actually nicely anticipated my next question in that sense. But before I come to that question, for Mr. Baker and Ms. Williams and you, Ms. Jenkins, would the short-term consent reference and the long-term consent reference the plans that we had on the map yesterday from Mr. Kelly? Is that the intention in terms of the access design?
So the way that the condition is worded currently, there isn't a reference to a particular design set. The condition wording merely says that the consent holder shall provide the final detailed designs to Waka Kotahi for approval. So there isn't a reference to a particular drawing set.
Just a quick clarification. General Condition 1, referenced against Tim Kelly's work.
Yes.
Yeah, I'll find the exact
Okay.
part for you.
What is that the latest iteration in condition 1?
Yes, it'll be in
Yes.
there. Yep.
And then what condition are you referring to, Ms. Jenkins, in terms of the...
Commissioner, I'm referring to condition 56 in the applicant's hearing set dated 12th of August.
Okay, that seems to work.
Condition 1E.
Yes, yes. So 1E is really, I mean, I guess it's no different from the erosion sediment control plan. There's a draft included with the application. There's a draft included of the design under 1E, and then condition 56 allows the nuancing and final approval of that.
Commissioner, just in terms of that point you raised, in terms of the legal sort of scope for third-party approval, the other option would, of course, just be to make an advice note, bearing in mind that the intersection can't be used without Wakotahi's approval anyway. So if you wanted to make that an advice note, that's fine. Everyone knows about it, but that might be an easy way to address that concern if you had one.
Yes, well, look, I'm open on that. I guess where I was coming to, Ms. Jenkins, is, and I guess Ms. Kelly, is that ultimately Waka Kotahi hold the cards, don't they? I mean, there needs to be a corridor access approval given, and I presume the upgrade to the access can't occur without that approval being given, and that's really the bottom line, isn't it? That's your ace in the hole.
That's correct, and I guess the intention has been to best endeavours agree and resolve all of this prior to the hearing. So there's not the intention to deliberately prevent or delay the applicant from upgrading. It's more about making sure that the framework around that is appropriate to manage those effects. And I think it would be fair to say that we are very close to that.
Yes. But the sequence is essentially you've seen the design, it's referenced in 1E. There's a process for Waka Kotahi approval of that. There's a safety audit process, post-construction, pre-operation, and there's an inherent car process associated with those approvals.
Correct.
In your condition set, at least.
Correct.
Yes. Okay. Just out of interest, Mr. Baker and Ms. Williams, what's the respective position of the council and the applicant on the car reference of the car and the conditions, the corridor access request process?
Whether we've got a preference on advice note or condition, do you mean?
Well, firstly, are you accepting of it as a condition, or as a... So I guess it does come down to advice note. I mean, is it a duplication of matters that have to occur anyway?
Personally, I was comfortable with it sitting in an advice note in condition 57. Quite comfortable for it to be there.
Yes, that's 57B, A and A.
And the advice
at the
note
bottom.
just down below that?
Yes.
Bottom advice note 57
Okay.
refers explicitly to the
Yes.
car process.
Okay. And Ms. Williams, what's your position on that?
I think that condition framework works in its current form. It's making it clear to the consent holder that they need to engage with Waka Kotahi before coming back to council
Okay.
with that information.
No, I understand that. Seems like there's a measure of agreement there. The reason I'm testing that is that that's not always the case, and quite often the car process is seen as frustrating consents, notwithstanding that there have been safety audits pre and post agreed, and for whatever reason there's some delay or issue with the car. I'm not hearing that in this instance. So
Yeah, certainly it's the council's position that they don't want to see the information until it's gone through that process with Waka Kotahi.
And that makes sense.
And get caught up in the middle of that process. So it's expecting all of those matters to be ironed out prior to coming through to the council.
So the applicant and the consent holder doing the heavy lifting.
Correct.
That's useful. Sorry, Ms Jenkins, where were we?
We were back with me turning my mic on and asking Ms Kelly if she could respond to any questions that the commissioners may have around any detail that she can share around the timing or the content or the scope of the State Highway Stage 2 State Highway 58 safety upgrades.
Yes. And Ms Kelly, we received usefully from Ms Jenkins some links to that, some material from Waka Kotahi. But before you move on to stage 2B, are you able to just give us a thumbnail sketch of stage 2A in terms of what it involved, where it's at, whether it's complete? We got a little bit of information yesterday from Mr Wanty on that, in terms of his knowledge of that project. Are you able to assist the panel in that sense?
In a very limited way. So first, kia ora koutou, I'm Caitlin Kelly. I'm a principal planner for Wakotahi. I just want to be clear that I am not a planner on this Estate 58 project. I have been working on the Willowbank project, and so I may need to go for clarification and further detail from the project team itself, but I can give you the general information that is my understanding, especially after hearing from Sarah and Ms Jenkins that you were after some more detail on the improvements.
And that's fine. And to put it in context, it is only context.
Yeah.
We're more interested in 2B.
So the information that I've been sourcing has been very much focused on 2B rather than the earlier stages. It's my understanding, and it could be wrong, but this is my understanding, that, thank you, 2A is more the Harris Road to east of Moonshine Road, which the approvals have been lodged mid-2022. And I've actually got some collateral that I've shared with Ash to be provided to the panel. And that is some collateral that has been developed up for the local neighbours to explain what's happening in the next phases. In terms of the safety improvements of stage 2B, the consents are due to be lodged before the end of the year, and that's on track. State Highway 58 is part of the NZ Up program, which is a series of infrastructure projects. And in terms of funding, that has been reconfirmed and baselined. The intention at present is for construction to commence in 2023.
And how would you categorise the main elements of stage 2B in terms of physical works?
Okay. Right. I have got a little bit of detail around this, which is cool. It is 2 roundabouts and those medium rope wire barriers, which are to be installed, are the key features of this. It's very much safety improvements as opposed to being capacity. So the other element of it is widening the road and adding wider sealed shoulders and side barriers. So those are the three critical elements of the project in 2B.
So wider sealed shoulders and what was the?
Side barriers, widening the road, adding wider sealed shoulders and side barriers. And then there's the medium barriers for the entire length of the road.
What's a side barrier?
I might actually have to refer to Jason, Mr. Truman here.
Side barriers are like on this like the W sections on wooden timber posts, for example, or maybe steel posts on the side of the road, prevent hitting a bank or something.
Okay.
It's a protection
Protection,
mechanism.
yeah.
If a car was
physical
to defer,
structure.
that's right.
So guardrail on the Remutaka Hill
Yeah,
is an
guardrails.
example of
That's
a side
exactly
barrier.
what I was thinking of. Yeah. And haven't they improved over time? There's a question of Verge. We're done.
The side barriers, that's where if a car went off the road, there's a particular hazard, might go down the cliff or something, is it?
That's purely from my experience. Not sure about this project specifically, but yeah.
Yeah.
I mean, if there's
Generally.
no hazard, then we won't be putting any side barriers. But I think the scope there have included that potentially, but obviously subject to investigation and design and whether it's necessary to have those guardrails.
Okay.
Just to be clear, it's a protection mechanism and to avoid the conflict points where there is something hard to be interacted with.
Okay, anything else you'd like to add on 2B? No? So what I'm hearing is that it has funding as part of the New Zealand UP program. Consents are to be lodged, and presumably they will be district outline plan consents under the designation and regional consents if necessary.
That's my understanding. As a planner, I did ask that question, but
Yes.
yeah.
Yes. As a matter of course, do Waka Kotahi lodge outline plans for road widening within designated corridor?
Do they
Do they
outline
lodge outline plans?
It's horses for courses, depending on what's required.
Okay. But there would be no need for a land use consent from Porirua if it was outside the designated corridor. It would be part of the roading designation, presumably.
I'm not clear about this particular project. If it was outside the designation, potentially, but I don't understand what consent's been applied for in this instance. I'd have to come back to you.
Yes.
Yeah.
Ms. Williams, can you just remind me? I mean, is the roading is the state highway deemed a deemed designation in the plan?
The current corridor is, it's my understanding, the roundabout element may require some expansion to that.
So, like a extension to the designation
That's my understanding under
section 181.
181.
Yeah. Okay.
I can come back to you and
Could
just
you?
confirm
That would-
that status. I'll confer with Waka
Yes.
Kotahi in
It's
terms
not-
of their
it's
regulatory
not
plans.
Not critical, but it's of definite interest because I guess it goes to the timing of the works, and I guess it has an indirect impact on the timing should consent be granted for the long-term consent as to how long that interim period relates on that long-term consent.
Sure.
Ms. Kelly, just on that timing issue, if you could work with Ms. Williams on that, or Ms. Jenkins, just that would be useful in terms of the likely consenting framework. We heard yesterday, we had asked these questions yesterday, but I guess we'd ask them more in relation to the non-roundabout components of the work, and whether now that there's a possibility that the roundabouts might be outside road reserve and might need a section 181 approval, which not necessarily processed in a non-notified manner. That's something we need to take account of. But I guess the other component is you said construction's program for 2023, is that correct?
That's correct.
Yes, that would be based on the consents being granted, but
100%.
yeah, could you just inquire as to the likely duration of the construction? And so I guess I'm trying to understand if it goes to what would be a typical duration of construction length for that project?
I can't answer.
No,
that question.
could you
Yeah.
inquire?
But I can confirm this, but my current understanding of this section is meant to take 2 to 3 years, but I'll confirm that.
Okay, it's okay. It's of that sort of ballpark that we're interested in knowing. Okay. Well, thank you for your attendance, Ms. Kelly. I'll just check. Anything further? No. Any clarifications, Ms Williams or Mr Matheson?
Can I just ask a question through you of Ms Kelly? I'm assuming that the order of construction would be roundabouts, road widening, with the median barrier being last, presumably given you need the roundabouts to turn around if you have the median barriers. So is that the order of construction?
This has been inquired of. Yes, as I understand it from the project team, it would be roundabouts first and then the barriers. I don't know the timing of the widening within that.
I appreciate there's a little bit of uncertainty, but the extent to which you can inquire on those matters and distill that information back through Ash, that will be useful. And I'm going to put a time frame on that. Ideally, we'd like to have that information by the end of the week, if that's possible, but at the latest, Wednesday next week. And I'll come on to the reason for that on Friday. Okay, thank you. Ms Jenkins, we're back with you on conditions, I think.
Tēnā koutou katoa anō, thank you. So you have in front of you an updated summary statement to which I've added a number of handwritten notes as we have been talking over the last hour or so. So indulge me as I perhaps am a little dynamic in what I'm talking to you about. One thing before I start, I also just wanted to confirm for the record, I would be very appreciative if my name could be recorded as Jenkin rather than Jenkins.
Thank you. That's...
So...
Yes, it's quickly recorded on the... but I may have added a plural to that.
It is not an uncommon occurrence.
Okay.
My name is Sarah Jenkin. I'm a Technical Director Planning at GHD Limited in Wellington. I'll take paragraphs 1.2 to 1.4 of my evidence, or 1.5 of my evidence as read. However, I did want to draw the Commissioner's attention to paragraph 5.3 of my evidence in chief, where I confirmed that the state highway is designated in the Porirua District Plan.
Okay.
There are no conditions on that designation. It is conditioned as a limited access road, which means that Waka Kotahi, under the Government Roading Powers Act, has the ability to control access points onto that piece of state highway.
Thank you, Ms Jenkins. I should clarify that I'm also on the Porirua District Plan panel dealing with the matter of designations. So that decision will come out next year, I think.
So at paragraph 1.6 of my summary, I set out what are, in my view, the traffic safety effects, and they are informed by Mr Chow's traffic safety evidence. Now, whilst I don't intend on repeating those because they are, I think, quite clear, what I did want to reiterate, and this goes to a point that you've made yourself, Commissioner McMahon, the need for the intersection to operate safely pre and post State Highway 58 upgrade. And at paragraph 7.8 and 7.9 of my evidence in chief, I outlined the reason why, and that was because whilst we have a reasonable degree of certainty about the timing of the State Highway 58 upgrades, as Ms Kelly has advised, there is still work to be done to get the shovel in the ground and to complete those. And it's for that point that I am reluctant to be talking about an interim intersection design. My strong preference would be for us to talk about pre and post, because I think it removes the inference that the right turn bay will only be operating for a short period of time. Ideal circumstances, yes, it will be, but we are very focused on making sure that no matter the duration, we have a safe intersection. Now, my comments are focused on the long-term consent, and this is consent conditions, and this is because my understanding is that should the long-term consent be granted, the short-term consent application will be withdrawn. And that was documented, and forgive me, I can't remember whose evidence it was in, but I'm sure the applicant would be able to reconfirm that
Yes,
that's the case.
legal submissions of Mr Matheson touched on this, and he indicated that should the long-term consent be granted and clear of any appeals, then the applicant would surrender the short-term consent. He said it's not possible to withdraw the consent for various reasons, including the Section 124 matter.
And look, I'm comfortable with that approach. I did provide comments in my evidence in chief on the short-term conditions, but as I say, my summary is very much focused on long-term.
Yes.
So really, I'm just going through where we're at with the various conditions. So in terms of conditions 56 to 61, and I am using as a reference point the 12th of August set. Mr Baker has accepted my recommended amendments to those. He's showing those in green. I note Mr Matheson's point regarding having advice note as opposed to having a reference in the condition itself in terms of condition 61. So this goes to the point that we were talking about in terms of the post-construction road safety audit, and the amendments that I have recommended that it covers all concerns unless agreed otherwise with Waka Kotahi. My preference is the condition as worded, but I would be open to considering an advice note. I would just want the opportunity to have a little bit of time to make sure that I was comfortable with that and to confer with Mr Chow around the process for road safety audits.
In saying that, do you have a different view to the one I expressed about the legality of that wording in terms of reserving a discretion?
No, I acknowledge that it does introduce a third-party approval reliance. I would also acknowledge that we do have a third-party reliance in other conditions as agreed with the applicant.
Yes, through process. Yes, okay.
Yeah. And just picking up on the design point and reinforcing Mr Chow's evidence, he maintains his opinion that the acceleration, just wondering whether I need to project, acceleration and deceleration lanes are not required, and so hence there's no change to the design of the intersection as we've seen to date. So turning to condition 63, now apologies, the page references I've got here are to Mr Baker's rebuttal evidence rather than to the hearing schedule, but hopefully it directs you to the right place.
It does.
So Mr Baker has accepted the majority of the changes that I suggested and acknowledged Mr Kelly's clarification of the area that I'd made around the somewhat random inclusion of Saturdays, so thank you for that. In terms of the requirement to have an average delay of 120 seconds, I understand that the applicant has now agreed to retain this. That was subject of a conversation just before the hearing started, so Mr Baker will be able to advise if my understanding is correct.
That is correct, yeah. We were just seeking some clarification how it would all work, and we've got that now.
And that went to the matter of a combination of bottom line condition and management plan provision.
Correct, yeah.
And I think the only point that I would want to make here draws on something that Mr Chow said. This is about a low probability but high consequence effect. And it may never happen, but if it does, we want to make sure that there is a mechanism in place for managing that. Now, there was a reference in the joint witness statement, issue 1, and I have just lost my joint witness statement copy, which talked about changing the average number of vehicles, and my understanding is that this does not need to change, as Mr Chow has referenced. So turning to condition 24, which is the left turn movements exiting the quarry. So condition 63 was the right turn in, condition 64 is the left turn out. Mr. Baker has accepted my amendments, and he has made some additional changes, and I have advised that I agree with 2 of those. So 64A1, I agree with deletion. 64A changing from 45 to 30. He has proposed a change to 64A3 to replace gap acceptance on the 3rd line with exit behaviour. I have conferred with Mr. Chow on this change because I feel it is one of those subtle but important matters, and he has advised that, in his opinion, there does need to be a reference to gap acceptance. So we're proposing a portmanteau of gap acceptance behaviour because I do agree with the applicant. It is about behaviour. It's about what people do.
I can confirm that's fine.
Thank you. Let's move on.
Condition 66, which relates to preventing right turn out movements. Mr. Baker has accepted my minor amendment to that, and a lot of my minor amendments were around recognising that reference to pre and post upgrade as opposed to interim intersection. Mr. Baker has accepted the condition 66A around the use of Moonshine Road intersection. Turning to 67, which is the traffic management plan. Now, Mr. Baker has accepted a number of my recommendations, but he has deleted deleted condition 67C. However, and condition 67C was the method for achieving the 120 seconds. But again, my understanding is, based on our conversation, is that is now to be reinstated, and Mr. Baker can confirm if my understanding is correct.
Thank you.
Can confirm, and existing wording's fine.
Thank you.
So the joint witness statement included a commentary on what is 69P, and that's about the location of monitoring cameras. It talked about, the joint witness statement talked about condition 69P, so I think there was just
67P.
It should be 67P. I think that's just one of those
Okay, thank you.
version issues. In terms of the first point, I've commented on that in 1.17 of my summary statement. The original condition 72C included a reference to 400 metre of the intersection. That was changed to 300 metres. It is now changed back, I understand, or it should change back, as I understand, to 400 based on the joint witness statement outcome.
Mr. Baker?
I'll need to check that one.
Okay.
And I would just say my position is that it should be the 400 based on the technical advice. Right, the point in the joint witness statement at paragraph 24B, I have not, my view is this could be included into condition 67. It relates to the use of dynamic electronic signage. So I haven't suggested wording, but that would seem like a logical place for that to be included. And my belief is that the point in 24C of the joint witness statement is actually already, or it was already provided in condition 70A in Mr. Baker's evidence in chief. And this is actually, it is also in the 12th of August version. So the wording is that the recordings should be retained for a minimum period of 12 months.
Yes, it is. Thank you.
Sorry, Mr. Chair, I just wondered while we're at that point in the joint witness statement, my reading of it at the start of 24 says the experts agreed that this matter, which I thought was the camera coverage over 400 metres matter, could be resolved on the basis of A, B or C. It might be, just in order to deal with this issue, it might be helpful if Mr. Chow, who was obviously the only one there, could confirm whether my understanding is correct. Because my reading of Mr. Kelly's comment was happy to extend the crash record review out to 400 metres, but having 400 metres of cameras requires multiple cameras along the motorway. But so is that right, or is that still a matter of disagreement? That would be my question through you.
Yes, I'm happy to take that question. And Mr. Chow, it's whether it was options or options, whether they are landed as a condition such as 70A or whether they are dealt with into condition 67, which is the traffic management plan.
Yeah, my understanding is that we have agreed to increase the CAS analysis from 300 to 400 metres to either side of the intersection, and that covers the coverage enough for the intersection, as in the matter for 72C, which was.
Look, if it helps, I don't actually think the joint witness statement addresses the location of the cameras and the length that the area that they should be covering.
Yes.
67P requires the traffic management plan to look at the location of those cameras, and the where and the how, the area that they cover, I don't believe has been addressed.
I agree with that.
Yes.
We have not agreed on the coverage of the camera, but we have agreed on the CAS analysis of it. Yeah.
Yep. So I guess the question, just to cutting to the chase, is Waka Kotahi happy for that matter to be dealt with through the traffic management plan through condition 67P?
In my opinion, yes.
Yes. And does that, Ms. Jenkins, does that raise any conflict with 70A?
No, I don't believe it does, because I think they're two separate but related matters. 67P is about the where and the coverage, and 70A is about how long one keeps the coverage. And in my opinion, the condition already established that would be for 12 months.
Okay.
Do you think P actually does cover the coverage?
Yes, that's what yeah. Well, I think...
Wording doesn't sort of says it just says the location, it doesn't say coverage.
In my opinion, I think it's broad enough to include that, and Waka Kotahi, the consent holder must consult with Waka Kotahi in preparing this. If you took a belt and braces approach, you could amend that. I am personally comfortable with the wording, but I'd be happy to consider in conjunction with Ms. Williams and Ms. Baker alternative wording there if that was required.
Okay. Well, let's leave it at that. I know Harriet Fraser's online, and welcome, Harriet. We'll get to you on Thursday or Friday actually to get your view on some of these matters. Just before we proceed, I'm just conscious of time, and can I just welcome Diane Strugnall? Thank you. Morning, Diane, and as Rob Howard and Lauren Devaney present. Devaney, sorry. Look, we're running late. It's inevitable. You picked that up. Yep. And I'll come to that in a moment, but we're going to break for some morning tea soon, but I'll have a discussion about how the rest of the day might pan out soon. Thanks for your patience.
Commissioner, I've just got a couple of statements, and then subject to any questions, I believe that I have finished. So just closing out the monitoring, as I mentioned, Mr Baker has accepted the recommended amendments, and I've referred back to the joint witness statement in terms of how I see they have been secured. And then similarly, he has accepted my amendments to condition 100. So, as I have maintained throughout, I have no in principle objection to the continued operation of the quarry. Apologies. I've just realised I haven't addressed 2 points around the waka kotahi position that you had asked me to. So before I summarise, in terms of the duration, no, we don't have a position on the duration. The intersection needs to operate safely no matter how long the consent is running for, and so that's not something that we have traversed. And then secondly, the hours of operation, we have considered those in quite significant detail, and are comfortable with the hours of operation that have been proposed by the applicant, subject to the condition controls that we've recommended, which the applicant has now accepted. And so when I wrote this statement last night, the kind of main issue to be resolved was around the 120 seconds. That has been resolved. So in my opinion, the only thing I think left to tidy up is whether the road safety audit is approved by waka kotahi via the condition wording or as an advice note.
Yes.
And I believe that everything else has been addressed satisfactorily.
Yes. Thank you, Ms Jenkins. I'll just check that there's no residual questions. No. That's very clear.
Sorry, could I just
Yes.
ask a point of clarification?
Yes, absolutely.
Of Ms Jenkins. The condition that's now being, the point of condition 67, which is the TMP condition, that's now being retained with reference to the 120-second parameter. I just wanted to clarify whether it's waka kotahi's position that that is retained only for the right turn bay, or whether that can be retained for both the left-hand turn and the right turn bay. I'm just looking at the condition set in front of me as the 12th of August, and it's a bit unclear with the strikeouts and some underlining, but I'm just keen to get some clarity as to whether it's your opinion that that's only applicable to the right turn bay or also the left turn operation.
Oh, look, thank you for asking that question. I think that is quite an important point to look at. It is for the right turn bay only. I have talked at length with Mr Chow about this, and we do acknowledge the point that Mr Wanty raised yesterday, that in his opinion it was actually the left turn out that was more important. There is queuing available in the access for vehicles, and my understanding of Mr Chow's position is that the 120 seconds for the right turn bay is where he thinks the focus should be. Apologies, I had actually meant to pick that point up and I neglected to. And I did have something just flit through my mind that I wanted to raise, and I can't remember, so I think that draws me to an end.
Thank you. I have one remaining question for Mr Chow. Mr Chow, in your assessment of the traffic environment, have you been aware of anticipated developments along the section of State Highway 58 as signalled by the proposed district plan?
Signalled by the district plan.
Proposed district plan, and I'm specifically referring to a proposal as notified in the district plan to create a future urban zone straddling State Highway 58, I think between Murphy's and Flighties and down towards Moonshine Road. So it's a future urban zone that would be later upzoned to an industrial zone. Were you aware of that possibility occurring?
Quick answer is no, I'm not aware of that happening.
Yes.
But in saying that, even if there is an industrial zone happening in the area, won't change any of my recommendations. In my opinion, what may change the intersections operations is really in respect to the two roundabouts and the wire ropes that would highly influence how traffic will use the section in between, regardless of whether the developments are there or not.
Thank you.
And if I may, I believe the way that conditions 63 and 64 in particular are worded with the 1400 vehicle threshold, the question there, I think, becomes how quickly do you reach that threshold? And it doesn't matter whether it's sooner rather than later. That is what the modelling shows as being the key. And so a land use coming in, as you've described it, may just mean that you reach that threshold earlier than might have otherwise been anticipated.
Yes. Just to be clear, the proposed plan signals a future urban zone. It doesn't, that in its own right doesn't create an industrial zone. It creates a holding mechanism for a future process to consider a Schedule 1 process to consider the industrial zoning and through a structure plan approach. In hindsight, it's probably a question I should have put to Mr. Kelly and Mr. Wanty, but I guess hearing from the Road Controlling Authority is important. That was all from me, just a quick check. Right. Okay. Thank you, Ms. Jenkins. Thank you, Mr. Chair, and thank you, Ms. Kelly. So as you can tell, we're running some quite considerably late today, which is unfortunate because we've been keeping to time the first 2 days. We haven't completed the applicant's case yet, and I'm sure that's weighing on Mr. Matheson's mind.
I suppose just on that, I guess the other, and I'm not sure what our timing's like on Friday, because I expect a lot of the questions for Mr. Baker are going to be around the conditions, and the conditions themselves are probably going to have a bit of panel beating.
Yes.
And I am wondering, unless there's any particular planning questions you want to put to Mr. Baker, we defer any specific discussion of the conditions. Mr. Baker and Ms. Brown have put together a very helpful diagram that
Yes.
Mr. Baker could perhaps speak to, answer any general sort of planning questions, and then hold off on a substantive discussion on the conditions until we do an update.
Yes.
Is that all right?
I think that's fine. The panel anticipated this happening. It might sound ironic, Mr. Baker, but aside from conditions, we don't have many questions to you on your statement of evidence. And that's just a mere reflection that, and I guess I can say this as a planner, that you're relying on matters of expertise outside your field. Will require you to update your opinion based on any changes that have occurred during the duration of the hearing. Will also be, so that's the first point. Second point, we're interested in the policy framework, and we'll be discussing that with you and obviously with Ms. Williams and Ms. Walker. But I think we can do that later. And thirdly, as Mr. Matheson said, the condition framework is critical, and the interaction of dialogue that we just witnessed between Waka Kotahi is probably, there's no real substitute for that. That's real life answers, so we appreciate that. So that's a long way of saying I think we could safely take a morning tea adjournment now for 15 minutes and come back and hear from Rob Howard and Lauren Devaney. Thank you.
Thank you, Mr. Chair. What I will do, just so that you can look at them over your coffee break, I will ask Mr. Baker just hand up that summary. You asked for a diagrammatic summary of so I just thought it'd be useful to have those for the break, and then
Is there enough copies for members of the gallery to?
we'll see what we can do. Otherwise, we can. Oh, can you? We'll see what we can do. Otherwise, we can email them to people or through Ash or put them on the website or something.
Just for the benefit of all the submitters in the gallery. So something we asked for yesterday was a graphic explaining how the conditions relate to each other.
Did you want me to quickly talk to the summary pack, or?
I just think just hand it up. I think hopefully it's self-explanatory, but
I think so, yeah.
yeah.
I can put them on the screen as well.
And they will go under the tab that we've created on the webpage, which is documents table during the hearing. So that's a new tab as of yesterday, I think. So is any procedural matters arising from that? Has any, Miss Strugnall, how are you placed for time? Do you have any pressing appointments? No. That's fine. Okay. I just wondered when were you scheduled? Okay, 10:15. Oh yes, I see. And you're happy for Ron and Lauren to proceed before you? Thank you. Appreciate that. Okay. Well, let's take 15 minutes. I think we're deserving of that. And let's come back at 10:40. Okay, welcome back, everybody. Just before we hear from the first submitters, and I understand there's been an agreed batting order now. Rob and Lauren, you're going to kick off. Thank you. Just a couple of preliminary matters I wanted to make. Some of them I made during day one, and I'm not sure that I know that a lot of you weren't here during day one, but I'm not sure how many were watching online. So apologies if I'm going over material you've heard before, but the three of us, myself, David McMahon, Commissioner Liz Spurge, and Commissioner Nigel Mark Brown, have been appointed by the Greater Wellington and Porirua councils to hear and determine submissions on this group of applications lodged by Willowbank trustees. So we have the power to make a final decision on behalf of the council, and that decision is then released to all parties, and there's a normal process of appeals should that be necessary. So we have full delegated decision making in that sense. I'm just hearing some background noise there. Is anyone else hearing that? Okay. As part of that, a part of preparing for this application, we've issued some 9 minutes, and I don't make any apologies for that, but that was an attempt to keep people informed from the first day that I was engaged on this, which was around about May last year, before some of the before the Greater Wellington and the Porirua City Council long-term applications were lodged. So the attempt of or the endeavour of those minutes was to keep everyone informed, to keep the information flow going, to encourage engagement, and to set out a process for evidence circulation so that we didn't have a situation that people had to read verbatim their statements of evidence, which would have probably doubled the length of the hearing otherwise. So we've read all of the evidence, so that has been pre-circulated, and we're allowing people that are presenting today and tomorrow to read their own statements. So that's permissible. And then we'll go to any questions. As part of our preparation, we also visited the site on Sunday afternoon. We were taken around by the Quarry manager, Shane Haggai, who came over from the Wairarapa to take us around. We did not discuss the application or its merits or otherwise with Shane. He was there really from a health and safety and as a navigator. We found that visit extremely helpful. We traversed the entirety of the Quarry site, the access road. We looked at the various stages that are proposed. We looked at full site number 2. We looked at the location of the bund. We spent some 2 hours on the site, fine but windy conditions. And we also then took the opportunity to be taken around up Murphy's Road and up Harris Road by Mr. Derek Voss from the council. Again, Mr. Voss didn't discuss the application with us. He was solely really our chauffeur in that respect. And we used this plan to assist our navigation, which shows the location of submitted properties in relation to both the access road and the quarry. And we'll be referring to that with each submitter that presents. I guess the only other matter, and it's a matter I touched on yesterday and probably should have touched on Monday, and that is, and you would have heard it this morning, there's been quite a bit of discussion about conditions. And we make no apology about that, but we make it clear that that doesn't indicate or should not indicate a predetermined position on the outcome of these consents. And the reason for that is we have to be satisfied that the effects of this quarry, whether it's short-term or long-term, can be adequately avoided, remedied or mitigated. That's the tests of the Act. Now, the ability to remedy or avoid or mitigate or even offset goes directly to the wording of conditions. Are they certain? Are they comprehensive? Are they easily understood? will they actually achieve what they set out to achieve? And so we need to test that, and the way of testing that is through questions to experts. So that's why there has been a focus on conditions. It's not only important, but it's essential and necessary to come to a finding on the nature of effects. But as I said, it should not indicate that, for want of a better term, that this is a done deal, because it's not. That's a decision that we need to address our mind to after the hearing's closed, based on the weighing of all of the evidence that's received during this week-long hearing. So apologies if some of those people here have heard that before, but I wanted to reiterate that it's important that everyone hears that. Just check with my colleagues, anything I missed? No? Okay. Well, on that basis, unless there's any procedural matters that anyone wants to raise, and doesn't appear so, we'll come to you, Rob and Lauren. In your hands.
So obviously not 100% certain how this was meant to proceed. I can go over my submission and points of interest that are important to ourselves. First and foremost, we're the owners of 327 Murphy's Road. We feel our property is the closest property to the quarry, most certainly the quarry workings. We opposed the application for various reasons, and unfortunately we don't have any expert evidence to present you commissioners today, and we have fair and reasonable causes behind that. First cause or reason behind that is that we're building. We don't know what repercussions that could have had, and another reason behind that would be insurance. We don't know what repercussions that would have.
I'd just like to point out as well that the applicant sold us our property after they had the initial resource quarry, and they didn't disclose that information to us. So they knew that we were a sensitive site, but still chose to sell us our property, and haven't actually been open with communication since then about our concerns.
Can I just ask a question of fact? When did that occur, Lauren? When was that sale undertaken?
So it was April the 14th, I think 2018.
2018, and
Sorry, it was March the 13th, and then we settled on April the 14th.
yes, but 2018.
Yeah.
And when you say the applicant sold you the property, that
Willowbank trustee.
Willowbank trustees, thank you. Was that property in its own title before that, or did it have to go through a subdivision?
The titles were issued some time before we had purchased it.
Yes. Months, years?
I would say years. Mr. Nation should be able to clarify this. He was the sales agent.
Okay. Okay, so the titles were in existence pre-2018. You undertook a sale and purchase agreement in March, and that was settled in April of 2018. Yes. Okay. So at that, and I need to ask these questions, so bear with me.
Yeah, perfect. Yeah.
What due diligence did you? What was known to you at the time of your purchase in terms of what consents the quarry had or didn't have at that stage?
We got a limb from the council.
Yes.
We were also given a limb by Paul, and we processed it through lawyers.
Yes. So at that point, I'm going to just ask Ms. Williams for some clarification. Ms. Williams, when was the 2018 consent lodged and granted?
So they received their draft resource consent on the day that we signed our sale and purchase agreement, and then we settled a month later. So
Okay, so when you say the draft resource consent, what do you mean by that?
So Willowbank Trustee Limited, when they talked to us, they admitted that they knew about the resource consent going through on the day that we signed, and then
Yes.
they still didn't disclose us that information a month later when we settled.
Okay. Let me just see if, are you in a position to answer that, Ms Williams, at this stage?
I can confirm consent was granted in November 2018.
Yes. Do you know when it was lodged?
Yeah, I'm just waiting for that to load.
Yes. Okay.
Otherwise, Mr. Baker may be able to beat me to the chase here.
I won't be able to.
Okay.
I mean, there was considerable like research and work
Yes.
done a couple of years before that
By,
by Willowbank Trustee Limited. You know, in order to get the
Yes.
resource consent done.
Yes,
So it's not like they started doing it at the time of our sale and purchase. They
Yes.
had a considerable amount of work a couple of years leading up to that.
yes, I understand.
I have beat him to the punch. The magic date is.
Okay.
Can you
So,
just repeat it into the microphone?
10th of August 2018,
it was received.
application received by council.
That the PCC.
Porirua City Council.
Yes. And, sorry, Genevieve?
Sorry, just having a look, and it's the application saved into our system 13th of August 2018.
20th of August 2018.
Sorry, 13th of August 2018.
Okay. So that's the Greater Wellington. So there were two applications, regional consent, and so lodged in a similar time period. Okay.
Sorry, can I just further clarify that? Yes, so it was from Becca, and it was their application was dated 10th of August 2018.
Okay. So that's the factual situation. You were talking to that, Lauren, about what might have gone on before that by the applicant.
Yeah, well, I mean, if you look at the resource consent, the initial resource consent, there's like a considerable amount of, traffic experts, visual experts and everything, for 2 years leading up to the date that they sold our property. So it was pretty crucial information to pass on to people who would be 150 metres away from the quarry.
Yes. Is it your understanding that Willowbank trustees were not the applicant for the 2018 application?
Well, their name is on a lot of the, they paid for a lot of that expert advice for the resource consent. So I think they should be held responsible.
Okay. Just for the record, Mr. Baker and Ms. Williams, Ms. Walker, Ms. McClelland, who was the registered applicant?
Willowbank Trustee.
It was Willowbank.
Correct.
Okay. 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 Are you suggesting had you had that knowledge you might not have proceeded?
100% we would not have bought the property.
Obviously, we are somewhat hesitant to disclose everything that we do know about it because following your decision or your team of decision there may be legal.
Yep, of course. We can only know what you tell us.
Yes.
That's useful background in terms of historical context. I guess what the panel particularly wants to understand is what are your particular concerns with the current application? The previous application is about to it's being carried over through a provision known as Section 124 of the Act, where the applicant lodges a renewal within the 6-month expiry, or just outside the 6 months expiry. They can continue operating until the new consent that they've lodged is determined. So they've lodged a rollover consent essentially of the 2018 consent, and which is called the short-term consent, and they've lodged a long-term consent for 35 years, and that's been lodged with the long-term's been lodged with both the Greater Wellington. So, rightly or wrongly, I guess we've got an indication of how the quarry's been operating between 2018 and 2020. And we've got some material, a considerable amount of material on the proposed operation should this consent be granted. So the panel is very interested in understanding the potential effects on your property that you anticipate occurring, and anything you can tell us about your view on those effects.
I guess at the end of the day, we're not experts, and we rely on experts to do that sort of work for us. But what we can do,
Well, what I can say, Rob, is that from the panel's perspective, you are an expert because you are the receptor of effects. So whether they're noise effects, dust effects. So
during a period, obviously, we're out of our control. We purchased the property before affected parties. We weren't a signatory or anything like that, but we were on site, in fact, living on the property during night works. During night works, the operation would continually wake us. The subbidder would receive complaints from us, but there was nothing to be done. The council would receive complaints from us, but nothing was done.
could you explain the timing and type of works that the night works encapsulated in that period, 2018 to 2020?
Well, night works, they ran 24/7 essentially.
Yes, but was it? I mean, did it include blasting?
Yes.
Yeah, blasting definitely, most certainly.
And
So blasting is probably the worst effect that we, have to experience.
yes. So in that 2018 to 2020 period, what was your experience of the latest time frame for blasting occurring at on any particular given day?
So like I work from home quite often. The blasting was pretty considerable. Like I've given Ash a video that we took inside our house just so you can see like the vibration effects.
Sure.
But it's too much for like a site like ours. Like we are too close to the quarry for them to continue doing that sort of blasting.
Yes, we'll have a look at it in the
So I
moment.
just got a notification.
Sorry, who's?
That's YouTube.
Yeah.
So,
But my question, Lauren, is was there blasting in the nighttime hours
no.
No, it was during the day.
during the day? Yes.
So I mean they had I think 24 blasts a year that they could do.
Yes, okay. Thank you.
But
Do you
as
want-
well, like the lesser amount of blasts, that the more blasting they'd have to do, and the bigger effect to us. Like they really need to spend the money and do more blasts that are littler,
Yep.
so we don't actually feel it.
Yes. Do you want to go to that video now
Oh, I'd prefer
to carry on?
I'd prefer to somewhat come back to our submission and talk a little bit about that,
Okay.
because I feel we're sort of getting a bit sidetracked in terms of that, and I appreciate the questions.
Okay.
Keep them coming.
Thank you.
I guess in the application we're extremely concerned. I don't feel that cyclists have been addressed whatsoever in the traffic management. The largest concern that I have as well, or obviously we've been subjected to, and every road user that uses State Highway 58, every public user, this area or this intersection that's been formed, I believe it's been incorrectly formed, and that's why it's currently sitting at 50 kilometres per hour at the moment as its speed limit. That's been a burden on everyone, I feel. I feel the applicant hasn't taken that seriously, and they should have rectified that a long time ago. It's been a couple of years now. So it's extremely concerning. There's also an Armco barrier there that's damaged. That's been damaged for well over a year now. Obviously, that intersection should be, or I understand, is care of applicant. They haven't repaired that. That's a penalty, obviously, to all road users, myself and Lauren, probably everyone sitting here that uses 58. I think that's a fair and reasonable observation of what the submit is about. I don't feel they are conscious of road users, the public, and most certainly not the local community. That's what I have on traffic offence. I don't want to, effects, I don't really want to go through my entire submission, obviously because there's a lot of traffic experts here, or been and going through and whatnot. So no questions on that? Yep.
So you said something to the effect of that the intersection's faulty, or did you
Yeah.
mean the Armco, or there are other aspects in your view that make it faulty?
Obviously it's still held at 50
Yeah.
kilometres an hour. The letter that I have from NZTA is to state that it's due to the intersection being incorrectly formed.
Oh, okay.
Is my understanding, or what I have for it. I suppose I need to read it out, but I have it somewhere here.
Well, Rob, can you remind me, was that attached to your submission as lodged, or is this material that you're talking to
This would be
today?
additional material.
Yes. So the way it works is we really need to see that correspondence to put any weight on it. That's not doubting what you're saying.
Yeah, I can hand that over.
Yeah.
Yeah,
Can you do that?
yeah definitely.
Yes. Well, we'll do that. Are you going to read from it today, or
Oh, I can do, yeah.
it will you want to highlight any matters, and we'll get copies to the applicant, and Miss Williams' team will be keen to see that. Yes. So we don't need to have copies now, but as long as we have the ability of getting a copy, that's sufficient, Rob.
Yeah, I wouldn't mind reading it. So, I had correspondence with Craig Nicholson of NZTA. Not sure they call it NZTA anymore. The current intersection layout is appropriate for the current temporary speed limit, but not for the underlying permanent 80 km/h speed limit. Consequently, the intersection needs to be modified, appropriate and safe for the 80k speed limit. It's quite a long email. I'm not going to read the entire
No.
thing, but we'll hand it over. And
Did he have an email signature stating his position within NZTA or Waka Kotahi?
maybe on the formal email.
Yes.
I've only printed the page out. There's a few pages to it.
Right. But he's a employee of NZTA as far as you're concerned.
Correct, yeah.
Thank you. Okay.
Yeah, that answers that. Yeah.
Okay. Liz, you're fine. Okay. Yeah.
Other than that, I don't have any further more on a traffic offence. Other than that, I think it's quite serious. It's a national state highway. I'd be fairly annoyed if that was under my jurisdiction to control that.
Yes.
And obviously quite disappointed.
Yes.
And the time frame that they haven't rectified it it's not that great, for them.
Yes. You were in the hearing chamber this morning when we heard from Waka Kotahi, NZTA, talking about the concerns that they have and the degree to which they've been resolved, and we heard about the potential, or not the potential, the proposed upgrade to the state highway between Flighties and Murphy's and Moonshine, or no, it was actually Harris, wasn't it? Does that give you any comfort that some of these issues could be dealt with?
I would like to see all of that rectified before they're allowed to operate, because they haven't shown that they can rectify things in a timely manner.
Okay.
Operating.
Yes. So if I can just explore that with you, the way it's proposed at the moment is that for both the short-term consent, the 5-year consent, and the part of the long-term, there are strict controls on traffic numbers and movements until the state highway upgrade is undertaken. After that, the condition framework changes. I don't know if you picked that up this morning?
Yeah.
Yes.
Yeah.
Are you saying that you would like to see that that pinch point moved right to the beginning of the operation?
Yeah, I'd like it to be made safe before they can operate.
Okay. Do you like the upgrades to occur before there's any operation?
Yeah.
Okay. And that's the upgrades to both the state highway and to the intersection?
Correct.
Okay, thank you. That's very clear.
Next on my list or my submission was the noise and vibration effects. I have various things in here, but of major concern, there's no blasting exclusion zone. Porirua City Council don't have anything in the RMA for that, or the district plan, I should say. We feel there should be a setback applied, and it should be applied as per other, quarries and regulators that we can relate to. I feel, for an example, Australia and New Zealand standards always worked hand in hand. In Australia, they have a setback or buffer zone of 500 metres. I feel that needs to be implemented, if not more. For example, Canada has 800. Other parts of Canada are 600. India, Malaysia, 500. Victoria of Australia, 500 metres. The reasoning behind that, obviously, is for fly rock and blasting. If you do enough research, you can find fly rock can kill, can damage, and is of concern. We're very close to the quarry, and I'd hate to think that we'd be subject to fly rock. I don't feel that it's been addressed sufficiently within the applicant or within the application of the consent. I've also done a little bit of research in terms of what Australia is implementing. The Australian and New Zealand Environmental Conservation Council, they've released a paper, and I can obviously share this because it's not in my submission, unfortunately. And they state for all new sites that it is recommended that a level of 2 millimetres per second of ppv to be considered as a long-term regulatory goal for the control of ground vibration. It extremely frustrates me that in the consent, Marshall Day state that we will not be subject to anything above 1 millimetre per second ppv. They put that in writing, that's in the consent. Obviously that's false, very fraudulent. They know that we're subject to higher than that. There are obviously, not obviously, but there have been readings from Marshall Day on our property when HEB were operating the quarry. I understand these haven't particularly been taken seriously as such. I've been told that these are not official readings, or we're not able to use these due to they're not being engaged by us. We don't know the process in which they conducted the testing and whatnot, but regardless, AECOM performed this testing. A competent technician or engineer performed the testing, so it does show and give a very fair and reasonable indication of what blasting vibration occurs on our property. I would like to think that the panel would take in consideration that the applicant has advised that our property would not be subject to above 1 millimetre per second ppv, and therefore you should enforce that. Anything above that, is somewhat insulting because that's what they'll put on paper. They're the experts, and we obviously understand that they know more than us. So I'd feel that it would not be reasonable or unreasonable for you to hold that, or to put that within the consent.
Can I just seek some clarification on that, Rob? The draft condition that's in front of us from the applicant that's relevant to this is condition 33B from my reading, and it says that the vibration from all blast events must not exceed a limit of 5 mils ppv when measured on any building not on the subject site. So,
Yeah, but they've referred to us as a sensitive site because we're so close.
okay,
So they've said that we wouldn't experience above 1.
that's their assessment.
Yeah.
Yes. And then, okay, what I'm referencing now are the conditions of consent that have been volunteered by the applicant. And so the next one is that all blasts should be designed to achieve vibration levels no greater than 3 millimetres ppv as an operational target when measured at any dwelling that is not occupied or owned by the consent owner. So I get, my question to you is, are you suggesting or are you requesting, and I appreciate that your submission seeks the decline of the application, are you suggesting that that 3 millimetres should be changed to 1 millimetre?
Correct.
Okay.
And obviously, you know, the Australian and New Zealand Environmental Conservation Council have stated in writing, you know, that it is recommended a level of 2 millimetre per second should be considered for a long-term regulatory goal. Now, I would imagine that Porirua City Council and you guys would want to try to better that, you know, for the better good.
And the thing is that 2 ppv is kind of taken into consideration like that 500 metre setback. We're like only 150 metres away from the quarry, so like 2 is going to be too much for us. 1 is much more appropriate.
Yes, can I just get some clarification on that? And I'm not doubting what you say, but the information that's in front of us for your property is that, and this is the approximate distance to your dwelling, not to your property
Yeah,
boundary.
so the dwelling will be more.
Yeah, the boundary
Yes.
of ours is 150 metres away.
Yes, the estimation, and I just want to check with Ms Williams, could you just remind me what the source of this?
It's a bit of a combination approach. The distances came through from my colleagues at the Regional Council, I think from the evidence of the air.
Yeah, those distances are an approximation from
Yes.
our GIS mapping system from the edge of the dwelling to that red dot on the sheet there.
Yes. Rob and Lauren, have you seen this plan before?
No.
I'm happy to we've got some spare copies, so what we might do is put it on the submitter desk. If we have other
Could I
copies.
just confirm, is that from the edge of the red dot or the middle of the red dot? Because it's quite a large red dot, so that sort of makes a bit of a difference too.
I believe the middle of the red dot, just noting it is an approximate measurement.
Yeah.
I think your property 12, is it? Or,
Yeah.
yep. So that, I can't remember, there was around the high 400s, I think, to both the access road and the red dot on the quarry.
Yeah, I think that's going to be.
We'll bring that up on the screen behind you and what's in front of you also. But we'll leave that on the desk that other submitters can refer to.
I think, you know, for all due respects, it should probably be measured as well, you know. I don't know why it can't be. Yeah, so then we're talking with some accurate numbers, eh? But
Okay.
I've measured my property from my foundation to my top corner of my property is almost 200 metres exactly. So for this to state that it's double that, I'd be very hesitant to agree.
Okay.
So, sorry, just to clarify, so it's the difference between the edge of your property boundary, the physical property boundary, and then it's the edge of your dwelling as well from the quarry. Yeah.
Yeah, so property, the foundation to the edge of our property boundary closest to the quarry is almost 200 metres on the dot,
Okay.
measured with a
helpful.
laser.
Yeah, that's helpful.
From there to the quarry face would be no more than 150 metres.
And can I just confirm something else? When you talk about fly rock, this is just rocks flying.
Fly rock is consequence of blasting.
Yep, so it's rocks flying in the air, if you like, excuse my ignorance here, in the air and landing on your property. Is that what you mean by
Well,
fly rock?
potentially. There's quite. I don't know. I'm not a blasting
I don't
expert.
know either.
But
I'm just asking if that's what
yeah.
you meant.
Yeah, it is.
We do
Yeah,
have
thank you.
animals grazing on our property
Yeah.
too. So, and they graze right at the very top of the boundary,
Sure.
which is very close to the quarry.
Yes.
Yeah,
So it could be
no.
rock, or it could be fragmentation of rock.
Yeah.
Yeah.
So,
Yeah.
I mean, if it's not us or checking on our animals,
Yeah.
it could be them.
Yeah, no, I understand that. I just wasn't quite sure what you meant about fly rot. Thank you.
Yeah, so what's been available to me is, things such as the Mine Safety and Health Administration. They state where fly rock incidents have been known to occur at operating surface mines, the blast should be at a minimum 1.5 times the furthest distance that any previous fly rock has travelled. For example, a known fly rock incident occurring 400 metres from the blast area would require an expanded minimum setback of 600 metres.
Yes.
So that's as a guideline, but I don't believe any of that is within the submission.
That's an Australian agency. Did you say
Correct.
it was what was the name of the agency?
Mine Safety and Health Administration. Might be American.
We have a copy of that too, through Ash.
Yep.
Thank you.
Also, I'd like to touch on, in terms of the vibration effects, it's not uncommon for other mining operations to have constant monitoring.
Permanent monitoring stations.
Constant permanent monitoring. That needs to be implemented if this is to proceed.
Do you mean on your property?
Yep.
And whereabouts would you think that should be?
Like at the house site.
At the house site? Yep.
Yeah, I believe, experts would say that would be at the foundation, which is quite probable. We could
Yeah.
probably accommodate something like that, but if not, obviously there should be another opportunity to do something else.
And that's very common for New Zealand quarries to do that. It's strange that they haven't implemented it with this quarry.
Okay.
So again, Australia and New Zealand Environmental Conservation Council state that blast vibration and air blast monitoring should be carried out on all sites where blasting occurs and where there are residents and other sensitive sites that may be affected. We are being identified as affected. So differing from that, I don't feel would be acceptable. Furthermore to that, they state monitoring should be generally conducted at sensitive sites around each mine and Quarry to confirm the air blast and ground vibration levels do not exceed the specific criteria. So that should be done at our foundation, I feel.
So just earlier, Lorraine, you said that you would prefer, you found the size of the blasts, if you like, and the vibration that you were receiving, quite large. And I think you said that you would potentially prefer smaller blasts more often than larger blasts less often.
Yeah, so I did talk to some blasting experts about this.
Yeah.
And they told us that the way that Willowbank Quarry, conducted their blasting was probably like a cheap and nasty approach. So, they need to, put more financial into actually doing a proper blast plan and doing smaller blasts, but more of them. And just really looking at it again, because it's an area of the consent that they haven't really done their due diligence in.
Sure. Okay. Just on that, so we did have some discussion the other day about notification of blasts too. Is that something that you've received in the past? It is, yeah. And you found that helpful? I mean, I know that result isn't what you want, but did you find that process helpful? Did it work? Did you have enough notice?
Yeah, of course, every blast should be notified.
Yeah.
I don't see why it would not be.
Yeah, sure.
Yeah.
Yeah. And the process that was occurring, that was satisfactory to you?
Yeah,
Yeah.
definitely.
Okay.
Well, I mean, they weren't very timely with it. They'd say the blast would be in between, 2 and 4, and it might be 4:30 that they blast. So
Yeah.
it
A
wasn't
little bit more
accurate.
accuracy, yeah.
Yeah.
Okay.
Coming back to my blasting exclusion zones, which I think are fundamentally extremely important for fly rock, which we've discussed. Obviously, we know the paper road operates very close to the quarry, and there's also a pylon which is very close. There's nothing to stop the public walking that paper road. There's no fencing, there's no signage.
There's also a lot of like people who do horse riding recreationally up that area. So, you know, if you're on a horse and a blast happens and they don't know about it, you know, that's actually really dangerous.
So continuing from what I'm saying is there's nothing to stop someone come in from another entrance. Say Belmont Regional Park, I've often cycled that. You can go from Belmont Regional Park and I can cycle home quite quickly. It's an easy route to take on Paper Road. There's nothing stopping the public from getting close enough to the quarry that they could be subject to being hurt or even a fatal fly rot.
So we've got a map here of paper roads, and so when you say you leave from Belmont Regional Park, so do you use paper roads to get to where before you can get to Murphy's Road?
I'm fairly...
All of those Western Hills link up for paper roads.
Okay.
You can really easily, like I've walked them heaps of times.
Yeah. So you'd use those quite often?
Yeah, and I often see other people walking their dogs, cycling.
Yeah. Yeah.
Yeah, I guess that's all I have in terms of blasting. We could probably show the video and give you a good idea of what the property is subjective to.
So I've just got one question before we get off the blasting, and it's following on from Commissioner Burge's question. If there was a really good notification, I understand what you're saying, it's a bit of a concern not knowing when it's going to happen. So if you're working at home, it's like, well, when's it going to happen? And you're sort of on edge. If you actually knew, say, within a certain half hour or something, would that help, do you think?
It would help if the blasting was lesser than what it had been.
Sure,
Yeah.
but I'm asking you that particular question. Do you think it would help? Because what the experts say to us is that with blasting, it helps a lot if people know when it's going to happen. You know? And I can understand if you don't, it's quite concerning. So
That's okay for us, but we have visitors and things, you know, and things like that. So at the end of the day, you know, if our visitors turn up, we could, you know, there's going to be a blast in another half hour. You're still going to get a fright.
yeah, okay.
You know, it's never going to stop you from getting a fright.
Yeah.
Never going to stop the animals, the horse riders,
Yep.
other users, you know, people that are at our property or whatnot. It's never going to mitigate against that.
Okay.
So what I'm hearing there, Rob, is that that's a major concern. But within that concern, if blasts were smaller and more frequent and there was a higher degree of accuracy about the notification of them, that might go some way to dealing with it, but you still have a residual concern about blasting.
Most certainly, you know, blasting is our largest concern. What I see being put forward really isn't sufficient. I've seen and read far more stringent plans, blasting plans, even down to the chemical used and and the type of
Like detonation.
detonation. I don't see any of that within this plan.
Yes. Can I ask you? I've recorded that blasting is your single biggest concern. Is it the nuisance aspect in terms of noise, surprise, or is it the potential for damage to your property or injury to stock or persons on your property that concern relates to?
Yeah, I think it's all of the above.
That. And
You
it
know.
also as well, like it devalues our property by the fact that we are, you know, we have to experience these blasts all the time.
You know, I opened our discussion with the fact that we have an engaged engineer to do official testing or official reports and fear that we don't know what repercussions that's going to have on our property. That could be huge for us. If we don't get insurance on our new build, you know, what are we to do? Who's going to pay for that? Who's going to purchase that property if you can't insure it? the damaging, I got examples of other mines. If there's a property within 800 or 3 kilometres, to some extent, they do an inspection every blast if there's a complaint. I don't feel the complaint process is stringent. I don't feel it's followed up, and under no circumstances should it ever be under self-monitoring. There should be no self-monitoring for this because the applicant has proved that they're unable to fulfil that. They're unable to repair an armco, unable to respond to complaints.
Okay. Well, shall we go to the video and then we can come back with some wrap-up questions after that? So let's watch the video and then you can talk to it and then we'll go to wrap-up.
Wow. You have to rewind it. Wow. See, it's quite quiet, eh?
I can show you on my phone. I guess it's important to look at like here. That's inside our house.
Wow.
So the person swearing is a visitor. You can take note that the camera moving is the air pressure. The noise that you hear is the strapping that restrains the building. Yes, it's not very nice, and that's not a large blast.
So are you saying that the intensity would be different on different blasts in your house? So that's one example of a blast, but there is a variation of what you would receive in terms.
We've had blasts that have been bigger than that. That was just a normal blast.
Yeah, that was a pretty light example that just happened. We recorded it on the day. Very difficult to record. As you could maybe understand, we didn't know when the blast is going off. In this instance, we caught it, So you can see even the air pressure affecting within side the building and not external. We've had air pressure exceed before from blasting. Nothing was done about that. So it's, yeah.
What do you mean by exceeding, air pressure exceeding? What do you mean?
So ACOM performed testing on site on our property for HEB. That was engaged by HEB and not for us directly, and the air pressure limit was exceeded.
Right.
There was no follow-up, no actions, no anything to say we're going to change this or do that to help with the next blast or whatnot.
Okay, yeah. So it's a monitoring, reporting type.
Yeah. I'd also like to state, consequently, when larger blasts occur, the data was lost, which seems very unusual when you have a chartered professional engineer perform a test. I deal with chartered professional engineers on a daily basis in my role for the business that I work in, and that just most certainly would not be acceptable. So I don't believe that that is correct. I think that information is obviously withheld for obvious reason. And for that example as well, self-monitoring is not acceptable.
I've got two questions I'd like to put to you both. The first is, I think we probably passed you when you were arriving back on Sunday. I think you had a buggy on the back of you. Yes. Pretty dirt splattered by the looks of things. The reason for mentioning that is your house still under construction?
Correct.
Yes. Okay.
We obviously made the decision to build. A little bit of background around that. The house that we're building now was not the house that we wanted to build on the property. After realising the repercussions of how the quarry operates, we did not pursue the large financial burden of building such a large property or large house. So we had to pull that back, and we pulled that back and we sat on that for a long, long time. We sat on that for over a year.
When did you commence the construction? I mean, you settled up in August 2018.
We started in like February this year,
February this year, we decided to pull pin and make the financial.
and we scaled back our house quite a lot because we didn't want to, I guess, over invest into a property that could be devalued so much by the quarry.
Yep, I understand what you're saying.
We also pulled back our design from double-storey, two-storey building to a single-storey building, following research of obviously how blasting occurs and it amplifies the larger the building, is what I understand, but I'm no expert. And knowing that this is a 35-year consent, and if it went through, we don't know the repercussions on the property or the house. No help from anyone for that. And obviously, as I said before, we're very hesitant to charter an engineer to advise on that, because once we charter that engineer and they come to us and they give us that information, like it or not, if it's positive or negative, we must disclose that if we were to move on.
Sure.
And that consequence or repercussion of that could be quite damaging to us.
Yes.
So yes, we've started building our property, scaled it back, and it's where we're sitting at the moment.
Yes. What would you, in terms of completion percentage, what would you estimate?
Oh, we're over halfway at the moment in terms of the building.
Yes.
Yeah.
And you don't have to answer the next question, but is there an intention to complete it?
It's a very good question. And I'll tell you openly that just recently we've had it valued, and we've had it valued for two reasons. One, so we have a baseline of where we sit now without the quarry operating, and it will be valued once the quarry is operating to give us a differential, so we understand if there is a consequence or an issue there that we may need to take action on. And two, yeah, we would leave, you know. So consequence is a reality that.
Okay.
Yeah.
Yeah. Sorry, I had to ask that.
We may not complete it personally. We may move on. We don't know. Yeah.
Yeah, but you understand why I needed to ask that question.
Yeah, 100%.
Yes. Second question I've got, and I'm going to ask this to all submitters, is we heard from the applicant over the last 2 days, and particularly on day one, I think, that, and this is from Willowbank trustees, that they gave careful consideration to engaging an operator for this proposed quarry. The term cowboy was used, and I'm just quoting from Mr. Walsh and others in terms of the previous operator. And what Fulton Hogan are saying to this panel is that we can be assured that they are a professional quarry operator with several years of experience up and down the country, with the appropriate procedures and protocols in place, and that where there are conditions of consent included in a consent, and whether that's a short-term consent or a long-term consent, that we should have confidence that those conditions will be adhered to and monitored and enforced where necessary. So that's the information that we're receiving from the applicant. They're drawing a distinction between the previous operator of the quarry, the 2018 to 2020 operation, and the operation that they propose to operate based on their experience elsewhere in the country. My question to you both is, does that give you any level of confidence? Does it change your view at all? Underpinning that is a large number of conditions that are proposed, that are being scrutinised by Ms Williams for the Porirua Council and Ms Walker for the Greater Wellington Council, drawing on their own experts, which were peer-reviewed the information from the applicant that have been the source of the conditions. So the question is, does the track record of a different operator, such as Fulton Hogan, give you some level of comfort compared to the previous operator? And to the extent that you've been able to look at the conditions, and I appreciate you might not be able to, does that give you some confidence about the regulatory enforcement of those regimes that Fulton Hogan are saying they would adhere to?
Well, like, I mean, CPB Heb had all new equipment as well, you know, all new trucks, all that kind of stuff. Like, Fulton Hogan don't have all new equipment. Like, there's nothing about, like, emissions or anything like that about what they're going to be using in the quarry. So, to be honest, it seems worse than what CPB Heb would have been, in my opinion.
We haven't heard any information on the age of equipment or anything.
It's probably quite important, you know, like the noise and effects and everything, you know, are going to be so much worse if they're using 10 to 15-year-old equipment. And we know that CPB Heb had used new equipment.
Yes.
So new trucks, new
Can
excavators.
I invite you, though, to put that to one side, and if there are bottom lines specified in a set of conditions, let's just say, take noise, for example, does it really matter? I mean, what's being told to us through the officers and the applicant is that if there is a bottom line specifying a noise, then that has to be achieved. And if that means modernising equipment, then that's what has to happen. So I'm not trying to advocate for the applicant on this, I'm just trying to test the veracity of the condition framework and the assurances that Fulton Hogan have offered during the course of the hearing.
It still doesn't give me any confidence in the new operator.
Okay.
Yeah, for me to answer that, to date, we have never been approached by Fulton Hogan. We've never had a discussion with them other than one community liaison group. I think that's really important, to say the least. I don't feel they understand who we are, how close we are.
Okay.
The other concern in relation to that, the operator is only one part of the operation. I feel the owner has obviously given enough evidence to show their incompetency, both with the intersection, the Armco barrier and complaints. Should the operator, say, be more effective or efficient, at the end of the day, the PCBU who is operating this quarry should act. They have a duty of care to ensure that what they are doing on their property is safe for people around them and for the public. So, to answer your question, no, it does not give me any reassurance, because the underlying factor is we have not had any correspondence. We have not had any discussions, and the applicant has not changed in terms of the owner of, you know. So no, it doesn't give me any reassurance whatsoever. I do hear a lot of talking in terms of trucking and movement and things like this, and I understand that this quarry is going to be open to the public. Therefore, I think some consideration needs to be given to, you know, users of the quarry as well, not just people around it.
Yes. Thank you for answering those questions, difficult questions, but as I said, I'll put that to all submitters. I'm just giving some heads up. Commissioner Burge has one final question.
Just been back through your original submission, and there's just a couple of things that we haven't talked about, but you did just touch on it then, was the community liaison group. So your submission says that there's no friend of the submitters been appointed. I'm not sure what you mean by that. Is that like a council person?
Yeah, so my understanding is, for me to understand the process, I went back and looked at other hearings.
Yes.
And that includes other hearings that the Porirua City Council have held, and they appointed a friend of the submitters there for that.
Mm-hmm.
I did question it, and they felt that this wasn't sufficiently large enough to warrant a friend of the submitter, which is
All right.
disappointing.
Sorry, I thought you meant that person should be on the community liaison group. That's not what you meant about this hearing process. Okay, sorry.
So Rob, do you feel you've been penalised as a result of not having a friend of submitter available?
Most certainly. You know, even sitting here today unsure of how the proceedings operate.
Yes.
We're the first submitters sitting here.
Yes.
So
Well,
I suppose we sort of somewhat set the base.
You have, but I've tried to explain the protocol as best as I can.
Yeah. But in terms of receiving help, you know, even the regulator, you know, if you approve this, you're going to have to be 100% certain that the regulator is going to be able to withhold, you know, and control it. And
Yes.
And for something as simple as helping us, a friend of the submitters would have been a critical point.
But
I
you-
asked, didn't.
Yeah, but you appreciate that was an obligation on the council as opposed to the applicant.
Yep.
Correct.
Yes.
Yeah.
Okay.
And just the, oh, sorry. Just
Sorry.
the other thing you talked about in your submission was about air quality effects. I think you may or may not be aware now that fill site 1 has been removed from the application.
Yeah, and it frustrates me. Putting it very loosely, I understand fill site 1 was put in there because of a recommendation from us, just loosely. It was then removed after questioning how they're going to conduct that fill site. Is the noise the same as under the same regulations as quarry operations? How are they going to do it? Why does the access road have to be on the top of the hill when there are alternatives? All of a sudden that's been removed. It seems like, hey, they're trying to help us. Yeah, let's put this in, but we're not going to try to help you with the noise or the dust or any other repercussions from building that fill site. No one's told me why they've removed it, why someone feels that that's not applicable anymore.
My understanding is that they've removed it for those reasons to help control dust and noise, or reduce the effects of dust and noise. That's my understanding. But yeah, so that may or may not have some sort of beneficial effect on your property, one would hope.
Yeah, I'm not sure. All I could go by is, you know, the submission, and that was going to help with noise, but it will probably have some repercussions. But I feel that wasn't covered in the submission, the noise, the equipment, the access way to that, you know.
Sure.
And maybe it was just an easy way out. Let's just remove it. We don't have to answer these questions.
Okay.
And just one final question is what's the size of your property?
Oh, 15 acres, 14 point something acres.
Okay, thank you.
Yeah.
Thanks very
Mr.
much.
Burge, thank you both for your presentations. 2 pieces of information that you were going to provide, the copy of the email from Mr. Nicholson, 3, and the mineral, the Australian New Zealand conservation thing. And what was the third one?
Oh, there's 3 things I'll put. I'll file
Yes.
through. It was,
Okay,
yeah.
we'll leave you to discuss those with Ash, but thank you for your presentation.
Mr. Commissioner, sorry, just one question if I may through you. I wasn't sure we had a date for the video that was shown.
Okay.
Is there a date available?
Yeah, we can submit a date.
Yes. Could you do that? You don't know that date at this point?
Oh, it's on my YouTube, but I'll send it through to Ash.
That'll be good. We'll post that video online, and we'll put a date on it. So it'll be under the tab information submitted during the course of the hearing. Thank you both.
You could actually be able to see it because I've emailed her the link. So when she goes onto the YouTube video, it will have the date there anyway.
Okay. Useful. Thank you both.
Thank you.
Thank you.
Okay. I'd like to think we've caught up a little bit of time, but that might not be the case. Was there any negotiations between the parties as to who would like to go second? Or was it Diane? Yes?
Yeah.
Thank you.
Mr. Neeson's,
When?
you're going to follow the normal flow.
I'm turning my microphone on too. You think I'd be used to it by now, wouldn't you? Welcome. You're a member of the Porirua Residents Association, but you're presenting in your own right as a no?
Residents Association.
Okay, thank you.
I did not submit on my own.
Okay, thank you for that clarification. Do you have any material no? That's all right. We've got pen and paper and we've become accustomed to writing very quickly.
That's fine. I've got a copy which I can leave with Ash.
Of your speaking notes?
Yes.
That would be really useful.
Yep. So you ready for me to go? Okay. Thank you for the opportunity to address the hearing on the Willowbank Quarry consent application. There was going to be a we, but time has meant that it is myself. I'm speaking on behalf of the Powatahanui Residents Association, which represents the rural community of Powatahanui from Mount Cecil Road in the east to Camborne, end of Grays Road, and to the top of the Paikakariki Hill Road in the north, as well as all those side roads off State Highway 58. We have more than 180 households on our email database and reach many more through our Facebook profile, website and newsletters, which are delivered to approximately 400 homes. In representing, the community, we are obviously required to represent a diversity of views and opinions, and for this reason our submission was neutral, noting that we have membership both for and against the application for the quarry. We do, however, wish to speak to the concerns that are raised by the potential presence of a quarry in the district. We have read as much of the expert evidence, council and opposition material that's been tabled to date. We also took part in the pre-hearing meeting on the 4th of April as directed. And the purpose of that meeting was to present the key concerns from the community and to receive an update on the key points from relating to our submission. The concerns we wish to address this morning relate to 3 specific areas: traffic management, environmental effects and the impacts on neighbouring properties. Traffic management first. Many of the residents represented by our association are regular and frequent users of State Highway 58 and are affected by road use on this section of the highway. We appreciate that there is much discussion about the State Highway 58 upgrade, which will change the patterns of use for all vehicles, including heavy vehicle movements. What we would like to point out is that previous operation of the quarry for the purpose of transmission gully meant that the quarry vehicles were on a limited number of routes associated with the motorway construction, that is to Lanes Flat or to the site access points on Flighties Road and Paikakariki Hill Road. Because their operation was associated with the TG project, there was also agreement between the builders of the road regarding heavy vehicle movements, particularly through the Powatahanui village at school pickup and drop-off times. There is concern that with more general use of the quarry, such restrictions are less likely to be in place. This raises particular concerns regarding the safety of other road users and pedestrians within the village area. We do note that there's been a recommendation within expert evidence of Mr. Wanty, recommendation 25.3, that there are times when heavy vehicles should avoid using the village, and we would encourage that this recommendation be adopted should the consent be granted. Whilst obviously the traffic management in the immediate vicinity of the quarry and State Highway 58 has been of the greatest consideration to council and traffic experts, we would also encourage some consideration being given to the impacts on other roads likely to see an increase in heavy vehicle movements as a result of the quarry. For example, there is concern from Grays Road residents that with the Northern Growth development area, that this could increase vehicles through that area of road. So we seek assurance that the traffic management plans, both under the current situation and after the State Highway 58 upgrade, ensure the safety of all road users. With regard to the environment, the Powatahanui Inlet, the Powatahanui Stream and its catchment is of great importance to our community. There is an increasing awareness of the vulnerability and susceptibility, particularly of the inlet, to adverse effects. There's also increasing awareness of the impact that the activities within the upper catchment have on the inlet, and any such activity that has the potential to affect the inlet's contributing streams, in this case the Pāotahanui stream, and its associated ecology raises concerns within the community. We note the mitigation measures proposed and seek to ensure that these are more than adequate to not just maintain the health of the stream and inlet, but to contribute to their improvement over time. The third area is the impact on neighbouring residents, and they are much more able to speak to this, as Rob and Lauren have already indicated through their submission. Some residents living in closer proximity to the quarry will be more directly affected, and we know that you will be considering that within this hearing. We've had a very recent example of residents experiencing negative impacts of a different activity with the opening of Transmission Gully. And one of the things that caused the most angst was that the impacts were far greater than people ever anticipated. And this has left residents feeling deceived and with little recourse to mitigation. Residents are also feeling caught between the operator and the monitor, in this case between Waka Kotahi and Porirua City Council, resulting in much finger pointing but not a lot of action. The residents near to the quarry have already had some experience of the quarry's impacts, and so are less likely to be blindsided if the consent is granted. But we would encourage the hearing panel to note the concerns that they raise and to ensure that, should the consent be granted, the quarry operates should the consent be granted and that the quarry operates over the intended timeframes, there are clear avenues for addressing concerns, not just now at the outset, but also over time. Previous experience has led us to know that whilst the intent of conditions set for the granting of consents may be worthy and ideal, it is the ongoing monitoring of these which is actually extremely important to those who have to live with the consequences of a consent being granted. We are therefore seeking that the consent, if granted, gives heed to this concern and includes provisions for the monitoring and enforcement of consent conditions over time. Thank you.
Thank you, Ms Strugnell. That's very clear. I'll just check with my colleagues to see what questions they may have. Mr Burge.
That was very clear, Ms Strugnell, and certainly like a copy of your speaking notes. I probably don't have questions as such as to just reiterate or read back to you what I heard to make sure I got it right. Just a few other points. I clearly might not have got them all, but I'll leave the traffic to one side at the moment. What I was interested in was about the effects on the Pāotahanui Inlet and the stream, which you just talked about, and the vulnerability of that environment and the effects of upper catchment activities. And what I took from that is that you would like to see not just maintenance of that environment, but you'd like to see enhancement. I mean, we all know those environments are degraded at the moment, so what I see from you, you'd like to see not just maintenance, you'd like the enhancement factor to be prevalent as well.
I was a member of the Greater Wellington's Whai Tour Committee, which spent 5 years looking at the impact.
Sure.
And am well aware that the work of both Greater Wellington and Porirua City Council is geared at the upper catchment, that's where the issues start, with the idea, obviously, that the inlet is, as the receiving environment, is very vulnerable, and that's been shown. So there are very clear targets within the Whai Tour implementation program that Greater Wellington, the community, would like to see achieved. And so to do that requires not just status quo, but actions.
Yes. And part of that way of achieving that is the importance of monitoring for the consent life, not just for certain years, if you like, and those sorts of parameters.
Yes.
Okay, thank you. It's very helpful.
Good morning. I have one question which relates to your comment that the impacts of Transmission Gully were greater than expected for some of the residents, although not directly related to this project. I'd be interested in what those were. Are there people that you know have told you these things, or just some examples of them would be useful to me.
We've had 2 community meetings with Waka Kotahi over noise has been the biggest, and
Ongoing noise now from traffic.
But where the constraints come are that the noise regulations are averaged over 24 hours. They only apply to dwellings within 200 metres. Inside measurements taken not at proper, so people are feeling their outdoor ambience and enjoyment of their property. So there is people are feeling that they were told that those effects would be less than what they were. The reality has been quite a stark reminder that things change. But the hard part is people are feeling powerless as to where to go. As I said, there's finger pointing. Waka Kotahi says this is what we're responsible for. Porirua has to manage is the measurement. That's their responsibility, is the monitoring of it. We're just and that leaves people feeling very frustrated. And it would be very good, I think, if those. For any consent, if those kind of the where to go from here is really clear for people.
Okay, thanks for that clarification.
Ms. Strugnell, a few things from me. I appreciate you clearly articulating the 3 concerns. That's useful for my note-taking. And it also allows me to compare those matters to any conditions that have been volunteered. Now, I appreciate that you're neutral, your submission's neutral, but I do have some questions anyway. In terms of the traffic issue, did I hear you say that you adopted Mr. Wanty's evidence?
Mr. Wanty, and one of his recommendations, 25.3, I think it was, recommended that there be some avoidance of heavy vehicles through the village at school pick-up and drop-off.
Yes.
And we would... that would be greatly appreciated by members of the community if that could be taken into account in your considerations.
Thank you. Yeah, that's exactly what Mr. Wanty said.
Yeah.
Okay.
The concern is that, we were liaising with, through village impacts with the Transmission Gully construction, so we had an opportunity to voice that directly and a line that we could report breaches to. So that was something that was implemented through that time, which was seen as very valuable.
I'll come back to that in a minute. You made mention of Grays Road and the, I guess, the cumulative impact of any development in the northern growth area, and how it might relate to this area. What did you want us to particularly take account of there?
It's just taking consideration that the impacts are wider, and that conditions. It's very difficult. I mean, that's a local Porirua City road. There is the State Highway 58, which will continue around the other side. But obviously time constraints mean that vehicles sometimes take shortcuts. There may be, I don't know what those things are likely to be, and I guess maybe you can't either. But again, it's having mechanisms to say these impacts may go wider than just entering and exiting 58, but will impact on road users wider.
Yes.
In the area.
You obviously have an understanding of the process that between a future urban zone and upzoning to a residential zone and the structure plan process. Yes. Does that give you some comfort that those cumulative impacts on the roading network is something that can be considered during the structure plan upzoning?
I think that the difficulty, and we just had an example last evening, because we were presented with the State Highway 58 an update from Waka Kotahi last evening.
Timely.
Very timely. But lots of the concerns from residents had been dropped, such as where buses might stop. It was only an inadvertent comment from the council that indicated that they'd had a presentation from Waka Kotahi that alerted us to the fact that there were changes that had been made. So I think the
So you
mechanisms
requested your own presentation as a result of that? Yes.
Yes.
Okay.
Which,
The
was
residents
quite a heated meeting at times. Again, it comes back to the fact that in the ideal world, yes, I know that there are these processes, the proposed district plan process, and that will go through subsequent processes when residents will have opportunities to hopefully submit and make a difference to what the outcomes are. I think one of the realities, and again, Rob's indicated it, that these processes are very daunting, that they're off-putting for lots of people, and also lots of things fly under the radar. People are busy with their lives,
of course,
and suddenly are faced. So I would really put that out there onto, I guess it's PCC in terms of how those things are, but ensuring that they really do engage as those steps move through, that the community is given an opportunity to address what are very real concerns. I mean, the capacity, what they were very clear last night was that the capacity, that the upgrade for 58 is related to safety, not capacity.
Yes.
And that obviously, as we've seen with the outcome of the opening of Transmission Gully, for anybody trying to exit any of our roads is extremely difficult.
Yes. Were you in the chamber when Waka Kotahi presented this morning?
Not when they were actually doing.
No, we heard from Ms Kelly, who gave us an update on State Highway 58 at our request.
I heard a little bit of that.
Yes.
But
there wasn't a lot of detail.
There's a lot of smaller detail, and what came out of the meeting last night was that it's 80%, and there's still design work to be done.
Sure. Okay, no, that's good. Just going to move quickly through the other two matters. You raised some issues about sedimentation on the inlet, and I completely understand why you would do that. The name of your association would support that. We've heard from the applicant about their erosion sediment control plan and their adaptive management plan. Mr. Pope has been coordinating some expert conferencing between Greater Wellington and himself. And from a process point of view, is the association satisfied with that?
Yes.
Yes.
Again, it comes back to the long-term monitoring and ensuring that conditions, that what's presented is, we're not experts, but, at superficial look is.
Yes, and belts and braces, review conditions, that sort of thing.
Yeah.
Yes. And that takes us on to the third issue, and that's a concern of residents, and we were fortunate to hear from Rob and Lauren earlier. Go on. And in that respect, you've said, and I would have noted down, is that there should be clear avenues to address concerns during the life of any consent. And so I've referred to a series of review conditions, an ultimate review at any time, a yearly review as to the fit for purpose nature of conditions, and then specific reviews tailored to things like erosion sediment control, noise, dust, those sort of things.
Just ensuring that if consent is granted, that the conditions are not just allowed to gather dust, but continue to be.
Yep, that's a strong thing coming through. Well, thank you. As I guess, no, that's fine. We've asked that. Thank you for your presentation. Okay. Thank you. And we'll take a copy of that and put it on the webpage, Miss. So Diane, that'll go on the webpage. Yeah, thank you. Mr. Neeson. And so what material do you have for us, Mr. Neeson? Welcome, I should say.
Yeah. Now, I do have some talking points. I would like to tidy them up before I send them through to the council, if that's all right with you.
Means that
That's right.
I'm on to my third pen.
I'm sure the council have plenty of reserve.
They have.
Right. So I'm going to take my submission as read, Mr. Chairman. Okay, so I'll go through the talking points, and some of these talking points reflect some of the information that's come to light in subsequent documentation.
Yes. Just to help us, though, in terms of a roadmap, can you just list the key areas so that we can keep a track of them as you go through?
Sure.
So can you, up front?
Yep. First point is about the unformed legal roads.
Yes.
Okay. Oh, just by the by, I'm not going to talk about vehicles per hour, blasting, vibration, or anything like that. This is more of a public interest type topic.
So I'm just looking for a list up front.
Yep, I'm going to tell you. Then I've got additional comments around the proposed conditions, if any.
Yes.
And in respect of that, there is the complaints process, the community liaison group,
Yes.
and the inclusion by reference of plans and other documentation.
Yep. Understand what you mean by that.
Correct. Thank you. Right, the first point is about the unformed legal roads. And I just would like to make a point here. In some of the initial documentation, the unformed legal roads were referred to as paper roads. And I just make a point that they're not. And my submission clarifies why that is so.
What's the essential difference in your view, Mr. Neeson?
There is no difference in the respect that paper roads, the term paper roads is a very common term that actually has no meaning. Okay. Unformed legal roads means that the roads are legal, but they're just not formed by the council or the Crown. There's no difference between those roads and Hagley Street out here, for example.
But you understand that that lay people might always prefer the term paper road.
Correct. Yes. But I think it's a process of education, and I hope you don't fall into the same trap.
Try not to.
Thank you. Right, so I've got both a professional or a past professional and a personal interest in public access. Yes. So I was quite dismayed to see initially that neither the applicant nor the council actually recognised that there is a network of unformed legal roads going through the proposed quarry site. And those roads actually have a big impact on the nature of the operation of the quarry. The roads, the public, as some of the earlier presenters point out, have a right of access along those roads, and as my submission points out, that access cannot be hindered by anybody else. So what I have done, for good or not, in my submission is to try to be helpful. I could have taken the proposition that the roads actually would have a quite dramatic impact on how the operator may operate the quarry, given that the public would be entitled to use the roads whether there's trucks there or not, whether there's a blasting going on or not, as one of the earlier submitters made reference to it. So what I've done is tried to think of, well, if this consent were to be approved, how might the operation of the quarry be facilitated, but how might also the safety of the public be managed. So that's essentially, I was quite pleased to see that the applicant's draft conditions, that at least the council's proposed draft conditions took into account many of the recommendations that I had included in my submission. But I think it does raise, there is a legal point, which is not for me to clarify, Mr. Chairman, but there is a question whether the use and management of the unformed legal road should actually form part of the consent condition at all. I've taken the proposition, if you like, that let's try and facilitate and make clear how these roads might be used. It's up to you whether, in fact, you want to do that. If the roads are to be excluded from the resource consent, then I would have thought that the applicant should also be seeking consents from the Porirua City Council on the use of the roads as a separate process. And then the question would arise, well, what is the council's response? Because only the council can approve the forming of those roads and any restrictions. But that's consents or conditions are constrained by the law. So I have, in my talking points, Mr. Chairman, made three or four changes or additions or amendments to the proposed conditions in respect of the unformed legal roads.
Yes.
Yeah.
Are you able to tell us what conditions?
Yes. So it's in the draft conditions. It's para 9.2.142.
Okay. Rightly or wrongly, there's a number of different condition sets floating around.
Sure.
The one that we've been working on is dated the 12th of August, and it's entitled Hearing Condition Set.
Okay, so mine is, I've referred to the draft, when I wrote these notes originally, 18 July. So it's one of the very early, I think it was from Ms Williams.
Ms Williams, section 42, would they have come in with that?
Yeah.
Okay. Have you got a copy of that? Can you confirm that, Ms Williams? Yes. I don't have those in front. Oh.
We can give a copy.
Sorry. Yes, I have got a copy of that, sorry.
Okay.
It's in my second pile.
Yeah.
Did you just receive an August dated version? So would you, if you wouldn't mind, just for the sake of us, to follow those ones, it'd be very helpful.
Okay. All right. So in respect then of the 12th August version, just trying to compare the two. So it's para 73 is fine. Para 74, where it begins, the consent holder shall maintain.
Which is this? Okay, so what you're reading from Mr. Neaton, just for the benefit of everyone, is the Porirua City Council proposed conditions for the long-term consent, I think. Sorry, the applicants, yes.
Yep. So
but for the Porirua Council applications.
Correct. So we're now referring to the 12th of August version. Yep.
And it was condition 74. Oh, yes, I'm with you.
So, Kara? Right. I propose that at the end of that paragraph, the following sentence be added. The alternative temporary access must be of a reasonable width, brackets, not less than 3 metres, close brackets, and physical nature so that it can be used safely and readily by the public. The explanatory note I have is 3 metres is about the width of a shared pathway and considerably less than the width of the unformed legal road. Bear in mind that the unformed legal road width is 20 metres, so it's not unreasonable. For the purposes of this exercise, I'm assuming that public use would be primarily walkers, cyclists and perhaps horses. Four-wheel drive use presents a wholly different set of issues if it were to arise. Para 75, the applicant has added some words, and PCC shall publish any such notification. That's fine, I agree. Para 76, the applicants has added 2 words, commencement of operations. I agree. Para 78, the applicants added the word the public use of the alternative, so the word public. I agree. Para 79A, small a, number 4, second line, the word publish is also included, shall also publish. I agree. I would make the following change to little 5 or Roman 5, with the consent holder shall ensure that all signs, and then ends up as notices as required by, and I would insert the words by the Porirua City Council. Then my last comment relates to the advice notes that are in italics. Advice note number 2 is I don't understand it. My comment here is the meaning intent of this last note is unclear. It seems to mean the same as the first note. If it has another meaning, then it should be reworded to make that meaning clear. Perhaps if you might like to ask the applicant to clarify quite what that means. If
Yes, we'll definitely do that, Mr. Neeson.
Right, thank you. Shall I move on?
Yes, sorry. Yes.
Yep. So those points cover the unformed legal roads. Right. My other comments are in respect of the draft consent conditions. And again, I'm basing these comments now on a mix of the July version, plus what I've read in various other submissions or material. I've taken an approach of looking at the draft conditions from an interested, informed and independent member of the community. So I don't live in that Judgeford area, I live in Camborne, but I use that road in that area a lot for cycling. The draft conditions are very prescriptive where they need to be and appropriate, for example, vibration, noise, etc. But they seem to be very light on process. Now, I make this comment from the point of view of being a former policy manager in central government where a lot of its stuff is process-driven, not too worried sometimes about outcomes. But none of us probably around this table are going to be here in 35 years if this consent is drafted. So we need to be very clear.
I'm hoping.
I won't be.
Disappoint. Well, yeah.
So you need to be, I think all of us need to be crystal clear about what the consent conditions actually mean and what they require of all parties for the future. I don't think any of us would want to be in a position where another panel gets together and makes a comment saying, if only the original hearing panel had made it clear quite what they meant by condition A, B, C, etc. So that's where I've taken it from.
And Mr. Neeson, you would have heard my comment on conditions earlier about why we're looking at them and why we're scrutinising them.
Correct.
It's not only just in terms of the ability to mitigate and remedy, but it's the ability to be workable, administered, clear, and enforceable. So
Correct.
Those are basic tenets of condition drafting that you'll be familiar with.
Yep. Yeah. I am. So the complaints process, the draft conditions propose that a robust monitoring and complaints process be established and followed by the consent holder. My questions include who determines if the complaints process is robust and is being followed, what happens if the consent holder doesn't adhere to this condition, and there doesn't appear to be a requirement for the consent holder to identify and publish a complaint's contact point, person or address.
So which conditions are you specifically referring to here?
The original version, the July version, was 9.2.59, but I don't know what the
I think it's 8 in the...
August version would be.
Condition 8. It's, no? Oh, yes. Yes, sorry, Mr. Neeson, that's it's on your page 29 of the hearings condition set. Condition 8.
Right. What I'm really trying to address here in thank you, my submissions is that any conditions regarding the complaints process must start from a basic foundation of requiring the consent holder to actually have a complaints process that is robust from start to finish. It must be required to have a website. I guess all these complaints seem to be filed on a website basis, electronically, not in paper. That there is a contact point, etc., etc. It's about not just assuming that these things will happen, but it actually must be required to happen.
Yes. Are you saying that condition 8 doesn't achieve that? It says the consent holder shall maintain and keep an electronic record of complaints.
No, Mr. Chairman, I haven't read this version based on the 12th of... As I said, my notes were prepared before that. So I'm just going on the basis of what I have written. If it's covered, that's fine, but I'm just... it's another exercise to now
Perhaps,
compare the
that
two.
condition's not that long. I mean, if you wouldn't mind,
Sure.
we're happy to sit while you read it because it's clearly an important point.
So bottom of page 29, Mr. Neeson.
Okay. I mean, generally it covers the point, apart from my last one, where it is number... No, it's not. So it's para 8. It says the complaints register must be available to the council's compliance monitoring officer. And then the last sentence is complaints received by the consent holder that may indicate non-compliance shall be forwarded to the Porirua City Council. My question then, who determines may indicate non-compliance? Is that the consent holder? Why would the consent holder... it would be in the consent holder's interest to minimise the number of may indicate. It would seem to me that it relies solely on the consent holder determining if a complaint may indicate it. I would have thought that should be an issue for the council. So all complaints must be forwarded to the council, and then the council should determine whether it indicates non-compliance or not.
I understand what you're saying. I'm going to leave that to Mr. Baker and Ms. Williams, and to the extent that there's a similar condition in the Greater Wellington. I'm not sure if there is.
For complaints?
Yes.
Yes, there is.
Yes. So the two officers, Ms. Walker, Ms. Williams, and the applicant's planner, I think they're hearing the question very clearly. You'd prefer that that the council was the recipient of all the complaints?
Yes.
Or at least both the council and the consent holder?
Well, I think that, no, I'm happy for the consent holder to be required to maintain a complaints register. I don't think that the consent holder should be the sieve or the primary determinant of whether something is non-compliant or not.
Yes.
Right. I think that is a regulatory responsibility.
Yes. I guess it's not for me to give an answer, but the way I had interpreted the word may is that there may be some uncertainty as to whether there is compliance or not. Not that it was giving a discretion to selectively sieve only those non-compliances that they wanted to forward onto the council.
May still is a very broad.
It's discretionary.
Discretionary.
Yep.
Yes.
Look, the point's well made. I think the officers are aware of it and they'll respond.
Thank you. Yep.
I just note, because we have got two sets of conditions, obviously, one from Greater Wellington, one from PCC. The Greater Wellington one is worded differently, where I won't read the whole thing, but just at the last sentence says complaints received shall be forwarded to the manager within 24 hours of receiving a complaint. So is that
more
sort of
along
wording
lines.
give you a little bit more comfort
Yeah.
about where that complaint goes and what happens
Yes.
to it? Yeah.
Yes.
So maybe if that wording was, or similar, was repeated on the PCC.
Yep.
Yeah,
Similar.
thank you.
So I'll move on to the next
Yes,
point.
please.
Community liaison group. I think it's a very good idea, and certainly that, given the, I guess, the interest of on the quarry for the, particularly the residents in the area, but the public generally, it's important that transparency be introduced into the process. I was impressed that the traffic expert for the Judge for Environment Protection Society was perceptive in noting that cyclists and pedestrians, and from my point of view, cyclists use State Highway 58 as much as trucks do. And I think that was a very valid point. He noted that some of the data indicated cyclist use of it. And I do use State Highway 58 quite regularly. I would point out that I guess over the last few years, the number of cyclists in groups anyway using State Highway 58 reduced for a period of time while the Hayward Hill construction was going on. Essentially, the construction made that road unsafe for cyclists. It's improved now that the work on the Hutt side is largely finished. But I guess it's going to become more and more difficult though over time as the construction moves further west. Where I do disagree though is the argument later on in the case put forward by the Council for the Environment, the Judge for the Environment Protection Society, that the CLG, the Community Liaison Group, exclude users or members of the public other than people who live in the area. I don't think on the one hand you can use data saying that there are cyclists using the road and therefore they should be included as a concern or a factor. But then on the other hand, you want to exclude those people from actually having a view on the impact of the quarry. I think it's important that if it's a community group, then it reflects the wider community. How those people are selected to be on that group is another issue down the track, which... So that is my first point in respect of the community liaison group. My second point is whether the community liaison group is a private body or a public body. It seems to be a hybrid. It's to be established by the consent holder, but then there are people involved who are not members, this is the council and the iwi, and members of the community, however you define that. So the minutes of the meetings of the group are to be made publicly available. But it's not quite clear who publishes those minutes and whether those minutes and any other information is official information. So, for example, if it's official information, and if this body is public and it's official information, then it's the minutes and any other information tabled at that meeting is subject to the Local Government Official Information Meetings Act. If it's not, then how does the public obtain information relating to the business of that group. I think it needs to be made clear what the status of this community liaison group is, because it's not clear to me.
Do you really think that's material, though, Mr. Neeson?
I do. It's in the conditions.
Yes.
So if you're going to establish a group as a consequence of these conditions, you have to know why you're establishing it and how it's going to be managed. Form follows function, Mr. Chairman. So what's its function, then determine its process.
Isn't condition F sufficient, and isn't it just sufficient that the meeting minutes are made publicly available? How that's achieved is a mechanical exercise.
No, it's not.
Surely.
Who's going to make them available?
Well, we know that they have to be public. The conditions state that they have to be publicly available.
Yes.
So the question then is how.
That's right. And by whom?
Yes.
Yeah, that's not mechanical. That goes to the heart of, as Ms. Strugnell pointed out, finger pointing. The consent holder could well say, no, it's up to the council. The council could say it's up to the consent holder.
Who do you think it should be up to?
I think, in my view, that the council should actually be should manage the community liaison group, and the council should publish any documentation related to that community liaison group.
That's not the way the condition's been structured.
No, I know
though,
they're not.
It's an obligation on the consent holder.
Yeah, but I think the council should take responsibility.
Yes. Have you seen other conditions on community liaison groups that would suggest an alternative approach?
No, I haven't, but I just know on the basis of, I've done lots of public consultation,
Yes.
that it is really, it's the responsibility in the end is here it would be the local authority. It's has to monitor compliance, enforce compliance. Therefore, if it's going to if parties are to come together and that requires the draft conditions require an independent convener, that it should be, in my view, under the auspices of the council. So the council can engage the independent convener. It might want to charge the consent holder for that. That's the council's business. Then you end up with a body that is seen to be independent, rather than sort of. If it's,
Well, aren't you conflating an issue that you've addressed here is how are the minutes made public? And now you're raising concerns about the independence of the.
Well, no, they're two different. They are different points.
So let's just focus on the public nature of the minutes. So the moment it's an obligation on the consent holder.
Yes.
And you've quite rightly raised some issues about how and who would undertake that. If those matters are resolved and there is a clear mechanism how those minutes are made public, does that address your concern?
No, it addresses that concern.
Yes.
And then there's another separate concern, which is probably a bigger one.
Okay. You tell me about that one.
Which has just been talking about, Mr. Chairman, is what sort of a body is this? In my view, it should be separated from the consent holder. The consent holder should not be, if you like, the gatekeeper of this community liaison group. It should be, the council should be the primary responsible body.
Does that depend on the willingness of the council to undertake that?
It does, but then that's your responsibility. I would have thought your role to tell the council that you believe that this is the way the process should be managed, not the consent holder suggesting how it should be managed.
Well, not sure if it works that way. I mean, we receive draft conditions, we receive comments from councils, and we receive comments from submitters. So there's three different sources there.
Yes.
You're suggesting a particular approach, and we need to give that due consideration.
Correct. Yes, that's fine. It's over to you.
Yes. But I guess what I'm trying to, get your comment on is there a fundamental difference between the intention of the conditions 9, 10, 11 relating to community liaison group and the delivery such that it might result in a materially different outcome other than what was sitting behind the intention initially?
I think that over time there would be. I have a feeling that, good intentions tend to morph into other interpretations or application over time.
Okay. Well, we've recorded your concern.
My last comment is about inclusion by reference. And the draft conditions require the consent holder to prepare and abide by numerous management and operational plans. For example, ecological, lizard management, quarry operations, and there's a raft of others. These are key documents that lie at the heart of the enforcement of the consent conditions, yet it is unclear whether they have have been finalised. The conditions seem to include or incorporate by reference. Now, given the sensitivity of this application from a public perspective, I would have thought it had been really important that all those plans that are incorporated by reference be readily available to the public. And I think they should. In this case, I'm suggesting or proposing that the council should make those documents public. So it may have, for example, on its website, a copy of the conditions related to the quarry, if the application is granted. But attached to that should be all the finalised and approved documents incorporated by reference. So there's no doubt what they are and where people can obtain them for a reference point if they want to check those sorts of things.
Okay, I've made a note of that. To the degree that it assists you, can I just actually have a look at condition 13, condition 14? This is on the Porirua City Council set of conditions, the set of conditions relating to the Porirua City Council consents. So condition 13, that deals with the quarry management plan, do you see that? And condition 14 deals with the noise management plan. And the key difference in the wording of that is in condition 13, the word final is inserted before quarry management plan.
Yes.
And you see that that word doesn't feature in condition 14. And as I understand, the reason for that is that the application as lodged includes a draft quarry management plan. So it's being prepared to a certain stage. It needs further nuancing to take account of a whole range of things, including this hearing. And so once that happens, a final plan has to be prepared, submitted to the council for certification within a certain time period. Conversely, and I hope I haven't got this wrong, but I'm sure Mr Matheson and Mr Baker will tell me if I have, the noise management plan in condition 14 doesn't exist. It doesn't form part of the notified application, and so it's a post-consent condition requiring the production and certification of a plan. So that's, and there will be numerous other examples. I think this erosion sediment control plan is in draft form.
Give a quick clarification.
Yes.
So all management plans have been drafted with the exception of that noise one.
Yes.
So there is a draft of all others.
Okay. Okay, that's good. Well, fortunately I picked the right example then. That was not by design. But that's the general approach, and the courts have found, the courts originally had concerns with future management plans dealing with effects that have been considered a part of an earlier decision. So I think that they've moved on from that now, but they've moved on on the basis that the consenting conditions around those future management plans need to be robust. They need to stipulate what the objective of the plan is, what it should contain, who should prepare it, who should certify it, how often it should be reviewed, what works can or can't be undertaken until it's certified, how additions or adaptive management conditions are fed into that. So that's a discussion we had with the applicant on day one, and I think the council officers, Ms Walker and Ms Williams, are very alive to that issue. And I must say it's a personal issue that I have, a professional issue I have on the construction of condition writing around management plans. So I think you can be rest assured that this matter is going to be very robustly considered, because if the avoidance and remedy and mitigation of effects relies to a significant extent on management plans, we need to be satisfied that those plans are going to be fit for purpose. And the only way to do that is to either see a draft of them and to see the condition framework that governs the finalisation and ongoing implementation of those plans. So, very long statement from me, but just to give you an indication that it's very much a live issue for this panel.
Great. Thank you, Mr. Chairman. I mean, I don't have any problems with any of that. My real point here is that those plans
Should be
when
public.
should be public.
Yep.
That's
Okay. And I'll just note that down.
Thank you.
Anything else, Mr. Neeson?
No, that's fine.
Okay. Thank you for that. I'll invite you to provide your speaking notes to Ash, and we'll get those published on the webpage.
Sure.
Mr. Chair, just on that note, and I've just had a discussion with Mr. Walsh, and consistent with the way the world's going, it's and we'll put it in the conditions, but I think the proposal is to actually have a specific website area to host these documents.
Okay.
So I just wanted to put that on the table now for the benefit of the council and others.
Yes.
So that would hold your management plans and everything and
That a Fulton
CLG.
Hogan website,
Yeah,
you mean?
well,
Or
specific for the
Willowbank.
quarry, specific to the quarry, and then you can put the CLG minutes and everything on it and find them.
And would that be a portal for complaints potentially too, or?
It depends how it's built.
I just noticed there's been a couple of points, from submitters about the ease of, being able to make a complaint, I feel like. I'm not saying that they're going to do it every day, but they want to be able to have an easy process. And I just wondered if you're developing a portal for the quarry, that might be a place for it all.
Yeah. So look, typically it ends up with the quarry manager actually being the recipient of complaints at other quarries. However, where we have community liaison groups, they often have input as to how the complaint should be made and the process.
Thank you. Right, just before we take the lunch adjournment, I need to come to you, Professor Irons. Clearly, we're still running late. You were supposed to be on at 11. It's going to be probably 1:30 till we get to you, and I just wondered if that creates a problem for any of your witnesses, and in particular, Mr. Kirkere.
It does. So Mr. Kirkere is at home with COVID. He would very much like to stick to his 1:30 time.
Yes.
But there's also Rebecca Sternman. Ms. Sternman is online. I don't know if she's still listening because we're way past when she was meant to go on as well. And I haven't heard from her yet as to her timing. What I would suggest is both of them go before I do, since I'm here and I can stay.
That's fine, but what I'm suggesting is that we're going to take the lunch adjournment now.
Yep.
And we'll come back at 1:30,
Yep.
Presumably to hear from Mr. Kirkere, followed by
Ms. Sternman.
Ms. Sternman.
And then myself.
Okay.
That's what I would propose.
Thank you. Okay, we'll see everyone back at 1:30.
Thank you.
Okay, ladies and gentlemen, hopefully you're well rested and watered and fed. We'll proceed into the afternoon session, and by my calculation, we're running around about 90 minutes behind time. I'm not perturbed generally, but I'm sure we can make the time up. But if we can't, we'll make sure that everyone has sufficient time. So I'm going to come to you, Professor Irons, and I want to also acknowledge Ms Blake's presence in the room too. The intention is to hear, as I understand it, from Mr Kerr, and then Dr Sternman in that order. Then we may go to you and then Ms Blake. Is that?
Yes, that's correct. Thank you very much.
Thank you for that accommodation. Do you want to introduce Mr Kerr in any way, or are you happy for us to go straight to his presentation?
I'm happy not to waste any time and go straight to his presentation.
Good. I think we've sorted out some mechanical issues in the lunch adjournments. So thank you for that, Ash. Welcome, Mr Kerr. We're just wondering whether you're on mute, Stuart. Okay. If you're able to hear us, Stuart, can you just raise the hand on the button on the Zoom or Teams to indicate that you're hearing us? Still showing as mute, isn't it? Semaphore. Have you got his number? Yeah. Don't you just love technology? Yeah. Here we go. It looks like we have some action. Welcome, Mr. Kerr. We can see part of you, and it looks like yes, we can now. Are we coming through? Can you hear me? Yes, we can hear you, Mr. Kerr. Getting a little bit of echo, Mr. Kerr.
Screen sharing. Yeah. Stop video.
Mr. Kerr, just pause what you're doing. Doesn't sound like he's hearing us, does it? Mr. Kerr, can you hear us?
Oh, yeah, yes.
Good. Okay. We have a very oblique view of you. I don't know where your camera is situated, but somewhere beneath you by the looks of things.
Oh, yeah. If I turn it much the other way, the sun blocks it out.
That's good.
But focus on the slides. Slides are that's the real oil. I'm just a spokesman.
Okay. Mr. Kerr, we're going to invite you to take us through your presentation. Are you sharing the screen, or you are? So you've got control of the mantle there. Before we start, Mr. Kerr, I just need to disclose a matter to the gallery, and that's Mr. Kerr is known to me. I only just realised that in the last day or two, and Mr. Kerr was a consultant that worked with myself on a particular project. I think close to 20 years ago on the Windstone Wallboard site in Apawa in Christchurch. You may not remember it, Mr. Kukur.
We still, yeah.
Yes.
So who are you?
My name's, sorry, that's a good question. I'm David McMahon, Mr. Kukur. I'm the chair of the hearings panel. I'm a resource management consultant based in Wellington, but at that stage I was based in Christchurch, and our mutual client was Windstone Wallboards, who are part of the Fletcher, and I was engaged to assist with a air discharge consent from their paper factory plant, and you assisted in a technical sense for an application to Environment Canterbury. So I just wanted to get that on the record. I don't consider it to be any conflict, but I wanted to disclose that. And I don't just invite anyone to, if anyone has any issues, now's the time to speak about that.
Especially since he doesn't know you. So.
No. That's probably...
Sharp memory to me, but I can't remember.
No, that's quite all right. I'm not that memorable. And it was...
You've got a good memory.
It was some 2 decades ago. Right, I'm going to be quiet, Mr. Kukur, that we're in your hands. You've indicated you wanted 30 minutes, I think. And so just invite you to use that time the best way that you can. You go through your presentation and we'll try not to interrupt you, and we'll ask you questions at the end.
I was told at 15, so I hope they're well and truly done. Okay, I'll crack on now. So first is a wee summary of what I'm going to go over. We'll talk about what is dust and what the different types are, and then I'll go through what the health effects of different types are. Then I'll talk about respirable crystalline silica and how that affects the body. I had 2 videos where we engaged with neighbours, and they give a bit of feedback on the dust, but it doesn't seem to be working, so I'm sure we can send you the files and watch them. They're about a minute, and I can tell you what they say. Now I talk about dust and how far does it travel, and then talk about the recommendations, how they should review the controls they're doing on site, what the activities are on site and what they're likely to cause dust, and what controls are required under the law. So I'm talking a bit about types of dust. Dust is made up of a huge size of particles, and in the slide you can see that there's one 60 micron diameter bit of dust, and there's on the right hand side you'll have 60 nanometers. There'll be millions of billion particles. And so now what is called for, and the World Health has made a comment in this effect, is that you need to consider the number of particles per metre cube rather than the weight per metre cube. Because if you do a weight, these billions of nanoparticles, they don't come up to anything on weight per volume, but they do come up to a lot in number of particles per metre cube, and these are considerations need to be made. So that's ultrafine. PM10 is particles less than 10 microns. PM4, which is respirable, particles less than 4 microns, and PM2.5, particles less than 2.5 microns. Now these definitions are largely convention. In reality, they're not. PM10 is not particles less than 10 microns, because you get particles up to 20 microns in a PM10 sample. So we use these as a convention because everybody in the world is talking about the same thing, and it's linked to the way these particles are measured. And why do we worry about the particle sizes? The smaller the particles are, the further they're going to go into your body. They're going to get into your lungs. Once less than 4 microns, you can expect they're going to make their way into the lungs. And the really small ones get right down into the alveolus, right into the meat of the lungs. Now I'll go over this a bit more, but when particles of crystalline silica get into the alveolus, you can see in the diagram that these alveolus get like cemented up. And so you're basically, if the diagram there on the left, normal alveolus is a hollow, and that is where the air exchange happens. And on the right there's a picture of layered with crystalline silica. And the body has no method to get rid of it. So once it's there for life. So if you get this ailment, basically you can't breathe. So how far does this travel? In the applicant, they said in the AE, they said it won't go much more than 200. There's subsequent evidence said it will go 400 metres. If you think of this unpronounceable Icelandic volcano, the dust from that shut all the airports down through Europe. It even affected flights in New Zealand. So that dust from that volcano travelled a long way. The AE quotes that dust can travel 1 kilometre for PM10. How long is it known airborne? Well, it can be from minutes to weeks. The range of dust can be from 1 to thousands of kilometres. So it's reasonable to expect that dust from a quarry could reach a neighbour at 400 metres and even further. Here's a graph from the moat study. And this is where they've looked at the dust coming from the quarry in Hallswell. And you can see on the brown line, the dust will get to 650 metres on the dotted line. But the brown line is 500 metres. So it is going, the PM10 will make the 650 and 500 metres. And this is in the AE quote of the study. And this is even on low wind speed, so it doesn't need to stir up for this effect to happen. And that's PM10. There are other dust sizes could also be expected to reach that far. And in some of the evidence I read that it said a proportion will be deposited. Well, what's critical is how much of that's going to be deposited and what's in it. In some of the evidence now, it says, well, it takes 5 metres per second to make road dust airborne. The CSA is predominantly larger than 10 microns. There is no data to substantiate these predictions. There's no data to say crushing is the only source of fine dust. In recent evidence, I read that crushing is the only source. Well, I'd ask the question, how do you know it is? How do you know it's not coming from the screening, the blasting, the earthworks? There's so much unknowns about it. And I talk a bit about spiral crystalline silica. Crystalline silica is what they call a class 1 carcinogen. So it's known to cause cancer. There's recent studies, and I've quoted them in my evidence, that is suspected to be a genotoxin. And a genotoxin is a substance that can cause health effects at any concentration. So it's not just the limits, it's at any concentration, it's considered to cause health effects. So the evidence in AE relies heavily on the moat data. The authors of the data have expressed a concern that there was flow issues on the data. They use a detection limit of 20 micrograms when analysing the sample, whereas 5 and even 3 micrograms can easily be obtained. The moat study did a long-term study, so it was samples were for a long period of time, months, whereas there's no short-term data. And you might say, well, short-term doesn't have a health effect. Well, yeah, it does, because if it's a genotoxin, any exposure is going to have a health effect. The moat data also uses a method that was unvalidated. It was an in-house method, and there's no data I can find that peer reviews the method used. It was also done in a year where Environment Canterbury said it was a very high rainfall year. So there are question marks on the moat data which is being used to obtain a consent here. Now there's one key question that hasn't been asked and hasn't been provided, and if Fulton Hogan had experience in quarries, he would have thought they'd have some idea, is how much crystalline silica is in the quarry dust. Is it 1%, 5, 20, 50? Is nowhere have I seen it said, well, this is how much crystalline silica is in the material they're mining. Now that's quite significant, because if a proportion of the dust reaches the residents, how much is there originally can affect how much they receive. And consultant that the council used said it will not be environmental concern. And again, the AEE doesn't actually have any data to validate the claims made. It's all done by predictions. And it's easy enough, very easy to do, is to set up air sampling at the boundary, at residents' place, to see how much dust is arriving. And you can do what they call suspended solids, where you take a sample of the water in the neighbour's rain tank, you filter it, and you can measure how much dust is in their rainwater tank, and then you can do an XRD scan on that dust and compare it to the dust on the site to say, well, is the origin of this from the quarry, or is the origin of this somewhere else? So it's like fingerprinting. You can do analysis to find out where the dust has come from. And there's reasonable grounds to question whether Rule 17 are complied with. It's, as we have no data to validate the claims, that it's not going to be an issue. The AE said that the majority of the extraction is from the pit, and that the dust in the pit will be contained because it's in the pit. Well, the neighbours have said that they get dust. All the neighbours I spoke to said they had dust previously, so whether the pit is an effective method for containing the dust, well, that's questionable. And then when I spoke to the quarry manager and the national quarry manager, Fulton Hogan, they said they're doing stage 1, 2 and 3 first, where basically they knock the tops off a hill. The stage 4 is a quarry pit. So scraping the hill, is that going to create dust? It's up high, it's more exposed. We don't know. Again, no data to say, validate that. Now, the controls they've quoted in the AEE is a 20-year-old document. The controls have changed in quarries, I'd imagine, in 24 years. And one of the key factors in containing dust is that the dust particle needs to be matched. The size of dust particles need to be matched to the size of the water droplet. Because if your water droplets are too big and the particles are too small, then the surface tension in the water is not enough to capture those particles. They just go around the water droplet. So you need to have your water, or whatever technology you use, matching the particle size of the dust. But there is no indications on what particle size they've got on site. Speed limits, I can't remember what it is. I'll just skip that. Okay, so my fishing buddy said to me a resource consent is basically a permission to pollute. And when I went visiting the neighbours, they said to me, well, no one from consultants council or the company has engaged with them at all. And I see there's complaints which weren't validated. And a lot of it is about our Kiwi culture. We go to a restaurant and we have absolute crap service, well, we just don't go there again. It's not in our DNA to complain. We don't do that. It's not what we do. And this whole process is quite intimidating for me and also for Joe Public. Now, I've got 2 videos that don't seem to work, so I'm going to tell you what they say, and I'll give you a copy. These are from 2 neighbours. The first one says that during the summer, they have to keep the doors and windows closed, because if they don't, the house gets full of dust, and that makes their house very hot. So these neighbours are about 400 metres from the quarry, and they say that their son has respiratory illness and they're concerned about his health effects. He also says they've changed their filters on their water from 20 and 5 to 10 and 1. So that suggests to me that the dust reaching these places, if it's come from the quarry, is bigger in size. If you can see dust, then it's bigger in size. And remember, the human eye can only see particles greater than 40 microns. Anything less than 40 microns you can't see. And I've read about some complaints that weren't validated, which I asked the question, well, how can they possibly validate a complaint or not, just based on a visual assessment, when visually you cannot assess whether there's PM10 there or not, because it's invisible to human eye. The only way to really validate is to take a sample and test. And I know the Wellington Regional Council will have a sampling kit that can do this. Do the local council have sampling kit? Do they have the skill set to go do that? The other video is about a lady who lives nearby and said that she's lived there for 20 years. She says normally they'll wash their water tank out every 5 years, and they'll take out 2 buckets of dirt. It says now they have to do it every year, and they take 5 buckets of dust. So that suggests to me that there's a change happened, and that change could be from the quarry. Well, here's a lady, but you'll have to, the sound doesn't work, so I'll send you the video. Okay, vehicles. The AE doesn't really address the issue of
hopefully you can. A whole bunch of carcinogenic compounds come out of vehicle emissions. Now, one property that I visited, you can see there's a hill. And whenever you go up the hill, the first thing they do is change gear. When you change gear, it pumps out a puff of smoke. Now this, I took a photo from standing on this owner's boundary to the hill. Well, whether it's 200 metres, 50 metres, it looks like 50 metres to me. When I'm from Littleton and when they have a bulk shipment in, there's a very strict protocol. All truck drivers, they must cover their vehicle load when they're full and when they're empty. And if you don't do it, well, they're in trouble. So they must cover it both empty and full, no matter what the load is. In the AE, it talks about, well, weasel words in my view. They say, when we think it's dusty, we'll cover them. So how do you determine what is dusty? So what I don't think has been enough work's been done considering the actual health effects to the neighbours and neighbouring property as well as the people who work there. There is no data for the site. the AE and reviews and evidence relies heavily on models, opinions, but there's nothing to validate what they've said. You know, last weekend I expected the All Blacks and the Warriors to lose. And that's my expectation. But you don't know until you actually test it. Well, unfortunately, they did win. So you don't know whether the claims made in the AE and evidence, whether it is validated or not. It relies heavily on Moat report that has issues, and there's reasonable ground to expect that the AE is not going to be complied with. In the evidence I've read, it says, where practicable, avoiding particularly dusty activities in windy, dry conditions. Well, it uses words like where practical and avoiding dusty and windy, dry. It doesn't say if the wind speed is over 5 metres per second and the moisture content in the ground is less than X, we will not do activities. So it's just left up to subjective opinions on site. And they can say, well, it wasn't practical, or yeah, it wasn't that dusty, or it wasn't that windy. What is windy conditions? It's not defined. So, summary, I think the dust is a good, I expect the dust will travel to the neighbours, but just like the Warriors and the All Blacks, you need to measure that to know, because it could be wrong. Respirable crystalline silica, it's been suggested it's a genotoxin, so it'll have a health effect at whatever concentration is present. Activities on site and how they're going to manage it are unclear. The Moat report has a number of issues, which has relied heavily on the AE, and the controls that they use on site really need to be updated with current technology and make sure it'll capture the dust. That's it. I'm done.
Thank you, Mr. Kerr. Appreciate your health is not at its best, and we appreciate you attending today. I'm going to hand over to my colleagues, Commissioner Nigel Mark Brown and Commissioner Burge, and to see what questions they have for you, and then I'll follow up with a few mop-up questions at the end. Commissioner Mark Brown.
Good afternoon, Mr. Kerr. Thanks for the effort of appearing today online. My first question relates to the evidence of Mr. Noonan for the applicant that he has used the UK Institute of Air Quality Management Assessment of Mineral Dust and Impacts document dated 2016 to address the risk of adverse air quality effects on the neighbours. And according to him, using that IAQM document, that the risk at 400 metres will be negligible. My question is, do you know about that publication and have you used it? And do you think that it is relevant for the situation? 3 questions, I guess.
So am I familiar with that document? No, I'm not.
No, okay.
But any controls that you use, you need a measure to make sure they're effective. You can use whatever controls you like, but you need to test to say, we're going to measure how effective they are and what the impact is on the neighbours. And I was going by the controls written in Matthew's evidence and in the AE, and they weren't that specific.
Yeah, so perhaps your main point is, you can do all the assessment you like, or when you say that hasn't been enough done, so there needs to be some monitoring. That's sort of really your bottom line?
Yeah, I mean, Paul and Hogan are well-experienced operators in the quarry business. And well, I would have expected they said, right, well, we're using X, Y, Z control mechanisms, and this is the data that shows how effective it is. It's easy enough done. We're not asking for rocket science. It's easy to go and user controls, put some monitors on the boundary and say, right, these controls generate this.
Yeah. Have you been involved in Quarry assessments of effects and consent applications similar to this one, or relate? You know that dust's an issue.
Well, I've had people contact me and ask me to go and do monitoring, but I haven't done it. But no, I haven't. No, this is pretty much my first foray into the area, but I have been involved in dust from other processes.
Yeah. Certainly, in my experience with dust monitoring for landfills, which are different animals I know, it's been of limited use because the argument has been, probably by the landfill owner, that the dust has probably come from some agricultural source. So I guess that goes to your point that if you're going to monitor for dust, then you need to do an analysis to see where it comes from. So that's a crucial part of it.
And it's easy enough to put a monitor on the property or in a boundary that measures a whole range of particles, sizes, PM1, 4, 10, 2.5, and then run side by side another sample that just sucks a massive volume of dust, and then go get an analysis done on that dust and see what the composition of that is compared to what's on site.
Yeah, yeah.
It's not that difficult to do. And but Thornton Hogan experience, I would have thought they would have done that already. And I asked the question, why isn't it in any evidence? Why hasn't it been mentioned anywhere?
Okay, thanks. That's all I have. Thank you.
Commissioner Burge.
Thank you. Just a couple of things from me. Would you agree, Mr. Kerker, that regardless of the size of particle, it would disperse and dilute as it's travelling through the air? Once it gets picked up from the ground and it's travelling through the air, would you agree that it gets dispersed and diluted to whatever degree?
Yeah, there's a saying I tell people, my clients, all the time. The key to pollution is dilution. So, hell yes, it will get diluted and it will disperse, but that depends on how much is in the source, how much crystalline silicate is in the source. And in the moat study, they talked about, I think about 70% reached was attenuated, so lost to 650 metres. The 30% made the distance. And you only need to look at where there's a fire and you can see the plume from the fire. It doesn't go in 360. It generally keeps fairly well together.
And
if you downstream that plume, well, then you're going to have all sorts of manner of grief.
Sure. I mean, I know you've been on site. We went on site on Sunday, and it was very beneficial for us to see, the actual location of the quarry, the topography, all the intervening hills, vegetation, all those sorts of things. They would have would you agree that they would all have some sort of role in, the degree of dilution and dispersion?
Well, without a doubt. So the question is how much?
Sure.
How much are they going to do? How much is it producing? You just don't know. It's like crystal ball gazing. Yes, they will have. Well, the key factor is going to be the wind and the wind speed, I would imagine. But we have no data to validate the claims. It's all going to be dispersed. It's all going to be diluted. And my gut feel is that passion and the number of neighbours that say they have dust issues suggests that, well, there probably is an issue. And the only way you can really confidently say there's not an issue is, well, measure it.
So I'm hoping we'll hear from some of those neighbours at some point. But are you aware that the applicant has offered a condition to say that there will be no objectionable or offensive, shall we say, particles beyond the boundary. Are you aware that they have offered that condition?
No, I didn't.
Is that something that would go towards, you're saying there's no monitoring, there's no controls. Does that go some way to crossing off some of those issues?
Well, yes, if they're saying they're going to comply with that Rule 727, that'd be fantastic. But remember, crystalline silica is suggested it has health effect at any concentration. So, and if you can argue about what concentration is valid and what's not, any crystalline silica has potential to cause a health effect and be objectionable. So that is good. And I'd add into it, I need to validate it for the life of the consent.
And I think that's what's offered up. The other day we heard from Mr. Walsh of Fulton Hogan. I'm not sure if you were listening in at that point, but one thing he did say was that they do monitor their staff for the RCS, as a health and safety occupational routine sort of operation. So that they take that very seriously, from what I understand, as a occupational health and safety thing. Is that something that you're aware of that happens in other? And what is your opinion on that?
It's a requirement of the law.
Yeah.
That they need to do that. So an industry, an operator like Fulton Hogan, I would say, well, I'd be surprised if they didn't do that. And I know personally they've got staff there that can do that work. I would have thought they do it, but what surprises me, that would make a really useful information if they had to put it in with the evidence or had to put it in an AEE.
Yeah, I think the point is the quarry's not operating at the moment, so it's not. But what I mean is that they undertake that. They will undertake that when the quarry's under operation. So I'm sure if there are effects in their staff, there would be a management response to that.
Well, there's the quarry was operating prior to Fulton Hogan for a number of years. So where's the data from that?
Yeah, well, that's under a previous consent, and they may or may not have had conditions that around that. I'm not sure, but I'm only unsure what's in front of me today. But I guess one thing I'm taking from that is that you have some sort of comfort with the condition that is or two conditions, I think, that are proposed regarding anything objectionable or obnoxious beyond the boundary.
Yeah, if they can do that, well, that'd be fine. But just going back to the previous consent holder, it's a legal requirement that they must do their occupational health assessment.
Yes, it's not an RMA requirement. That's probably what I'm saying.
Yeah, but there's a legal requirement that they would do it previously. Therefore, you'd expect they did it, and why haven't they provided that data?
Sure. I can't answer that, sorry. That's not in front of us, but thank you. I appreciate your help.
Thank you, Mr. Kierkegaard. David McMahon here again. Just a few from me, Mr. Kierkegaard, and in no particular order. I just wanted to pick up on some of your responses to Commissioner Mark Brown. And these aren't critical at all, but just for the record, that this is your first foray, I think you said, into quarry assessment, and that your assessment of you've been involved in the assessment of dust from other operations. I imagine particularly industrial ones. This is
we have been involved in quite a number of quarries doing workplace assessments.
Yes, in terms of the health and safety and workplace legislation, presumably. Yes, and you accept in this case, though, that's not the jurisdiction that we're acting under.
partially, I would imagine your jurisdiction is concerned about the risk to health of the neighbours.
The risk to the health of the environment and persons that reside in that environment from a natural and physical resources perspective, as opposed to occupational health and safety, which is governed by other legislation. So this is something I tested, I think, with Mr. Noonan the other day, and he made it clear that there were two different standards. One was an occupational health and safety standard administered by WorkSafe New Zealand, and that the ambient air quality standards that are administered by the government and which find themselves being reproduced or modified in regional plans around the country is the RMA context in which we are operating under. So I just want to make that distinction clear.
So under your definition, are the neighbours part of the receiving environment?
Yes, they are.
So do their health and safety need to be considered?
Oh, their health and safety, but not an occupational safety in the narrow sense of the word, of workers on the site. That's covered by other jurisdictions. But look, we don't need to get bogged down on that, Mr. Kirk. What I was just trying to understand is how much experience you'd had in this field. You were quite candid and said that this is your first major foray into this area, but that you dealt with other dust source issues. And I just wondered if you give us some examples of those alternative or other examples that you've been involved in.
Well, we've looked at air quality within the Canterbury airshed, where we measure 2.5 micron particles in the air.
Yes.
We did that alongside Environment Canterbury monitors. So that's running monitors for a couple of months, where we're looking at what the particles are in the airshed and compare it with data from ECAN.
Thank you. Any other examples you'd want to draw to our attention? It's not a trick question, Mr. Kirk. It's just I'm just trying to get an understanding of the breadth of your expertise in this area. Then that's fine. I can understand why you would say that. Acknowledge you're suffering from COVID-19. So, I guess the next topic of questions is you've talked a lot about the AEE that was lodged with the application, and it's clear to me that you're very familiar with it from what you've said in your evidence and your comments today. I wonder whether you've had any opportunity to consider some of the draft management plans that have been produced as part of the application also.
I've probably read them, but I don't. Nothing in them has sort of struck my mind and saying,
okay,
I haven't read them in detail.
Right. Okay.
There's a whole bunch of stuff to read. So
certainly, and as a panel, we certainly were the first to acknowledge the voluminous nature of the material. So you have our sympathy there. The reason I asked that question, Mr. Kirk, here is that there's a couple of management plans that the applicant and Mr. Noonan have asked us to focus on specifically, and that's the Quarry Management Plan, and, well, particularly the Quarry Management Plan, which includes a number of requirements, including looking at dust nuisance, and that's there's conditions relating to that in all three consent applications that are in front of us. But the general tenet is that the applicant has produced a draft quarry management plan that was part of the AEE, part of the application is lodged, and then there's a condition that requires them to finalise and nuance that plan based on all of the evidence heard during the course of this hearing and any other relevant matter, to submit that to the councils, and I say councils in plural, Porirua Council and the Greater Wellington Council, for certification. And through our questionings, we've indicated that the conditions that are governing that process should make it clear what the objective of the management plan is, what it should contain, who should prepare it, what the process of certification should be, how it's adapted over time through adaptive management, how the undertaking of work should relate to that certification, and the review, ongoing review of it. And it's been suggested that to us by the applicant that's a key management technique to control, in this case, the issue of dust. And I just wondered, as a broad tenant, do you accept that management plans have a useful role in achieving the control of nuisance such as dust?
Yeah, potentially, but this is devil in the details. Is what are they going to do to validate that the risk?
Okay, I think I understand what you mean there. So let's just break that down. Would you accept that if the management plan had sufficient level of detail, or the conditions stipulating what that detail is appropriate, and that information comes forward in the management plan, then based on what you're telling this panel, the key issue is the monitoring and validation that the operation is occurring in the manner anticipated by the management plan. Is that it in a nutshell?
Much. The validation that the control systems are effective.
Yes. And what's
validation?
Sorry,
that there's no increase in crystalline silica at the neighbouring properties.
Yes. And look, these questions might seem fundamental, but I need to ask them anyway. In your view, what would be the key mechanism to achieving validation in this instance in terms of achieving the objectives and goals and the processes and procedures that are set out in the management plan for dust?
Well, no increase, as it says in Rule 27. There's no dust that's objectionable or toxic leaving the property.
Yeah, and what's the method of validating that, though?
We just test it.
Yeah.
Just measure what it is now, measure what it is when the plant's operating.
Yeah. Through the location of monitors around the site or at the receptor or at the boundary? That's what I'm getting at.
Oh, effectively, if you're doing both. Not every neighbouring property, just randomly select those that say they're affected the most.
Yes. And should that be, how frequent should that be undertaken and for what duration? How critical are those parameters in the validation process?
Until you've shown there is no effect.
Right. Okay. If you were writing the conditions of consent for this, and I appreciate you're not, what would be the key? What were the key sort of metrics that you would suggest that those conditions contain in terms of frequency of monitoring, location of monitors, that sort of thing?
Well, initially be at the closest neighbour, and the monitors you can set out and they can run for months and they log every minute.
Yes.
So you're looking at the data to show there is no increase
yes.
of toxic dust at those properties. So one at the close neighbours and one at the boundary.
Yes, close neighbours and at the boundary. And to what extent does the prevailing wind condition have an impact on the placement or location of monitors in that sense?
Well, you really want to be looking at those sensitive receivers.
Yes.
So you want to place them where the sensitive receivers are. If it's prevailing wind and there's no sensitive receivers downstream, well, then you're probably okay. But not prevailing wind, and I think some of these receivers seem to change around 20% of the time the wind blows in their direction.
Yes.
So you can run it. They can easily run 24 hours a day, and you can log the wind speed and wind direction. So
yes. Do you have a? Sorry, carry on.
It depends on. You want to basically consider those who are affected by it.
Yes. Do you have a sense of, and I don't, do you have a sense of what the prevailing wind is in this locality?
I have read the windrows in the AE, and it's not towards the neighbours.
Okay, thank you.
I think the neighbours, I'm not sure, I think it's around 20% of the time the wind is blowing towards it. The prevailing wind is the other way, I think.
Okay, thank you. I'm just going to change tack a little bit, Mr. Kirkia, and I'm very pleased to see that you've visited the locality and you visited the some of the neighbours. So thank you for doing that. I think that's critical for any expert witness to undertake those visits and familiarisation. So thank you for taking the time for doing that. You mentioned in your evidence, and you reiterated it today, that you'd talked to at least 2, if not 3 neighbours. Is that privileged or confidential information? Are you able to share with us the names and locations of those neighbours? I'm looking across at, I'm getting a nod from Professor Irons that's okay. Can you readily do that now?
No. They've got videos of them. Professor will know their names.
Yes. Okay.
There's Indian couple closest by, then there was that on the South African lady.
Okay.
On Jenny Blake.
Yes.
And then, so, no, I can't remember them because...
That's okay. There's another way we can achieve that. I'm sure Professor Irons will assist there. So I won't take your time any further on that. But presumably those 2 or 3, and was it 2 or 3 that you visited?
Jenny and South African. I visited, saw 3 people.
Yes.
Who went to 4 properties.
4 properties, okay. And
the guy who was on the 4th property was deaf.
Okay, that's good. Okay, and do you think, well, were any of those properties the closest neighbour?
I think that the Indian people were.
Okay.
Well, I heard the evidence this morning, and some couple were said they're 250 metres away.
That was to their property boundary. Yes, that was. Yes.
That house that they're building was just quite close to the people I visited.
Okay, and we drove up there on Sunday, so I think I know what you're talking about. But we'll get to use the vernacular. We'll get some validation of that from Professor Irons.
But the video is of those people.
Yes, no, thank you, and hopefully we can see that in due course. I understand you weren't able to hear the audio from your end either.
Yeah, that's why I like to come in person, because
yes,
I like all this technology. But they have got a copy. I can send you a copy of it.
Yes, please do. Just checking the rest of my notes. Okay, and this is just following on from questions from Commissioner Burge. This was about compliance with condition 27, which is the no objectionable or offensive beyond the boundary rule. The applicant has volunteered a condition to that extent. I think Greater Wellington have accepted, based on the evidence, that the activity could qualify as a permitted activity.
Correct, yep.
And I'm getting an affirmative on that. That sort of begs the question as to whether, why would you apply any conditions on that? But the applicant has front-footed that by saying, well, that works in tandem. To actually achieve the condition, you need certain conditions in place, and so we're better placed to put that on a group of regional consent applications, even if they're volunteered on what's known as an OGIA basis, which we don't need to get into. But my question to you is, in the event that rule's not complied with, and that there is some objectionable material beyond the boundary, and that would only be known, I guess, at the time of validation, is that the be-all and end-all? Don't we then consider the nature of that material, the nature of the dust in this case, its size, its composition, its quantities, where it's landing. Is it landing on paddocks, or is it landing in water systems? Is it landing in filters? Is it landing in the house? Aren't they all variables that we would need to consider in the event that conditions or that rule is not complied with?
I would say so, yeah.
Yes.
And I would say the well-being of the humans should be considered, the neighbours. And if they've been affected, we need to be improving something to make sure they're not affected.
Yes. So I guess the point of the proposition I was putting to you is that the mere fact of dust going beyond the boundary in itself may not cause an effect. It's the nature of that material, the dust, where it settles, and in what quantities and in what size are key considerations that we need to have regard to.
Yes.
Thank you. I think that's it. I'll just double check.
I've got a clarification point for you.
Yes, I'll come to that in a moment. Just let me exhaust my questions. No, that's everything. That's everything from me. So yes, please go ahead with your clarification.
You talked about workplace exposure standards and how they're not part of the RMA. Well, that's not quite right. And consultants have for many years used workplace exposure standards for consent applications. Okay. And these are often situations where there is no, and it's on the MFE website, a list of standards, priority of standards, that there's a last resort you can use workplace exposure standards.
Okay, I'm happy to be corrected on that, Mr. Keke. That was my understanding.
It's on the MFE's website.
Okay.
That you can use it.
Okay.
So we say that it's a clear line between workplace and RMA type issues. Well, it's not that clear.
Okay.
It's very easy.
Okay, can you just pause? I'll just double check if there's any re-examination. No. Any questions of clarification from Professor Irons? Was there any? No. Ms. Blake? No. No. Mr. Matheson? No. Mr. Matheson, is Mr. Noonan listening in to this?
Hopefully, but we
Yes.
can double check.
Yeah.
Otherwise, he can watch a catch-up version on YouTube later.
Okay.
Thank you.
Mr. Keke, thank you so much for your time. We wish you rapid recovery with your health. Would have been nice to have you here in person, but quite understand the situation you're in. So we are very appreciative of you making the effort, and hope you feel better soon.
Thank you.
Thank you.
Okay. Cheers. Catch you later.
Okay, that takes us to Dr. Stern.
He has been watching.
Great.
There we go.
Good afternoon.
Good afternoon.
I just want to check that I've got the pronunciation of your name right, and I suspect I haven't. So can you assist me in that task?
Sterneman.
Sterneman. Thank you.
Yeah.
Thank you.
And I'll apologise in advance. I'm a bit sickly as well to add to the group.
Okay. Good job. You're coming in remotely then, Doctor. Can you just give us a moment? We've got a couple of briefs of your evidence. I think we've got your full evidence and brief, and I think we have a summary also, which I identified just before lunch. Just want to put my hands on it too. Just a couple of ticks, if you don't mind. Thank you, Doctor. For once, my pile system let me down. But now I have your summary and your evidence in chief in front of us. So we're really in your hands, but what we've been doing up until now is asking witnesses to précis their summary and draw the main points of the summary out to us, and then, if necessary, we can dig down into your evidence in chief for any of the detail.
Yep.
That's
yep,
just a
I can do
suggestion.
that.
But if you think there's a better way,
Yeah, no, that's fine. So when I've reviewed the documents, and there is a lot of documents, so there might be some gaps in my knowledge on some of those documents, but according to what I've read, I believe that there might be a little bit of lack of understanding on both the effects on reptiles, bats and birds. For bats, we've got the long-tailed bat, which has been found in a number of new sites nationwide over the last few years. Like the last couple, it's been popping up in a few places. And from my understanding, having read the environmental impact report, it looked like they'd been relying on surveys in the surrounding area and desktop reviews. Well, I did think, given the threat status of that species, that it should have been surveyed using ABMs or automatic bat monitors, which is quite a simple way to survey for them. So there was just a few aspects of the AEs like that, which I thought were quite important, but particularly that species because of its threat status. The applicant's ecologist suggested that they could add bat-friendly tree felling protocols in the consent conditions. However, if you don't know if the species is present, it's useful to know if they're there or not, so you can actually consider and mitigate against all the effects, such as to maintain flyways and to take lighting into consideration and things like that. So that's why it's useful to know if things are there or not. And I felt the same really with the lizards, or the reptiles. It's good to know which threatened species are there. You can redo those surveys later on, but it's really useful to know what species are there, so you can really look at what are the effects, and therefore look at ways that you can remedy those effects, or even determine if this is a really threatened species, and like if there's some big issues why certain activity shouldn't occur. So, but I will also add that there were some really good surveys, and that there was also some really good ecological work in there. So this is, it wasn't me just picking on the negatives. There was also some really good work. However, when I did review things, there were a few other points which I thought could be improved. Like there was attention paid to the removal of the farm dam, and that's habitat for the long-finned eel, which is an at-risk declining species. And I don't think that was also sufficiently considered, because that proportion of habitat was not sufficiently replaced, from what I could see. I also considered that there is likely to be effect of noise on bird species, and though that was potentially suggested to be minor, I don't know if there has been enough research really looking at how minor those effects really are, and I haven't had access to that report, which was apparently done by the regional council, which apparently somehow showed that the species richness and the species number has increased, which was, I found, a surprising result. But unless I could see how they did that and why, it's a bit difficult to comment on that. But I would have expected the opposite, especially because birds do tend to respond to big loud noises by moving away. So, and then there's a lot of other stress impacts that you'd expect as well. And those can affect seed dispersal. And you might still have some of those birds around, but seed dispersal can be affected by the proportion of species that are present, or the proportion of a population that's present. So if you get a drop of proportion by by a certain proportion, then seed dispersal isn't necessarily linear. It can be a curve, and then you can have quite a big impact on seed dispersal. And so I've worked on that sort of thing with fruit bats and other species previously, looking at how that can have an impact. So I suppose it was more, especially if they're considering using being reliant on bird seed dispersal as a propagation method, that does suggest that might have effects there, as well as, of course, having effects on habitat use by the species. I suppose one of the other things that I was considering and was the restoration and offsetting that was proposed. There's these kind of models showing that you've had a positive effect, but I suppose you have to really consider what you're doing on the ground, and then also considering, are you doing actual habitat restoration, or is what you're doing on the ground more akin to landscape gardening, which is something as an ecologist I have seen occur as well. So as a mitigation, when mitigation is occurring. So what you're trying to achieve is a self-sustaining, stable, functioning forest, which will then result in long-term benefits. But if you're just plonking in a few things which then die a few years later, then I would call that more short-term landscape gardening. And it looks good in the short term, but then it doesn't have those positive ecological effects in the long term. And really, to achieve positive ecological restoration projects, we need to think of things in a long term, because these things are quite slow, and we've got our native fauna and flora already dealing with pest species infiltration. So when you've got a small area, you've got also the edge effects, which are concerning, and those edge effects will be coming in from farmland as well. So to achieve true forest restoration, you really have to think of the length of time for restoration and look at best practice. And there's been some great research by Bruce Clarkson about where they've looked at achieving that stability of restoration and how long it takes, and then different ways that you can achieve that. The biggest one, of course, is that you need to get canopy closure, and one way you do that is you plant densely, and then after a certain amount of time that canopy will open up again, and that's when you have to go in there and fill in those holes with with other species, and that depending on what habitat you're doing, but that can be 10 years later that you're doing that with another with the next succession of species. And then I suppose the other concern I have, and I point out at this point that I'm not a sediment expert, that's not my expertise, but I have dealt with, I suppose, or looked at the impacts both in the marine environment and also in the freshwater, and I am concerned by sediment discharge effects and the fact that these are cumulative. I've worked on wind farms previously, and I suppose it's a little bit akin to that, where we quite often think of these resource management as these activities in silos, but in reality, what's happening is that we've got to our environment is multiple cuts occurring at the same time, and so that has to really be considered, even though it's quite tricky. And so with wind farms, it's occurring because we only think of the one set of wind farms over here, but then you have another one over there, and then you have those cumulative effects. So it's the same thing with sedimentation. And this proposed activity will contribute to that. And I am concerned about that, particularly given the increase in extreme climatic events with climate change, which is an area which I've worked in doing research previously, is in climate change effects. So yeah, so I suppose that's one of the big ones, and yeah, I suppose climate change is the big one for us all, but yeah, those are, I suppose, the key concerns that I've brought up. There's more small ones, but like those are I think the big ones. Yeah, is there any questions?
I'm sure there are. I'm going to start with Commissioner Burge in terms of her portfolio.
Thank you. So I just want to, you brought up first the reptiles, bats, birds, the three key features there. So you're aware that, so overall you felt like there was a lack of data for those. And first of all, I just wanted to know if you'd been listening into Dr. His name's gone from me, Dr. Moolings the other day. Whether you heard
No, I
missed
missed it. Sorry, I've been a bit sick.
Yeah, no, that's okay. There is a lizard management plan as part of the process, and obviously monitoring and management regime surrounding that. The other thing I just wanted to bring up was the bats. Both Dr. Mackay and Dr. Bruling, they both thought that there was enough information readily available today to show that there weren't bats within the area. You sort of still maintain that there's a possibility that there could be. So you, from what I hear from you, you feel it's important to still run what was it, ABMs?
Yeah, it's quite a simple survey. You just put out these recorders. It has to be within the summer period, like from October, and you just put these recorders out, and then they record whether the bats are present or not. It's quite easy, and it doesn't even take it's a certain number of days that you put the things out. So it's not that hard to do, but given the threat status of the species, I think it's quite important to do that. They have been popping up in some surprising places, and it's otherwise trusting whether the other people who've done the surveys have done them in the right places, if they've and just because they don't occur in one place quite close by doesn't mean that they don't occur in another place. And yeah, I think there's even been a news article of them popping up. They've done quite a few surveys in the West Coast and got a whole lot more recently as well. Mm-hmm. So yeah, I just think given the rarity of that species, it's important and it's quite simple to do. So that would just reduce the chances of having that effect.
Thank you.
You're going to carry on there?
Did you want to say something? Yeah.
What?
No. Yeah.
No. Dr. Sternman, it's David McMahon again. I just wanted to take that line of questioning a little bit further, if that's okay, in relation to the presence or otherwise of bats. You say it's a fairly simple process. So if there was a pre-construction or pre-commencement condition requiring that's the use of, is it AVMs, is it? Yeah.
Yeah.
As a technique, would that go some way to satisfying your concerns?
Yeah, I suppose the only issue is if you don't do the survey before, then because they are affected by things like light, for instance. So previously, when I've been involved with projects where there are bats, then you have to do a lighting plan, and then you have to figure out where their flyways are, and then figure out that you're not affecting those because they're protected. And then it's more that in some ways it's just easier. Figure out if they're there, and if they are, then you follow down that path. But
yes,
it just simplifies things.
It's like you. I've been involved in some wind farm hearings, and I've seen pre-construction, pre-commencement conditions requiring these sort of surveys to occur a minimum of X months before construction commences. So I'm familiar with the construction of the condition. The question then is, well, I guess if there's no detection, is that the end of the matter? Is it as simple as that?
I think if there's no detection and they've put out enough recorders and they've done a good survey, which
Yes.
then there should be no bats. Like these recorders are quite good at picking the things up. So if they've put out enough, and then you don't need the consent conditions for the species because
Yeah.
you've used a survey method which is quite accurate.
Sure.
Um,
And did I hear you
yeah.
say that there's a particular time? Was it the summer months where that should occur?
Yeah. October until November. No, April. October to April.
Thank you.
I think that's right months.
Yeah.
It's basically until things hit are less than 10 degrees. But then you also have to have it occur like not in rainy conditions and like they like good weather basically.
Yes.
Good summery month.
And what would be a reasonable period for that? Those detectors to operate? Is it for that full period or is it?
No,
sample?
2 weeks of good weather. So yeah, there's a I think Doc has a good survey list with all the conditions, but yeah, it's a 2-week survey, so it's quite easy to do in summer.
Yes. Now, if there is detection, I guess that's the so what question. What then needs to happen? What would your advice be?
Then you need to figure out which areas they're using and make sure that their flyways are maintained, and that I suppose if you're removing habitat, then you need felling plans, and you need it just becomes much more complicated. You need to consider light conditions as well.
Yes.
Yeah. So with developments which I've been involved with, where there's bats been present, they even affect how you put your street lights in and everything. So.
Yes. Is there a direct comparison between wind farm activity and quarry activity in terms of the potential threat to bats? And I understand that with the wind farms, there's an issue with low frequency noise and how that affects the navigation of bats and their navigation and sensory perception. I mean, I'm getting out of my field of expertise, obviously, but is that is that an issue that you've encountered?
Yeah, so with wind farms, it's also the fact that they get chopped up, which
Yes.
I suppose is
Well,
less of
I
a
didn't want to
threat,
mention
yeah.
that. Yeah.
So and they get attracted towards the lights on the
Yes.
rotors.
Yes.
But so that won't be, that's luckily not an effect. But I suppose you have to also consider truck lighting and and going through flyways. And is there a lighting management plan for the quarry? I don't think I've seen one.
Can't recall having seen one. No, it could. Well, it's not for me to answer, but it may well form part of the quarry management plan, as opposed to being a section in the management plan as opposed to its own.
Yeah, so I suppose then you consider bat-friendly lighting and things like that. But that's also only an issue if it's being lit up at night rather than, I suppose, yeah. So it depends on night activity and stuff like that.
Yes. So what I'm trying to ascertain is what would be if there was detection, and what would be the sort of effects that would need to be avoided, and what type of activities in the quarry would that relate to?
So you'd have to avoid maternity roosts in particular, so where they're breeding. Okay. So and wherever those are, that would be more of a a concern,
yes.
Or quite a big concern. You have to have, if you're tree felling, then you have to take that into account so that you don't cause mortality. And then I suppose there's habitat loss and flyway loss as well would be the other ones.
Okay.
And then lighting. I think that's the main ones.
Yes.
Oh, yeah, and then habitat loss.
Yeah, and the flyway loss, is that related to noise and light?
Yeah, noise and light, or potentially avoidance as well. But noise and light would be the big ones.
Yes. And don't take anything from this question, Dr. Sturman, have you visited the site and locality?
Yeah.
Yeah.
Yes, I have.
And did you manage to get onto the site, or did you view the site from outside the property boundary.
From outside the property boundary.
Yes. Okay. And have you done any bat detection work yourself in the Wellington Porirua area? Have you been involved?
Yeah.
Yes. Well, I guess what I'm getting at is what's your gut feeling on the likelihood of detection in this instance?
It's possible because there is big vegetation, and I don't write them off from being in areas where there's also farmland, because they also cross farmland quite a lot. There is a reduced probability of them being there because there's been not a lot of sightings like in the local area, but again, it's only within the recent years that we've even had a method to really be able to detect them. So it depends on survey effort and things like that.
Sure.
So I'd still recommend it given the threat status and the fact that they've suddenly been discovering them in a whole lot of places where they didn't expect them to be. So now I'm much more cautious
Yes.
with saying where they're not.
Thank you. I interrupted Commissioner Burge on that, so sorry, Liz.
That's fine. I just was also interested in the area that is to be restored for restoration, the Pig Gully area. You've had quite a lot of comments on that. We had quite a discussion the other day with Dr. Mooling, and the reliance that he has on gorse to provide if you like, a nursery for the establishment of other plants that would be, which would be, I guess, reliance on birds for dispersal of seed in that area due to the steepness and that sort of thing. I just wondered what are your thoughts on the reliance of gorse to provide a nursery for areas that are being restored?
I think it's risky that it will spread into other areas, and I'd be surprised if the farm manager would like it. But from that side of things, it's also, I found it's quite prickly to work around for the poor people who are having to do work around that area. But you can use it as a nursery plant. It depends apparently a little bit on the dryness of the area and exposure and things like that, how successfully it works. One option is to kill the gorse, and you've still got it there as a structure, but not in a live structure.
Okay.
I'd probably look into other methods. It's probably not.
Sure, and that probably leads on to the. You sort of made the comment of the restoration / landscape gardening sort of scenario. A strong theme that's come through in your evidence is, the mid-successional stage and, monitoring to occur throughout the life of the consent rather than this magic 10-year sort of phase. I just wondered if you could discuss your reasoning behind that.
I'm not too sure where the 10-year phase has come from in terms of research, because there's a really good paper which I could send or pass over, which is by, I know Bruce Clarkson is one of the people on it, and it looks at what period you get those changes in for instance, canopy and things like that. And there's these points where things shift, and but you can see that it definitely takes, it's definitely more than 10 years before you start to get enough canopy closure, even for a really densely planted area, to really be able to start for the ecosystem to start to maintain itself and need less human intervention.
The applicant, sorry to interrupt for a second, but the applicant has suggested a 10% cover at 10 years. Greater Wellington have indicated, or actually, sorry, it might have been PCC, have indicated a 50% cover is more appropriate. Have you got comment on those sorts of figures?
Yeah, it definitely has to be on the higher end, because otherwise you're going to be there for ever so long. Like, it just takes so long to do restoration if things don't get dense, and that's what you're really aiming for in that best case scenario, is for canopy to close over as soon as possible to like get those weeds out. And in New Zealand, we're really lucky with the way our forest is structured, that those forests can maintain the weeds out, for the most part. It will push them out if you can get that canopy cover, which isn't the case in a lot of places overseas. So that's a real big aim, is to get the canopy to close over, and then you can push out the weeds, and people can step back further and further as you get that, like, especially once you reach 80%. So yeah. If it's too open, it's going to just be continuous management, and it's going to be basically a pain. So yeah, that's what you really want to achieve. But I just don't know if it's possible to achieve it at 10 years. That's, I suppose, what my comment would be. So I'd have it go longer, so that they can actually achieve what they're trying to achieve, and then you're actually getting that gain in biodiversity, which, like that net gain, which sounds like the applicant is aiming for.
I think what they're saying is net gain will happen at 10 years.
Sorry.
One second, sorry.
Oh, no, I was just going to update. Ash actually got a letter, I think, just before lunch or at lunch, I don't know, the days are all merging into one. Anyway, so Dr. Mulling has been in discussion with Dr. Mackay, and there's agreement not to use gorse and 50% canopy.
Thank
50.
you. I know that was discussed the other day. I don't know if the
it's been
agreement had been
formally
reached.
conferred. So there's a letter from both of them, I think, to the panel. So I just wanted to thought that might help.
That's helpful. Yeah. Yeah. Sorry, did you hear that? So it was a sidebar conversation there to say that Mr. Mackay and Dr. Mulling have had discussions, and the gorse is off the table, and the 50% cover is what they've agreed upon. So that you would have some comfort in those sorts of results.
Yeah. I think that's a much better aim,
much better outcome.
And yeah.
If that's the case, so if that's at a 10-year, target, if you like, would you still think that beyond the 10 years, what sort of monitoring of success should occur?
I think
beyond the 10 years. Sorry, just imagine if the consent was
they
25
monitor
years, for
15?
example.
Well, if you want to ensure that what you're actually resulting in a real net gain, and I'm not talking just about a modelling net gain, which is a different thing.
Yeah.
But if you're talking about an on-the-ground thing, which is going to be there long-term to replace, what has been lost, then you want that canopy closure, and then you want that people monitoring it and ensuring that happens. So I would have it for the length of the consent, or like at least 15 years. Like you want to have a good length of time to actually ensure you have those outcomes, and then there'll be then it can actually be said that there's a net gain in the vegetation, rather than removal, and then, like I said, landscape gardening, which is the alternative risk.
Mm-hmm. Sure, thank you. I think that's all I had at the moment. Thank you.
Yes, Dr. Sturman, in paragraph 24 of your summary, you talked about, given the sensitivity of the receiving environment of the Pawanatui Inlet and significant ecological values involved, a measurable compliance limit for the site and appropriate safeguards must be in place. Have you had a chance to look at the draft conditions, looking at sediment and water quality? They're quite detailed, and have you had a chance to look at them? So in them at the moment, in the Regional Council consent conditions, I don't expect you to go to it now, but they've got provision of an adaptive monitoring plan, which essentially talks about doing monitoring of turbidity, and then based on those results, then having a review, remedial actions as required, and also an annual reporting that provides details on how the level of effect to the receiving environment will be quantified and reported annually. This is a requirement. So I hear what you're saying. It's hard to have some sort of quantum limit on sediment because it's very hard to measure, the actual sediment going off the site. But it seems to me that this adaptive management plan with monitoring and then steps and review probably goes a long way to what you're thinking is needed.
Yeah, I have to admit, I read the what's it called, the expert caucusing from the sediment people about auto sampling, and having been involved in a bit of that, I did think that it was, in my perspective, I did think that having an auto monitoring sample, continuously taking sediment sampling during high-risk stages and periods was actually quite a good idea, partially because otherwise there's like it could be a 12-hour gap between someone going out there to physically do it, and then you can miss that point, but also that ensures that it's happening in the time that it needs to occur. So then you can actually have that monitoring, and it could then trigger what is needed quicker than if you then had someone go out at 12 hours later and things
Well, that's
like
what
that.
they're now proposing, I think. Yeah.
So I did think that was an improvement.
Yeah. Okay. So do you think that's going to be sufficient to meet your point about in your 24? Measurable compliance limit. It's not really a limit. It's more a process to say, how's it behaving? How much sediment's coming off? If there's too much, then you look back at your devices and your systems, and then you have a yearly review about that as well, with an ecologist looking at any sedimentation downstream and that sort of thing.
I suppose the only problem would be if there was like really large, if there was suddenly a large effect because of, large rainfall and, and then you have, more damage than they're anticipating. And then how do you offset or remedy any that larger effect? And would there be funding, for instance, to put in, say, an additional wetland if it's needed? Or so I suppose it's more those sorts of considerations did come to mind of what if if it wasn't enough and there was a bigger effect than they anticipated. And like I said, with climate change, some of these things are not as they're more of a surprise, and they're happening more often than we anticipate them happening previously.
Yeah. Okay. Thank you. It's clear.
Dr. Sterneman, but you're back with David McMahon. Just a couple of minor questions to wrap this up. In fact, just one question. There's a dispute at the moment between the applicant and the regional council about should these consents be granted, what duration should be applied, and that dispute applies to the Greater Wellington application. So they are the discharges and the water takes, those sort of things, as opposed to the land use consent for Porirua City, which I'm not sure if you're aware, land use consents usually run in perpetuity. They're associated with the land as opposed to the applicant, but in this case, the applicant has applied for a fixed term consent of 35 years to the Porirua, and they've applied for 35 years to Greater Wellington. The recommendation, as I understand it, from Greater Wellington is that the consents be approved for a period of 10 years.
Correct.
Yes. Yeah. Which is a different recommendation from Porirua, which it's not so much about the duration, it's about whether the consent shall be approved or not. And I'm just referring to the officer's report as circulated prior to the 2 or 3 weeks prior to the hearing. That position may well have changed during the course of this hearing. And we're yet to hear from Ms Williams on that, but that's just context to the question I'm going to put to you. And that is, from an ecological perspective, terrestrial and aquatic, do you have any particular preference or strong feelings about how the nature of effects are affected by the duration of the operation? And just in terms of context, what I might add is that the applicant has indicated that they would like to see a longer term consent of 35 years not only because of the investment involved, but also because of the ability to get more fulsome ecological betterment than might be associated with a 10-year period. And I was very interested in the conversation that you were having with my colleagues on the panel about that betterment and the time involved and the monitoring involved. And I just wondered whether you might have some thoughts on the duration of the consent in that respect.
I suppose you've got the ecological benefit of potentially having longer input into restoration, but then you also have the risk of changes in policy, and like what we've seen with wetlands occurring, with greater protections occurring, which would then not, well, I don't know how it would work. If, for instance, you had higher protections on the inlet, for instance, or on waterways, if you had those sorts of, if you had a longer condition, or the consent conditions were going for that long. So I suppose those are things that would concern me. And like I said, particularly with climate change coming up and increasingly going to be a thing that we're going to be looking at. So I suppose it's more, how will this consent be influenced, or how will it affect the area by being so long, if you see what I mean. And though they can have positive impacts by having, I suppose, a longer time to do restoration, that does concern me because, I think the impacts of climate change, having done research in that area, we're going to be seeing more and more and more, and it's going to be speeding up. And and because of that, it does alarm me a little bit to see consent conditions which are having to look at what's happened previously in the short term with, I don't know, water and things. But yeah.
Appreciate that answer, and that's useful. If you can just bear with me, putting aside some policy construct changes aside, such as changes in freshwater management regimes and that sort of thing, on a purely effects basis, and in this case, in your area of expertise, ecological effects, terrestrial and aquatic, is there a strong reason for having a shorter term duration consent as opposed to a more medium to long term consent duration?
Depend what like I said, some of the things I don't think we know completely what the effects will be, and one of those is the effect of noise on the avifauna fauna in the area, and therefore seed dispersal and things like that. Long-term blasting effects in that way, I think, are really not understood. There's been a lot more research on say effects of noise on dolphins and whales and things like that, but so I suppose in that way it could have a negative effect, but then potentially a positive effect by having people do restoration manually. So it is a bit hard to say in that way.
Yes, so I'm taking from your answers that it's a careful matter that needs to be considered. Yes. Would knowing that there is some proposed review conditions in place in relation to things like noise and vibration and ecological restoration and rehabilitation, and also sedimentation matters, that those management plans governing those effects, would knowing that that there are reviews in place, that they can be yearly, change your view in any way?
What would be the outcome of the review? Like, is there the potential for activity to completely cease, or would it be just a review to cause small alterations of the current activities to reduce effects?
The normal procedure is I ask the questions,
Sorry.
but that's a good question, though. Condition number 100 of the, I think it's the hearing condition set, and it may well be I'm not sure which one it is, Porirua for the long term, says that these reviews may occur after the first year of the consent, for the duration of the consent, and and it's quite a long condition, Dr. Sturman, to review the effectiveness of the condition of the consent and avoiding, remedying and mitigating any adverse effects, and to avoid, remedy or mitigate by way of further or amended conditions. To review the adverse effects that have arisen as a result of the exercise of the consent that were not anticipated at the time that the consent was granted. To review the adequacy of any plan or monitoring requirements, so it's any management plan or monitoring, and if necessary, amend those requirements. To require the consent holder to, where necessary and appropriate, to adopt the BPO, the best practical option to avoid remedy, and that's to take account of any technological advances, and then to take account of any changes of relevant district plans or policies. The council would undertake the review in consultation with the consent holder. On the surface of it, it's not clear to me whether that would allow the consent that's granted for a period longer than 10 years to cease, and we'll have to hear from the applicant on that, but at the very least it would allow alteration to the condition and management framework and the monitoring conditions, and the application of any other best practical options associated with the activity. So that's my answer to your question. So I'm going to come back to my question to you, is knowing that condition exists, and given that there might be some uncertainty. Look, let's just go to Mr. Matheson on that. Mr. Matheson, you had any experience in these review conditions? Are they tailored solely at the conditions of consent, or are they tailored at the exercise of the consent per se?
No, I mean, the law on that's quite clear. You can't do a review to cancel a consent.
Okay.
So, but in circumstances, the question is what's cancellation? I mean, there could be any number of conditions you could impose, as long as the degree of conditions doesn't get to the stage where, in a practical sense, like if you said 1 truckload per day and hours of operation of 1 hour per day, I mean, technically that's a condition, but that would frustrate the consent.
Yes.
But with, leaving that extreme example aside, all of the other conditions are fair game.
Yes. So the answer is that cancellation of the consent per se is not really an option. It can be achieved through contrived conditions that would frustrate the consent, but generally the aim is to make sure that the conditions in the regime are still fit for purpose for avoiding, remedying and mitigating, and in this case offsetting and compensating. So the question that I have to you is, if on that basis, would you take more comfort of it in terms of a longer consent period than you've sort of indicated in your previous answer?
Maybe slight more comfort,
Yes.
but I would still question like what would really happen in reality.
Yes.
On the ground, and if things, I don't know, if things were not occurring, which would, like, if there were negative effects, quite large negative effects, but it sounds good.
Yes. Can I just understand?
Answers your question.
Can I just understand from Mr. Matheson? Is this a proffered condition, or is this a condition, Ms. Williams, that you've suggested?
There was a proffered review condition. It's perhaps a bit more filled out than what was originally proffered,
Yes.
but there's agreement between the parties in terms of the status of it currently.
And can I add to that Section 128 conditions are standard conditions on any resource consent?
Yes, they are. But yes, I mean, all of those answers are correct, Dr. Sturman. Obviously, there was a proffered condition. It's been added to. You don't need, as I understand it, you don't need a standard, you don't need a 128 condition, but in this case, to conduct a review, because Section 128 allows you to do that. But in this case, it's helpfully indicated what the nature of the view might be in terms of items A, B, C, D, and E. And they range from the effectiveness of the conditions of consent right down to taking account of any changes to district plans or policies and everything in between.
It sounds good. So I just have to hope it would work. Then.
Yes, I don't think I can take that any further, and I think I'll leave the questioning at that point. Thank you for your attendance. In a similar manner, I understand you've been in the unwell stakes too, like Dr. Kirkia. So, did just one final matter, and I might just, I'll take it up with Professor Irons, but it's about your ability to have partaken in any of the expert conferencing, and I think on the basis of your unwellness, you weren't able to do that. Is that right? Yes.
Yeah.
And one of the alternative
I did read it though.
Yes. We may provide the opportunity for you to comment on the relevant ones in terms of what your position might have been had you been an attendee, but we're just keeping that open at the moment in terms of correct procedure.
Could I clarify that she did indeed send me a comment, but it was in one of the 100 emails I haven't cleared, but I just saw it. And she said she's agreed with Mr. McLean that continuous monitoring in the high-risk area and stages of auto-sampling would ensure accurate information is collected during the period. So she's read that joint witness statement and agreed with
That's good. We just need to see that in front of us.
Exactly. I was going to forward it to Ash, but I have just one of the ones that I hadn't noticed.
Yes. Is that the only matter? Oh, well, not the only matter.
Yes,
Yes.
I've got a very short paragraph that Rebecca, Dr. Sterneman sent me.
Okay. Yeah. Thank you. Thank you, Dr. Sterneman. You're welcome to listen in for the rest of things, but I suspect you want to get some rest.
Commissioners, if I may provide 2 points of clarification. The first was in response to a line of questioning from Commissioner Mark Brown about turbidity monitors on individual devices. And I believe you said that the applicant has confirmed that they are doing these monitors. Okay, just at the mixing zone?
I didn't mean they're doing continuous turbidity on everyone, but I understand they're doing one continuous turbidity at the bottom of the...
Yes, correct.
Yeah,
okay, that's cool.
Yeah.
The second matter was just about the canopy cover on the Greater Wellington condition number 62. We have the standard that the consent holder shall undertake and maintain biodiversity offset planting to achieve the following standards at this 10-year success mark, and that was for the 80% canopy cover of planted species, not 50. If there's a difference between the Greater Wellington and PCC consents, I think this needs to be married up to have the same percentage of canopy cover.
Yes. Thank you for drawing our attention to both those matters, Ms. Walker. Ms. Matheson?
Oh, no, we can, that probably should be discussed. That was a deliberate distinction between riparian and terrestrial planting.
Okay.
But we'll leave that with Dr. Mulling and the...
Yes.
And just as a quick matter of clarification, condition 85 of the Porirua City Council also has the same 80% in the same fashion, so
Okay.
it's slightly different.
So apples and apples, we need to be dealing with apples
As I'm
with
aware,
apples.
there should be some apples and apples there.
Bram's hands up on the screen.
Oh, Dr. Mulling, come on in.
Good afternoon. Can you guys hear me?
I can. Yes, we can.
Yep. Yeah, no, quick clarification on that. I think the 80% is indeed adapted for everything that's manually planted. I think the 50% is on the section that we're letting regrowth in that regard. So there's that distinction between the coverage.
Yep. Okay, thank you for that. Making some progress. Okay. Professor Irons, Do we need a cup of tea?
Sure, well, I'm in your hands. I mean,
Yes.
we,
Let's just take an inventory. So we've got your own submissions. We've got Jenny, and we've got Tracy, and Tracy as a JEPS member, but also Tracy and Lyle Davis in their own personal capacity. Jennifer Blake in her capacity also. And yes, we've got then a number of other submitters. I think the only one that we're not hearing from is Brett Hall. So can I just get an indication of who's in the room? Is Shamel Quarry and Mika Quarry present? Welcome. Cheryl Anderson. Esther Harrop and Stephen Smith. No. And Nadine and Lee Stephens. Oh, of course, yes, thank you for your memorandum. Oh, it was a memorandum from Stephen, I think. Thank you.
Could we maybe get Shamal and Micah to go first, because they've been waiting for quite a while?
Yeah. 30 minutes. Jamal and Micah, would you be upset if we took a brief afternoon tea adjournment for 10 minutes and then came back to you? That's fine. And is that okay with you, Professor Hines?
perfectly fine.
Yes. It's unlikely we're going to get through everyone today. So what I would suggest is you battle it out in the afternoon tea adjournment and work out what the most appropriate batting order is. It means that there might be a delay tomorrow to the commencement of the Greater Wellington presentation. It's due to commence at 1 o'clock, I think. But I think it's important that we hear all the submitters before we proceed to the council officers, even though we haven't quite managed that with the applicant, with their one planning witness. So let's come back just after 25 to, and hopefully there's some agreement on who's going first, opening the batting. Right. Working backwards, we are going to finish at 5:30 for two reasons. One, we're all tired, and secondly, I guess it's been a long day for a lot of people. Now, that will mean, out of necessity, we're not going to get through all the submitters today, so we'll have to reschedule for 1 o'clock tomorrow. So hopefully there's been some discussion in the interval as to how that might work through. Good.
Do you want to know that now?
Yes, that would be.
Okay, so we're going to run through the submitters who basically to take time off work and stuff to come.
Thank you.
And we'll move me till tomorrow. And if we need to move the Jono representing the Stephens, he can come tomorrow as well.
Thank you.
So we'll see. But so basically all the other people will go first.
Very
and then
sensible.
we'll see where we go.
Appreciate that.
Sorry, question. Can we sit till 6? Like, can we sit a bit later tomorrow night? Is that possible?
Tomorrow night, yes, we could, yes. But the panel is just not in a position to sit beyond 5:30 tonight.
No, that's absolutely fine. I understand. I just thought if we needed to let the council know, or parties know, it might be useful that if everyone knows now or what the plan is.
That's fine. And the other thing that everyone needs to know now is that we need to vacate the chambers tonight. There is some ability to store material overnight, so Ash will be organising that, but I can tell you that the panel will be taking priority over that storage, so we've got first dibs. So yes, we'll want to finish around 5:30 and then start packing up. But yes, Mr. Matheson, every reason why we could go to 6 tomorrow. That's the administrative, that's the clerical component. During the lunch, during the afternoon tea adjournment, the panel had a discussion about one aspect of Mr. Kurkur's evidence, and it was around his theme of validation, and particularly how that might affect monitoring and monitors. And we would encourage the receipt of a proposed condition framework, even if on a without prejudice basis, as to how that might fit it in with the current condition framework in terms of either a line item in the dust management plan or its own bespoke condition, or a combination of both, as has been a case with a couple of other the issues that Mr. Baker's referred to. I guess in terms of the verbal right of reply, we'd like to hear the applicant's position on that and the position of Greater Wellington and Porirua on that, and if there's the ability to conference and with a small c on that in the intervening time period, that would be useful. But at the very least, as a drafting assistance, if you don't agree with it.
Can just to be clear, so Mr. Kurku covered quite a lot.
Yes.
So when are you talking about a TSP particulate monitor, or what? Because I mean there are some issues around that, but which will be well known in the rural environment. But is that what you're thinking, or what were you thinking?
I think a variety of techniques. I guess what I'm seeing would be useful to have is something that can pick up the accumulated dust, and then Mr. Kiakia's point of perhaps checking for silica, RCS, and then where it's coming from.
Right, so it's not a okay, because that's different from like an ambient dust monitor. So it's directed more towards silica rather than dust, because obviously removing the overburden rounds, moving around the top of the soil. That's
how I see it.
Yes, okay. I guess it's potentially in two parts, and I'll come to you, Commissioner Burge, in a moment. It could be purely to demonstrate compliance with the permitted activity rule at the boundary. But I suspect it's more than that, because then that's the noxious and objectionable at the boundary. But what Commissioner Mark Brown's suggesting is that it might be appropriate if it goes further to indicate the presence or otherwise of silica at the closest dwelling to the quarry face.
Okay, that's helpful.
Yeah, sorry, Commissioner Bird, sorry.
I guess, we're not experts in this field, so probably what we're saying is if we can get the experts to look at that issue and how best to address it by way of a condition, something in the plan, in the quarry management plan, how best to address it, how best to validate whether it is an issue or not. And obviously that would be linked to your meteorological data as well. So yeah, we don't know how to package that. We're asking the experts to look at that and look at how to package it.
Well, that's excellent. Sounds like Mr. Noonan's got some homework, which is perfect. Somebody else. Okay, we'll let him know.
Thank you.
Thank you.
Well, hopefully he's listening in, but anyway, if he isn't. Okay, thank you. Okay, so I'd firstly now like to welcome Shamal and Mika Quarry. Welcome to you. You've been diligently sitting in this morning and this afternoon. We're in your hands. I understand you have a written presentation that you'll speak to, and you'll provide us with copies of that, or provide Ash with copies of that. And you have a PowerPoint presentation also. So let's kick on.
Of course. Sorry, I'm new to the process. Good afternoon, everyone. My name is Mika Quarry, and with me is my husband, Shamal Quarry. We are the owners of the property at 328 Murphy's Road, so that's the last property on the road. We are here today because basically we wanted to be heard. Before we start our presentation, we want to stress that we are with JEPS, and we agree with and support everything that JEPS has raised, including expert data and all submissions. But what we want to talk about today, specifically at this moment, is our lived experience, the impact of the quarry on our property, our mental health and well-being, and what our family is seeking. We want to reiterate our main concerns. And these are complete negligence from Porirua City Council, and that's associated with non-disclosure of the quarry, impact of blasting, vibration on our property, mental health and well-being, absence of monitoring despite being the closest dwelling from the quarry. Now, I want to clarify that one because with Rob and Lauren as 327 at that time, when the quarry was operating, we were the property that had people inside. So Rob and Lauren would have acquired their property at that time, but they were not living in their property. The second is impact of exposure to dust, particularly on our son's health, and dust buildup contaminants on our roofs, which is our source of our drinking water. Loss of enjoyment and lifestyle affected, inability to use our land and property and enjoy its potential. Traffic, we've been having difficulty going in and out of Murphy's Road, and this has an impact on driver safety. Lack of monitoring, compliance and enforcement, and general lack of accountability. Now, we will talk about those points as we go along with the presentation, but just as a background and context, we purchased the land on 328 Murphy's Road in July 2017, settled in September 2017. At no point at that time, Willowbank has disclosed any information about the quarry before or after the purchase of the property. We got an approved resource consent and building consent in April 2018. Earthworks on our property started in May 2018 because we were starting building. By October of 2018, the house is fully closed in. A month after that, in November 2018, resource consent was granted by Porirua City Council to Willowbank Trustee Limited to recommission and operate the quarry located at Willowbank Farm. Now, earlier today, we've learned that the application was received by PCC in August 2018. We moved into the property in May 2019. Now, at no point in time from the time we purchased the property up to the consent was raised, and even until such time that we have lived in the property, we have no idea about the quarry. We started noticing trucks, machineries, diggers building the overburden bund, and eventually found out about the quarry after talking to neighbors and asking them about the noise. We then later found out that we weren't considered as one of the affected parties or signatories with the original consent, even though our house is the closest dwelling from the quarry, and Porirua City Council would have had that knowledge and information about our building consent and resource consent. Rob and Lauren at 327 were building their shed, and we were not living on our property at that time. Our house was not mentioned at all, like we don't exist. This has prejudiced our ability to partake in the process. We absolutely have no knowledge of the quarry whatsoever. We were completely in the dark. We made several attempts to contact Porirua City Council to raise our concerns, including Derek Voss. We contacted Derek Voss in an email on September 2020. We spoke to Derek Voss over the phone, and he advised that the quarry is to support the transmission gully, which will cease operating at the end of 2020. We requested him to send us an email with a summary of what we discussed over the phone, but we never received any correspondence from Derek since the phone call. This then prompted us to contact Paul Nation, as he may be able to help us. Paul provided us the information on who to contact, so we can be added to the list of email recipients for blasting notifications after we expressed that the blasting vibrations felt like earthquakes. Throughout this period, no one from PCC came to our property to check or speak to us or hear what we have to say until May this year, when Karen Williams came with John Stiles with very short notice. We were unable to meet with Karen and John as we were out of Wellington at that time. We requested if we can reschedule, but they responded that they cannot. This visit was the first and only visit made to our property from PCC or anyone associated or working with PCC in this matter, as far as we know. This was following Shamal's phone call to Karen asking her to explain how she missed our property when we had it closed in-house before the quarry was approved. We believe there was a complete disregard by PCC in notifying us and complete negligence in looking after their rate payers. At that time, whilst the quarry was operating, we lived in those circumstances that we were in, and we didn't make a big fuss because we knew it was only temporary, and we were in support of the completion of Transmission Gully. We bought this property because we want to live in a peaceful and quiet lifestyle and rural setting to start a family. As advised by our lawyers and stipulated in the covenant, we cannot carry on industrial or commercial undertakings other than rural activities. This is the view from our house, the rolling green hills of the Pawatahanui Inlet, and the sea. This is our son, Emmanuel. He will be 2 years old next month. He loves the outdoors and has been exposed to the outdoors since he was a baby. This is our lifestyle, being outdoors. As much as we can, we walk around the land, enjoy the scenery and the livestock we have. So behind Emmanuel there are 5 alpacas. On a nice day, we sit outside our deck, have our meal, and play with our son. At nighttime, we like to sit outside with a fire and enjoy the stars in the night sky. For you, this might be a little thing, but for me, who grew up in Hong Kong, in a concrete jungle, mass transportation, densely populated, and city lights, living here is a dream come true. This is where I want to raise my son, and we want him to experience what we never did, a beautiful backyard and pure nature. How can you really say we live in a peaceful and quiet rural setting when there is dust nuisance, excessive noise from machinery, trucks, crushers, and blasting from quarry activity literally next door? This will severely impact our lifestyle and enjoyment of our property, and this is of no fault of ours. This is the screenshot of our land and the quarry from the website. It's one of the property websites. As you can see in the slide, our property is within close proximity to the quarry. Now, this is not on Google Maps. If you look at it on Google Maps, there's no quarry in there, so it's not updated. And this is the screenshot from the Google Maps. The only buffer between our property and the quarry are the line of pine trees and the Willowbank farm. And the pine trees behind Rob and Lauren's property, or their house at 327 side at the other side of the road. On the slide, you can see an X mark. This is a potential building platform. This area is more elevated than where the current house sits, so the view from that area is breathtaking. Our retirement plan is to build on that area. Due to its close proximity to the quarry with no buffer zone, if the quarry were to be approved, we are stuck with a property that is unusable for our needs. In the beginning of the quarry operation, we were never home during the day. However, after COVID lockdowns, we have been working from home almost every day. This is when we started hearing the noise from the machinery crusher and trucks, etc. This is a photo taken from where I would normally sit in the mornings and enjoy a cup of coffee when I'm working from home. The Willowbank pine tree circled there in red can be clearly seen from where I would be sitting. I was unable to sit there for too long as the noise became unbearable and very distracting. Since then, I would rather stay inside and get frustrated and annoyed by the noise. This is the photo of the bun and the hay bales or excess track taken from the deck outside our eastern bedroom. As you would notice, there are no trees or buffer between the bun excess and our property. This essentially means that excessive dust resulting from truck and quarry activity will reach our property. This is another photo showing you how close the pine trees are from our property. So that's the Willowbank pine trees, which I would, in my view, is just our only buffer zone. Our source of drinking water is rainwater through rainwater catchment through our roofs. We have found dust buildup or clay or soil, whatever it is, on our roof many times during quarry activity. We had to change our water tank's filter to a lower micron filters as we were very worried about what we're drinking. We also had to boil our drinking water. During summer of 2022, we had to stay indoors, close all our windows and sliding doors because we were getting too much dust inside the house. It got very hot and unbearable inside. This is an example of limiting our ability to enjoy our property. Most importantly, I am very concerned of the impact of dust on my son's health. My son has a respiratory problem. When he was born in September 2020, he had an infection in his lung due to inhaling meconium. We believe that this has impacted his respiratory system. The breathing problem started in February 2021, so he was about 4 or 5 months, and his respiratory was never the same since he contracted the RSV in the winter of 2021. He seems to be showing improvement now, but I'm concerned that the ongoing long-term exposure to dust could exacerbate his condition for all the reasons Stuart has raised earlier. This is the east wing of our house that has sustained most of the damages. The east wing is the one that's close to the road. This is a photo taken from one of the eastern bedroom, the one closest to the house at Rob and Lauren. It is an internal wall separating from the ceiling. The east wing of our house has most of the damages, and it's a bit unexpected to see a house that's built fairly new would sustain this much damage. Do you want to talk about the house?
So we built a house, it's a site-specific engineering design, and we had a PS1 and a PS4 from the engineer saying it's up to code or exceeds 300% to the code. So we built a house, we pretty much future-proofed our house. So we went German triple glazed windows, insulated panels, pretty much to a passive standard. But no one, when we built the house, we didn't plan for a quarry. We didn't plan for any blastings or anything like that. And we have up to 64 piles on our foundation, and the piles go over 2 meters deep. When they blast, I know the quarry is probably 10 meters below at the moment. So our piles actually go pretty much close to that blasting level. So there's a massive effect on our foundations with each blast. I don't know if I'm going to...
Yeah, so just in summary, so the house, to describe the house, it is made of steel, it's structurally sound, it exceeds the current building code. We have a geotech report and things like that. So it is just unexpected that a house this new, it was built in 2018, closed in 2019, would sustain this damage. This is another one from the eastern bathroom. Our house is a code of compliance, and we do not expect for a newly built house to sustain damages a few months after it was built. These are only examples of the damages to the property that we have taken photos of. There are many. We are also concerned of the impact of vibration has on our mental well-being, particularly on me. I have not experienced earthquakes before and have only experienced 3 earthquakes while living in Wellington. After COVID lockdown, I had to work from home most of the time. Albeit the notification about blasting, the effects of every blasting for me is I would go into a panic attack and heightened anxiety. It then led to anxiety attacks whilst in anticipation of the blasting. Stressful was an understatement. I have then decided not to be home within the blasting time frame. However, the time frame got wider and wider. They said it was for 2 hours and then became 4 hours, 3 hours, or 4 hours. And it meant that I had to be away from home for hours. Quarry blasting also increases risk of land instability. In the last few weeks where we've had rain, there had been slips around our property. In the last 4 years since we've had the property, we have never seen this much slips before. The left side is a photo of our sliding doors that we are unable to open and close with ease. As you can see, it is no longer leveled or straight because the gap at the top is wider than the bottom. These sliding doors are German UPV profiles and are triple glazed. They are structurally sound. The second photo is one of the Scotia moldings from the eastern bedroom. So that's the second bedroom in the eastern side. And you can see that the Scotia molding is separating from the ceiling. Another point that we want also to raise is that we have made attempts to look for structural engineer to assess our property. But we couldn't find one who would be willing to carry out commissioned work who does not work for or associated with either Fulton Hogan or Porirua City Council. Up to this day, we have not found a structural engineer who would confirm or assess that these damages were sustained from the blastings coming from the quarry activity. I also want to raise just a minor point about the traffic, because I think there's a lot of points raised about the traffic and expert data here and there. But I just want to raise that as a driver and as a resident of Murphy's Road, we've been having difficulty going in and out of Murphy's Road. I go in and out of Murphy's Road early in the morning or late in the afternoon when I pick up my son or drop him off from daycare or go to work and so on. And what I'm really scared of is turning from State Highway 58 to Murphy's Road, because cars are too slow or too fast. And I'm concerned that my son is on the left side of the vehicle. And if I turn right, he might get slammed this way. Or if I stay in the middle with no median or no turning bay, and then there's a car on coming out of Flytus Road, he might get the impact from the left side of the vehicle. And in closing, what we were basically want to stress is we were left alone on this. And all this time, we felt like we have to prove everything. So the damages, the impact on our health and well-being and so on are caused by the quarry or attributed to any activities from the quarry. This requires, and I hope you acknowledge that this requires financial resources. It requires expert advice. And at this point, it appears that our only option is a legal pathway. What we are seeking, there may be some recent updates on these matters. I'm talking about the conditions as the hearing goes, but our position has not changed. What we are seeking is to decline all 3 consents or put on hold to consider more information and conditions. And what I mean by that is, for example, following blasting, properties within sensitive areas should be checked for damages. And if damages are identified, there should be remedies offered. There shouldn't be self-monitoring, and this is emotionally exhausting. It's time-consuming and it's emotionally exhausting, and I cannot stress it enough. We have been running around like headless chicken, looking for experts, looking for people who can help us, raising our concerns to Porirua City Council, to people who could just basically help us. But at the end of the day, we are left alone. There should also be robust and effective complaints process where our complaints are heard and addressed and remedied, because at the moment, this is the hard part. Like, we've been trying to raise the complaints, but then no one responds to us, or, it just left neglected or unanswered. And also an example of that monitoring is the water tank should be checked for contaminants. As I raised earlier, our water source is rainwater. It goes into a water tank. If they could be checked for contaminants before and after operation of the quarry, I don't know when, I'm not an expert, but to establish a baseline, then that would be a positive thing. We also are seeking to fix all the damages to affected party. And this is for the purpose of establishing baseline. So if the quarry should be approved, we should be able to say that this is the state of our property at the moment, and if the quarry continues its activity, then we should be able to track and monitor any changes following quarry operation. Third is effective and timely monitoring of properties to establish baseline, which I've mentioned. But what I essentially mean by that is compliance and strict monitoring. We shouldn't be policing ourselves, and at the same time, we shouldn't be self-monitoring as well. If approved, the applicant should offer full compensation for those affected parties, and this would cover damages that our properties have sustained. And the fifth one is set up an independent fund to remedy damages and hear damage claims. So if I raise a complaint regarding damages, where do I go? Who pays for it? So that is something that needs to be considered. Currently, we're left with shouldering the cost of remedying the damages. I think, do you want to add more?
I think we should go slow, even fast. But do you have any questions for us? We're just gonna quickly.
We will, but possibly best to pose those at the end if there's more that you want to bring to our attention.
Yeah,
I think we have,
that's basically.
us,
I think
pretty
we've
much.
just summarized it.
We just want to add a little bit to each one, because, like, for example, when we bought the property here, as Mika mentioned, in July 2017, and when we go back through all the information that was there, you can see Willowbank, Quarry, and Porirua City Council have been talking since 2015 about opening the quarry, but there was no mention about it. There was no disclosure on a sale and purchase agreement, and even after we, had a resource consent and building consent approved, no one approached us from Porirua City Council about, hey, there's going to be a potential quarry. There was no mention of that. I think that's pure negligence.
Not even a visit.
Not even a visit.
That's what really aggrieved us, because we just basically left to ourselves.
I mean,
we didn't get any help. Not even a visit. Like, are you guys okay? Do you want to talk about something? Nothing.
If we knew there was going to be a quarry after we purchased the property, we would never build. We would never build that particular property. We would just probably own the property and graze it, and we'll go somewhere else. We would never build there. That's pretty much the hardest part. That if we knew, or someone, even Porirua City Council, I think that's their responsibility to tell us, hey, we're gonna give you a resource consent, a building consent, but there's going to be a potential to open up a quarry.
Yes. Mr. Quarry, there are some questions that arise from that, and I want to ask them, but I don't want you to be offended by me asking them, because you're putting a lot of emphasis, quite rightly, on communication, and I just want to get the facts right. So you purchased the property in July 2017.
Yes.
It was settled in September. Oh, the offer went in July, and settlement was...
Yeah, September.
Yes. I've got down that the building consent was approved in April 2018. You commenced earthworks in May 2020, and by October 2018, sorry, yeah, and by October 2018, the house was largely enclosed. So that's the factual time frame, isn't it?
Yes.
Yes. And you just mentioned earlier that you are aware that there were some discussions between Willowbank and I don't know if you said Fulton and Hogan, but the Quarry Opera as early as 2015.
PCC.
Can you just clarify whether
So-
that your understanding of that was that discussions between Willowbank and Fulton and Hogan or
PCC, Porirua City Council.
PCC?
This is way after we found out there's going to be a 5-year quarry.
Yes.
So when we found out there was a quarry, we were okay because it was for the greater good in the area. Right?
Understand.
We were willing to, we were a bit annoyed, but we were willing to, have a blind eye just for all the noise and all the disturbance because we knew it was for a short time and everyone wanted the transmission gully. We were happy with that.
Yes.
So when we found out they're trying to get it for 5 years, that's when we emailed Derek Voss, and Richard Hopkins and Nicola
Etheridge.
So Derek rang us. I don't know if you remember. And you also said you're going to send us an email, but didn't happen. So we were clearly, that's when we started, hey, this is not okay, because...
And look, like, we don't know how to deal with this stuff.
Yep.
So we were so thankful that someone from JIPS approached us, like, do you want to join? And say, yeah, we will be, because
Sure.
we don't know how to deal with this type of matter.
Yes. I'm asking these questions as useful background context.
Sure.
The panel has no jurisdiction to deal with those past matters.
I understand.
And yeah, I mean, there are other jurisdictions that can deal with
Yeah.
those.
Yeah.
100%.
But I just want to understand a little bit more about the due diligence that you undertook at the time. So prior to putting in the offer in July and having it confirmed in September of 2017, did you undergo, did you seek LIM reports from the council?
We all went through lawyers, right?
Yes.
As any property purchase, we go through lawyers.
Yes.
Our family lawyers are Gibson Sheet.
Yes.
Dave Robinson is our family lawyer.
Yeah.
So we went through that, but there was not. He doesn't have any of those information. It's purely between Willowbank and Porirua City Council.
I understand that. Just bear with me.
Yeah.
Did the LIM make any mention of any previous quarry consents, such as the consent that was granted in 1993?
Not that we knew about it.
Well,
No.
not that I can remember, because that's when we started doing our research, and
Yes.
that's when because this is all after the fact, and that's when we found out there was actually a previous quarry in there.
Yes.
And then we knew that there was an access track being built at that time. I think it was already built.
Yeah,
before we
they were
reached the quarry.
building something. We didn't know what it was.
Yes.
We just thought it was residential area.
Sure.
Just like any rural neighbor, we just keep to
Yes.
ourselves, and we don't care about what other people do.
Sure. Look, I'm not going to take these questions, and it's not a blame game or anything. I just want to understand the context. So what you're saying is that you weren't aware that there was a previous quarry operating in the 90s that closed around 2000 until you became aware of the 5-year consent.
Yeah.
Right. Okay, thank you. And that's probably as far as this panel can take that matter for the reasons I've just outlined. But appreciate that. We will have some questions on your more substantive concerns about effects. But is there anything you want to add before I hand over to the rest of the panel? So I'll ask Commissioner Burge firstly too.
Thank you. I just want to understand the noise effects from your property. You said earlier that you sit outside with your morning cup of coffee and the noise is annoying, and so you go inside. What is the noise that you hear?
Crusher. It was the crusher that made me realize what's going, because we didn't know about the quarry, and then when the trucks came, we just thought it was about farming related. And when the crushers came, I didn't know what the noise is, because the crusher is like.
It's like
So
an
that's
echoey
when,
sound.
yeah, so
right?
that's when we started asking questions. So in terms of like sitting outside the property, the photo that I was showing adjacent to that is just basically the quarry. So any machinery noise, crusher, truck noise, and even the blasting noise, we could hear it, and not just the vibration.
So I'm just writing as you say, so sorry.
Can I add to that? We really noticed that when we were working from home. Before that, we were, due to COVID, everyone was working from home. Mika was there all the time. We were hardly home. And
it was after March 2020.
2020. This is about
Yeah.
like 2020.
Yeah.
But we were okay because we were hoping that it's going to finish.
Yes.
And we didn't really make a big fuss or make huge complaints or, chase people up here and there, because we know it was going to get completed at the end of December, or when Transmission Gully is completed.
We were approached by neighbors saying, hey, there's a lot of noise. Are you, we were like, yeah, because, when we're inside the house, we cannot hear it back in, because...
Well, you've got triple glazed windows,
Yes.
so that must be
Yes.
a big help, yeah.
Yeah, but, summer, you could hear it because, everyone's outside.
Outside.
The night works as well. We could hear them.
We have a dog, 13 years old at the moment, right? So she needs to go toilet every few hours. So at night I used to wake up and I'm like, oh, what is this noise? So we didn't know it was a crusher. We thought there's some work going on somewhere. Or trucks. Then the neighbor said, hey, it's a crusher. It's they're operating at night time, because we didn't know anything about it. Because we were the last one in the property, in the road. There's the closest one at the time was 294, and that's few hundred meters away from us. So we hardly see each other, so we don't talk much. We only found out from neighbors approaching us saying this is what's happening.
So the largest sound you hear is the crusher, but you hear trucks and any other machinery, and obviously the blasting. You clearly hear that.
Like the truck noise, it was annoying, it was frustrating, but we could go inside the house, close the windows, and then we could barely hear it. But it's the blasting and the blasting and the vibrations that really drove us to the
Crazy.
edge.
Yes, yeah. And so you also said about the blasting, you would leave the property. They would notify you of a window of when it's likely to occur, but what I heard from you is that window was being extended, and that was obviously impacting on, as you say, your enjoyment of the
and
property.
as a matter of fact, we were not even part of the list. So we would be feeling all these vibrations, and I would be like having these panic attacks, in tears. What's going on? Checking GeoNet. Is it an earthquake? What's the magnitude? It's not an earthquake, right? And that's when my husband contacted Pole Nation, and Pole Nation was the one who suggested contact this person and get you to add it on the list. So when they started emailing us and giving us notification, yes, it's helped, but it also meant that I had to get out of my property. I had to go to a cafe somewhere else and stay there for 4 hours and text my husband, has there been a blast? And then I'll go home.
Yeah.
And at that time, it was very difficult because my son was just born. He was a baby, and just imagine the stress of taking care of a baby and dealing with all these vibrations. There was only so much that I could take at that time. I'm not trying to being like, a dramatic person here. I'm a very rational, reasonable person, but I just want to give you an idea what it's like living under those circumstances.
I think you were here earlier when Rob and Lauren were talking. One thing I noticed from what they were saying was Lauren thought that if there were more blasts, if you like, of lesser impact at your property, she would find that a little bit easier to live with than the intensity than as what she was experiencing at the moment. Could you comment on that?
I'll let Mika go first. Yeah.
No blast is better.
Yeah.
Right?
Okay.
I wouldn't want any blasting. Because if you multiply that in 35 years, that has got to be some sort of impact. But if it's to mitigate, then yes, certainly it is better than having a massive blasting that, drives us out of our property just to not to experience it. I will take anything lesser than what I have experienced if it means that it would make my life easier. But certainly my position is I would be seeking for no blasting.
Sure, no, I understand that.
But as a compromise, then yes, it's it's something that we could. I mean, it's really like difficult options,
Yeah,
like-
I know, I totally agree. I'm not putting you on the spot. I'm just trying to understand how you felt about what her explanation was or her, compromise
Yeah.
could be.
Can I add to that, please?
Yeah, sure.
I think it's okay, like for like, you feeling okay, like you just little blast, it's something you won't get a fright, it's like, oh, okay, that's okay. I mean, for property damage wise,
Yes.
I don't think anyone's property in the area is built for that amount of blasting, or frequent blastings. I don't even know even the insurance companies know what's happening in the whole Judgeford area. That's pretty much a non-disclosure for all the insurance companies, because they would pretty much have a blanket rule saying, hey, if you live in Judgeford or Murphy's Road, we can't give you insurance.
Yeah.
Because none of the properties are built for that blastings.
So would yours be roughly, apart from Lorraine and Rob's, would yours be the newest property on Murphy's Road?
Yeah, so we
got
roughly?
the
Yeah,
2020, we got the Code of Compliance.
Yeah.
So it's a brand new property.
Yes, we drove up there. We did a U-turn at your
Yeah.
at your entrance.
Yeah, I saw that little Swift.
Yes.
Yeah.
We were swiftly doing it.
Yeah. Yes. So it's a brand new property.
Yeah.
But engineers didn't do a
Well, they
structure.
weren't aware of
No.
that, and so maybe some sort of design parameter might have been different.
So we spoke to a structural engineer.
Yeah.
Right, so at that time, we were looking for an expert to assess the property, so we get a baseline, and to actually assess the property if there had any damage following the Code of Compliance. He's basically explained that because the geotech report suggests that the eastern bedroom of the house sits in a rock, the piles are drilled down to up to 2 to 3 meters. He's basically saying that the vibration would have hit the piles, and then it would work like a tuning fork.
Yes.
So it would hit the piles, and then the top would go and vibrate. So he would have at that time his opinion was that the cracks was caused by that. But unfortunately, he couldn't provide us a report because he is currently working on his New Zealand registration or license or whatever that is. So it wouldn't have any bearing anyway.
Sure.
Certainly, it is an expert opinion.
Yeah.
But that is one thing we want to focus on, and this is what we're probably pushing, that monitoring. We need to have some sort of data, and we're happy to have our properties monitored.
Okay, I was moving on to that.
And to actually have a baseline, so we could actually, if there's any damage, we can say that this was caused by the vibration, and therefore we can act on it. Because currently we're just headless chicken. We're blind. We just don't know what to do. If we have damages where someone would say, "Oh, you have to prove that it's caused by the quarry," I mean, how do we even prove that? Our house is new.
So what you'd like to see is a line in the sand now, and so if the quarry was to operate, that you'd like to have some sort of monitoring equipment, appropriate monitoring equipment on your house, that if a blast was to occur, that would be able to pick up if there was any movement at your house. And that
And it
would be a
has to be-
baseline. We can't sort of deal with what's happened, but we can certainly look at how to deal with what might happen. Yeah.
And certainly, what would that mean? What would that mean if there is damage?
Yes,
then
and a
what would-
process to then, after that, no, it's not just monitoring for monitoring's sake. It would be to pick up and what process would happen after that.
And I also want to stress that I do not believe that we should shoulder that cost. We have spent a lot of money even just to get into this hearing and to get experts and to give us advice how to deal with this whole process. I don't think we're in a position to spend any more money to self-monitor or like pay for any other experts
Sure.
to establish this baseline or for whatever purpose that it is.
We believe that Porirua City Council should have done that from the beginning because we are ratepayers. We pay a lot of rates for being rural itself, and there was nothing done, or we haven't been approached by anyone to do any monitoring. We are very happy. You know, we would be very happy if they asked us.
Yeah, I mean we're reasonable
in 2017.
people. They could put their equipment in there. We would take time off from work and then help them, assist them just to get achieve something.
Yeah.
But we didn't even get that. We didn't even get a visit. We didn't even get a phone call. The only phone call we got is from Derek Foss, and that was basically it. And in May from Karen, but absolutely neglected.
That's me ringing her.
Oh yeah, Shamali and Karen, but
Yeah.
absolutely neglected and basically left on our own. We don't know how these things work.
Yeah, no, I
Coming into
understand
this
that.
hearing is nerve-wracking for me, and it's so stressful to talk about all these personal stuff.
No, I understand. We do appreciate that. I guess just one other thing I just wanted to touch on was the dust issue. You say you came from a concrete jungle. You're now living in a rural situation. I mean, I live in a rural situation too. We get dust regardless of anything. I just want to understand whether if you can attribute that dust to the quarry, or can you maybe attribute that to normal rural living with the windows open as well?
We actually talk about it quite a lot because, could be from the road, could be from just in the area, farming, activities. But can you prove it? Can you prove that it is not silica dust? Can you prove that it is just farming? It just from the road.
Yeah.
But there was no testing done. If they did testing, then we would have been like, okay, that's okay. Just dust being living here. We are quite.
So you'd like confirmation, if you like, that if it is just dust, well, it's just dust. But if it's got something that's not just dust, you'd like to know that.
Yeah,
And
especially silica dust. As I said, we have a 2-year-old.
So they've now put that in the conditions or something. But anyway, we tried to mitigate dust.
Yeah.
We've planted grass. Do you plant grass? Seeded the lawn.
Yes,
we changed the whole
do plant grass.
Yeah.
Make sure that that it grows and covers the dry
we noticed
area.
you've got extensive plantings around your place.
Yeah, so that's our effort to get it. Mitigate the dust that's coming.
Yeah.
And also the bund, if there could be some vegetation there as well. And I think, if it could stop something, then that would mean that it would have achieved something.
In summer, does your lawn dry right off and go brown, or does it remain green?
Depends on the season. Like
Yeah,
last summer it was dry, so it does get a bit brown.
Yeah.
But what we did was we changed it. It used to be gravel, metal. Now we've we had topsoil and planted, and we're just going to concrete it. Probably in a couple of months, we're just going to concrete the whole area because we cannot put up with that anymore.
So this is why I raised earlier about testing water tanks. So, how can you prove that there is no contaminants in there, or no silica, whatever it's called? I'm not an expert. Either the applicant or whoever should try to make some effort to actually test some of these tanks and just make sure that we're not ingesting them.
Yeah.
We've already changed our filter.
So you would have heard our conversation. We came back just from afternoon tea that we've asked the applicant to look at, some sort of package that's going to identify if something's leaving the boundary, which means potentially entering somebody else's property. So, it'd be good to see what they can come back with that. Thank you. I appreciate your effort, and thank you very much.
Do you have any questions?
I'm just going to invite some questions from Commissioner Mark Brown.
So it's got some questions on the damage that you showed in the photos. Could you tell me roughly when that started?
So we actually didn't notice the damages.
Right.
Right, because the eastern wing of our house, no one lives there, and that's how we designed the house, because we have a big extended family. When they come in from overseas,
right,
that's their area.
Okay.
So we don't go check the damages. The only time we actually checked it because one of our neighbors raised damages in their house, and they said, they asked us if do you have damages, so that's when prompted us to check for damages, and I believe that was just after I gave birth.
2021.
No, 2020. About 2020.
Is it? Okay.
Yeah.
Okay.
Just around the building consent.
Oh, yes. Yeah.
And have you repaired it, or is it just still the same? You've just left
We're
it?
just going to leave it because we don't live on that wing.
Yeah.
We're just going to keep
Has it got any worse with time? Do you know?
So it's we measured the gap. It
Yeah.
used to be just hairline, and now
Yeah.
it's starting to expand.
So
And that was during the blasting until April 2021. And since then, I haven't really noticed any new cracks or hairline gaps or further damage.
Yeah. So it's just the eastern room with that damage to the corners plus your sliding door. Is that?
There are damages around the house, especially so the area that sustained most of the damage is the eastern part of the house, but there are also damages on the western part of the house, our bedroom, our ensuite, and my son's.
Mostly sliding doors, big sliding doors. They and the entrance door, very hard to close. And our sliding doors, you could just push it with
You
one
could just
finger.
basically
Not
just any
anymore.
sliding door.
So-
Now it's just
Yeah.
you have to.
So
push
especially
it and
the
drag
one going out of the kitchen, you just got 2 hands. One from the media room, it's a hard push to lock.
And have you done anything about trying to repair that, or that's just?
We have companies that could repair it, but we need to. We are talking with our lawyers at the moment. Which channel to take? Yes.
Yeah. Okay. Thanks. That's all I have.
Just before we finish, just a couple of things from me. We would like to visit your property, and we need to arrange a time for that, and we'll do that through Ash. Is there any particular time of the day that's particularly suitable for you?
Look, we're very flexible people, but maybe just
son is in daycare.
after 9:30, because we drop off our son or pick him up.
Yes.
So between 9:30 to 4. would
Yes,
be-
thank you. Certainly useful to have the images, and particularly the aerial photographs and the constructed aerial photograph that you put together. That's useful, given that Google Earth doesn't show the quarry. But it's no substitute for a site visit, and we want to take that opportunity.
Thank you.
It's difficult to know how to follow that up with further questions, given your relief that you specified in your submission, which is to have the applications declined, and that's quite clear. But I just wanted to explore with you, not in terms of any particular conditions, but whether you might have an appetite for, if the opportunity was provided, to comment on a final version of draft conditions that might come from the applicant and the council. I don't want to offend your sensibility in terms of undermining your primary relief, which is having the application declined, but would that serve a useful purpose or not?
So we have read them, and we're in a position that, I'm talking about the conditions.
Yeah, this would be any further iteration of them at a particular time. Would you find any benefit in having the opportunity afforded to you to comment on them?
I'll be honest with you. If the quarry is going to go, we don't want to stay there. Yeah. Pretty much, we can, we don't want to stay there. So we didn't buy the property, we didn't build the property with a quarry next door. That's the bottom line. And we, Paul could, add to this. When we bought the property, we had a subdivision clause removed because we wanted to further subdivide and build at the back. And that's even closer to the quarry.
With the future building platform with a yellow cross.
That's even closer to the quarry. So the land got zero use for us. I mean, it is pretty much...
So, Mr. Corrie, that's precisely why I asked you that question. Is there any appetite to view those conditions, or is that going to undermine your primary relief that you're seeking?
I don't think we're in a position at the moment to answer that. We are seeking further advice from our
lawyers.
I
I
hope
I hope you understand as
I
well.
do understand that, but I am going to have to put a time frame on that for an answer, I'm afraid. Not necessarily today, obviously, but by the completion of the hearing on Friday.
Yeah,
we can
definitely.
have,
We will have an answer.
Okay, thank you. Look, I'm going to ask this next question, and it relates to the question I just asked about commenting on conditions. Has there been any attempt by yourselves to contact the applicant directly to come to some sort of accommodation or arrangement regarding some of these matters, particularly baseline condition on monitoring for structural damage, repairs of structural damage, and particularly in relation around the property damage issue? Has that's just a simple yes or no answer?
No.
No.
We met at the golf course. I think we had a brief chat with the manager. That's about it, and just said, if you want to come and have a look, we are most welcome. We're happy to accommodate, but that's it.
Yes.
Nothing further.
Yes. Is there a willingness to
Sure.
do that on your behalf?
Yeah, certainly. But at that time, we just felt that the applicant should be approaching us because we have already raised a concern.
Yes. Well, the applicant's present. They're hearing your answer, and that's why I've asked the question.
Yeah.
Okay. I probably don't need to take it any further than that. But if you do see Rob and Lauren, could you? I should have mentioned it to them at the time. We will want to visit their property also. If you could mention that to them, and we'll make an approach through Ash to arrange a suitable time also.
Sure.
Thank you both.
Thank you.
Now, just a time check. I noticed Mr. Smith and Ms. Harrop are in the room. Welcome. Yes, you'd probably see we're running pretty late on timetable. I think we're going to go with Cheryl Anderson next. Is Cheryl present?
She's up here.
Hello, Cheryl. Sorry, I didn't notice you there. And we're going to pull stumps at 5:30. Cheryl, you've indicated 15 minutes, and Esther and Stephen, you've indicated 30. Is that a pretty? Is that a good indication of your time frame? Yes, we'll definitely hear from you then. And Cheryl, is the 15-minute estimation still valid? Yes, that's good. Well, it sounds like we'll get to you around 5 o'clock, and you'll be the last presenter. And Professor Irons, that means that we'd come back to you tomorrow at 1 o'clock, hear from the Judgeford Protection Society, and then from Tracy and Jennifer. And then
There's actually still some more residents that haven't, but Tracy and Jennifer will be there separately, not for JEPs, they're for themselves.
Yes,
And then the Stephens, yeah.
Yeah, the Stephens are the last ones. I don't have a list of any other submitters that have sought
No, that's good.
presentation.
No, that's good.
Thank you.
Sorry.
Are you good for tomorrow?
Oh, well, I'm reluctant to say now. Well, what I can tell you is the time we'll be starting, which is 1 p.m. And obviously, Ms. Williams and Ms. Walker, that's going to have a knock-on effect. You both, in terms of availability. What's your best guess as to? I mean, if we took the majority of the time available tomorrow, which will take us through to 6 o'clock, do you think we might?
I'm sorry, I've just been informed Tracy Davies cannot attend tomorrow. She's a prior work commitment. Yeah, she's already taken all day off today. I just let you.
That creates a difficulty, Ms. Davies.
I can make what with Tracy.
The suggestion that she...
How long did you have, Tracy? Do you want to have mine and I can come back tomorrow? No, because I've only got a meeting tomorrow morning, so I can do that.
That's a great accommodation. Thank you.
Thank you very much.
Sorry, just going back to you, Ms. Williams and Ms. Walker.
I'm available, but it does have knock-on effects to our experts.
Yes.
Dr. Greer is flying in tomorrow and leaves at 6:30.
Okay.
And Miss Ryan was scheduled to go 9 a.m. on Friday morning and has a commitment at 11 a.m. So
Okay.
is only available for that period as well.
Okay, we'll try and accommodate those people. In fact, we will accommodate those people.
Yeah.
Ash just need to remind me that they're locked in. In the event that we don't get through everything, we'll have to just come back on another day. And that's just the way it is. But what I need to signal is that the availability of the panel to get together is severely constrained within the next 2 to 3 weeks. And that's a function of other predetermined hearing commitments. And it's probably, there's some availability on the 29th and 30th of August. That was some time we'd earmarked for deliberations, but we would vacate those obviously. But let's just see how we end up tomorrow. And that was all predicated on a written right of reply, Mr. Matheson. Okay, thank you, Tracy.
Thanks.
And now, can I just clarify, are you presenting now in your private capacity or as a member of JEPS, or both?
I'm both, but I'm presenting for myself.
And now are you presenting for yourself?
That's right.
Thank you. Without further ado.
Thank you. So thank you for your time. I'll try and be brief, but I do have a few pages, but I can hand them in to you. I'll just email them through. So again, this is my lived experience at 233B. And I do want to just note, I did briefly submit. So I put in a brief submission because I've actually been the person that's authored most of the letters and consent application, responses for JEPS. So that's Greater Wellington Regional Council, Porirua City Council, Ombudsman, complaints, things like that. And I did step aside from the committee briefly, which was mentioned yesterday, because of a conflict with RMA reform work.
Okay.
And that's the only reason why I stepped aside. So before I sort of get into it, also I'd just like to mention number 53 Murphy's Road was mentioned yesterday by one of the experts, and it was mentioned that that person was not a submitter, and that person is actually a member of JEPS. And we have, and even though I'm not submitting for JEPS at this point, just like to note that we have tried to be efficient with the committee's time and not have everybody turn up and sort of submit. So yes, Fulton Hogan is a new proposed operator, but there are some constants here, and the constants are Greater Wellington Regional Council, Porirua City Council, and Willowbank. And that's actually relevant for things like consultation with the residents and the complaints and how they've actually been managed and dealt with. And in particular, duty of care to neighbours. So I've been listening to most of the hearing, and I understand that there's been comments made around how to predict, effects. And I would suggest that, yes, we can use the lived experience to predict what the future effects will be. And in my view, the effects cannot be avoided or mitigated. And by that, I'm referring most obviously to property damage. And for us personally, at our property, the significant amenity impact has come from the access track location. And Fulton Hogan have called, and Willowbank Council have called lots of experts, and much can be said about modelling and predictions. But the reality is that we actually know what it's like because we've actually lived through it. And we can tell you that it's actually worse than what was predicted for that consent that obviously you can't do anything about, but that's still in play because of Section 124. So some of the facts are the behaviour changes when monitoring happens and everybody's on notice that the monitoring is happening, and we've witnessed trucks being flagged to slow down. Blasting has exceeded the limits and damaged houses and property. Residents have been told to prove it, given the runaround and misled. Proof is difficult without a baseline. Having access track on the boundary of most of the properties down Murphy's Road on that side means that amenity is significantly impacted for most of that side of Murphy's Road. The amenity impact is so great that many of my neighbours have either sold or are trying to sell, and they have been living with a lot of stress. And while we could argue that, well, if people have sold, then it can't be so bad, we don't have the counterfactual of what people would actually have achieved for their property sales if there had not been a quarry. In regards to noise, I can tell you that it's a typically very peaceful environment, and the trucks are loud, and I'm talking about very quiet trucks that have been run by the joint venture. They do wake you up, and you can hear them over your television in your double glazed lounge. The trucks by the joint venture, we've heard about them being quiet trucks, and they weren't allowed to do engine braking. I don't think this is the sort of activity that was actually anticipated by seasonal and cyclical in terms of the rural environment, given that it is talking about something that's going to be running for 35 years, day and night. So I also heard comments about the noise and vibration expert yesterday talking about what's appropriate for night, but not necessarily in the morning when they were talking about the crusher. And in relation to the crusher and the fact that maybe it wasn't appropriate to be running the crusher at around 7 o'clock in the morning was, well, people were waking up. Well, we have some night shift workers actually up Murphy's Road, including my husband, who was here earlier, who's a police officer, and Nadine Steffen's husband, who's actually a diver. And they don't sleep when other people sleep. So I think that these things are all, easy to say, but actually it's not really a reality for people. And I've heard I actually think I heard a statement, but I may not be correct, but I heard a statement that there's actually more birds now because of the quarry. I can tell you that there are more birds now that the quarry has not been blasting, and that in fact through lockdown and before that, when there was actually the blasting, we didn't have the bird life. So just want to talk to you about, just very briefly, a couple of points. So 233 Murphy's Road has got a lot of these landscaping rock walls. Now they're not retained walls, they're not engineered walls, they're just landscaped walls, but they're in fact been there for decades. And they feature in the promotional video that was done for the sale of the house before we bought the house. And I have an email that I've attached to this presentation that talks about how they were all intact when we purchased this house. Now, in the winter of 2020, and I don't know the exact time because we were stuck in the house and not really outside a lot, we had some large blasts, and they were abnormally large, and it caused 2 of the rock walls to come down. And so the damage was reported to PCC, and PCC said, go to the insurer and go to the operator. And the operator said, go to the insurer. And the operator also said, oh, but you might want to also go to EQC. And the operator also said at that time, well, it's not really our problem because the council consented it. So it's actually the council's fault. So the insurer said, after, they went through 6 months of looking at engineering and all the rest of it, they said, well, it's probably blasting, but we can't be sure. So then the operator said, this is the joint venture, well, we might be able to do something, but we can't call it. We can't say it's about this. We've got to give you some money and call it something else. And you know how you couldn't sleep at night? Well, maybe we should just give you some money for double glazing your bedroom windows and do it like that. Now, so where we're at is I went back to the joint venture in, I think it was February, and I said, what are we going to do about this? And they said, well, we can't talk to you anymore because we've been instructed that we can't talk to you by our lawyers, which is basically that bottom email. Now, what I will say about this is that Paul Nation did get in touch with me
and promptly got in touch with me, and he came with Shane, and they, looked at the rock walls, and, and they've said, look, they'll sort it out. And I think, if they do that, that's great. So, I'm not going to bag them for that. That would be fantastic. But that's not the reason why I'm raising this. I'm raising this because I shouldn't be, in this circle, and it shouldn't fall to Fulton Hogan. It should have actually fell on the previous operator, and it shouldn't have actually been the council telling me that I needed to go and talk to someone else. So, I in this matter, I look to the council and the previous operator, and this is one of the reasons why. We have to have a proper process and reports to show baseline and things like that. And I must say, when I did talk to Paul, he didn't say, show me proof and all the rest of it. He was very pleasant to deal with. And same with Shane. But the thing is that, if we're going to have something that's damaging people's properties potentially, we can't have people scrambling around having to prove what's what and all the rest of it. So it has to be a fair process. And so those pre-operational reports, whatever they look like, pre-blast reports for people where things have gone wrong, it's not about a feeling. I've heard people saying, and people might feel safer. Personally, I don't care about the blasts in my property. Apart from that, I'm not worried by blasts. They don't bother me. They don't bother my kids. It's not an issue. The blasting doesn't actually bother me. But I can see that it's a factual matter for people to be able to prove that if something's happened to their property, to get any recourse from it, they need to be able to prove what it was like before and what it was like after. So if you can't prove causation, you're pretty stuck. Anyway, I'm nearly finished. So this here is just a bit of gives you an idea of the property. And what it shows, though, is the access track is sort of on the boundary of the property, up just on the other side there. And I noticed that there were some measurements that were uploaded to the site, I believe, yesterday afternoon. And I found it quite interesting because there was no measurement for the access track to my property. It was one of the ones that didn't have a measurement. I can tell you it's about 300 metres from my house to that track. And it's about 40 metres from the track to my spring water supply. And the picture that was on the front page of the slides is actually a landslip just above the water supply from the spring, which has got nothing to do with blasting. It's actually just showing the erosion of the land in the area is, it's get a lot of slips. It's a fresh one. But... so the access track, I guess my point being, the access track is the main amenity point for my property because of the noise. Currently there's a lot of pine trees, obviously, there that are between the track and the house. And that's unfortunately, they're going to have to come down because they're actually threatening the house. You'll notice when you come around the road, when you head up to 233A, they're huge and they actually have to come down. And that's unfortunate because I think they are actually shielding us from quite a bit. But the fact is that the night works was the main issue for me. I must say, I pretty much was not too wound up about it all until we had the night works. And we were told, I actually told the council before the night works that I objected to the night works because I was finding the noise during the day quite bad. But the night works were consented on the basis of getting transmission gully done and getting out. And that's actually what people were told. They were told, you're going to suck up these months and then it's going to finish. So we lived through that. I slept in another bedroom. People were told to use earplugs. And it wasn't great because even though I actually think the drivers were pretty respectful and good and all the rest of it, I didn't think there was any terrible behaviour. But when
from my perspective, that I had any issue with. But it was just, if someone got stuck on the access track, or if there was some sort of issue, or someone had to stop the truck or something, you would get woken up by it. So I mean, nighttime noise in particular, and I think that's because it's so quiet, and then there'd be a truck. So quiet, and then there'd be a truck. So it was a major issue.
Just on that,
Yep.
Ms. Davis, can you give us a sense of the time frames associated with the night noise, night works?
They went through the night.
They went 24/7.
Yeah.
Okay.
Yeah. So and that was just for that period of time to get it done and out is what we were told.
So that was truck movements and quarry operations 24/7.
But for where I am in our property, I do not hear the crusher unless I've only heard it a couple of times, quarry noise, and it will be if it's, the wind conditions and all the rest of it have to be a particular way. And then I have to be, outside to really hear the crusher from my property. But the access road, I hear all the time.
Yes.
So for my property, it's the access road.
Yes. We'll be very keen to visit your property too, because we struggled to get a view of that. And you can imagine that from both Murphy's Road and from the quarry site.
Yes.
Yes.
Yes, yep.
I think
You're welcome to come.
See the fence. Was that one?
Yep. Yep.
Yes.
So that's up the top. Yeah. So that you would have been on our road, but you would have gone up to the top.
But even from the quarry site, we struggled to get a decent view of your.
Yes. Yeah.
I think we saw some fencing.
Yep.
But whether that was your fencing or your neighbours, we weren't too sure.
Yeah.
Maybe because you've got a red roof, haven't you?
Yes, we have.
Yeah, so
Yes.
maybe we did from some position.
Yeah.
I don't know
Up
where
on
we saw.
Murphy's.
Yep. Yep.
Yes.
But not from the quarry.
No, we saw a fence from the quarry, but we're not sure whether that was.
It probably wasn't ours. I don't know, but you are welcome to come.
Fence was in terms of 233A.
Yeah.
Yes, it was. It was either
On the top. I've got a good picture of that in a minute.
Yes. Okay. Thank you.
So quickly. The road. It feels like it couldn't actually have been put any closer to the properties, to be honest. So I've heard about, the need for certainty of investment for the applicant, and Fulton Hogan has spent, a lot of money, and low millions was mentioned. And I've heard about how integrated the farm is in the community. And the residents have had to fund an opposition because they were told at a limited invitation meeting that was attended by PCC that many of the neighbours wanted to attend and were excluded from, to bring our experts, bring our lawyer, and because, Fulton Hogan wanted to go to the full extent of the RMA. And I can understand that from a, financial point of view, but, that's kind of fighting words from the outset. And, we didn't receive the draft conditions that went to some other people. So it got sent to Rob and Lauren, didn't get sent to Jeps, didn't get sent to me personally. We had to do a bit of a game of Go Fish to just find out what the document was, and it was a bit of an interesting exercise. And residents were excluded from meetings that were happening because they were told they were not affected. Earlier I heard about a meeting, a pre-hearing meeting in April. First I heard of it. So what I'd say to that is all of those points about investment and integration in the community is that the residents are integrated into the community too. We also go to ground up. We also support the trading post. We also have children at the school. We also live there. And the cost to the residents is high, and the impact on their amenity is great. And, for me, due to the access road being where it is, it means that I, like Shamal and Mika, won't be able to build on that section that I just showed you at the top of the road. So this shows you the access road, and continuing that way, you continue past the top of my section. And the photo on the right is just the approximate location of the track now, and the spring water supply to my property. So it just gives you a bit of an idea. So this is the area that was, pretty much you can't see from the road because of the pine trees, but this is a potential building site that in reality, because of the location of the access track, you would never build there because the access track is on the other side, not directly on the side, but it's, very, very close to where this is. So, I mean, I guess just on one more point on that is that, I've heard, about the access track. So the access track was funded for building, TG, and it was funded by the taxpayer. It wasn't funded by the joint venture. It was, as far as I'm aware, it wasn't funded by Fulton Hogan, was it? Don't know. But we have heard that Fulton Hogan is great at building roads. Maybe they can move the access track away from the houses, because I think that would be a significant improvement. This is just a picture showing a typical morning trying to take the kids to school, taken outside Willowbank, and, on the 2nd of August. And just one point that I'd make about this is drivers are very considerate, behave in a considerate way, trying to let people in and out of Flighties and Murphys by slowing down and flashing their lights, or almost stopping sometimes so that you can come in and out. And, and sometimes it's people trying to be considerate that actually cause accidents. Yes. So I just want to make a couple of departing comments, really, but 4 questions. But, I heard on Monday about how protected the quarry site was when we were discussing visual amenity effects or visual impact. And I heard someone say out of sight, out of mind. Well, from history, it makes it really hard to know what's exactly going on when there's additional noise outside consent hours, when you can't actually see, but you know that there's a noise. And that's because of, I think, the dual use. PCC is frankly not resourced for monitoring and enforcing this type of activity. Monitoring falls on residents, or is, self-monitoring, which frankly is just not good enough. We've reported that monitoring coincides with peaceful activity. Numerous breaches have been reported to the council and the operator, and obtaining accurate information has been challenging and difficult. When you make an OIA request to request all complaints between a particular period, you don't even get your own complaints reported back to you. So I would suggest that there isn't actually any accurate record of complaints when the council can't even, provide you with your own. So also, I think, the most concerning thing is that it might be standard practice that you have these management plans, and that a lot of the detail gets sort of delegated down into that, like some sort of second sort of tier, regulatory mechanism. But my concern is that what sits in those management plans and the status of them and how they'll relate to compliance and enforcement. And I'm pretty sure that earlier I heard, discussion, I think when we were talking with Rebecca Sternman, about how, breach of these conditions in a management plan wouldn't, certainly wouldn't have any impact on, the actual consent being stopped or anything. So I think as much as possible, the conditions need to sit in the consent, not in the management plans, as much as possible. And need to be very transparent about what will actually happen when people are not complying with what's going on. How will anyone know if the trucks are not complying, if they're not being, recorded and monitored all the time? How will we know that the trucks are actually going down to Haywards? And then if they don't go down to Haywards, given that, that's not against the law, what happens? So in our view, my husband and I are of the view that this is a completely incompatible activity to living in our rural lifestyle setting where people are already living. The amenity effects were documented in our submission on the proposed district plan. And the reality is we sucked it up for the greater good, and now it's time to actually put things right. And we ask that you not allow what has been a non-compliant activity to continue in just a different form. And finally, I like an analogy used by my husband. You know, the quarry is like a relative that comes to stay to get back on their feet, and then it gets so comfortable that they don't want to leave. Well, I'd like you to ask them to pack their bags and take their toothbrush. So that's all I have really to say about that.
Thank you, Ms Davies. I'll just check and see if there's any questions before we head across to the last submitter for the day.
Yep.
I don't sort of have a question as such, but I would just like to recap a little bit. One that I took is you do have double glazing on your house, did you say?
Only in the lounge.
In the lounge. And that's something that you put in?
No, previous people.
And that was the other question I wanted. How long have you been living there?
So we moved in December 2019.
2019.
Yeah.
So the other thing you'd like to take from, a sort of a baseline line in the sand in terms of damage to property. Similar, you heard us talking earlier to early submitters, so I don't want to repeat all that because you've heard all that.
No, yeah.
So, but that's something that you would...
100%.
Yep. And your main issue is, so that's one of your main issues, and the other was the access track, the amenity issues arising from that, and any nighttime activity.
Yeah.
Although you don't so much hear the quarry noise, like crushing.
Yes, that's right.
But it's the access road.
That's right.
Nighttime activity.
Right.
Obviously, you've got a lot of trees around your place, so it's not the lights from trucks or anything like that. It's just noise and...
That's right. We're quite protected where we are.
Yeah.
I don't know what the noise will be like when the trees are removed, but I do not hear the crusher noise or the operational noise of the quarry in my location at all. It's not a problem. And I think that's because of where we are in all the trees.
Yeah.
But it's the access road. And I think because the access road kind of faces our bedroom and it's sort of, and we're a two-storey house, and that is the main issue.
So I don't know if you were here the other day when Mrs. Wilkinson...
I listened yesterday,
Yep. So it was one thing I did ask her was what sort of benefit are trees for noise, and she's basically said none, no benefit. So just for interest's sake for you for that.
Yeah.
And the other thing I took too was this whole complaints issue register process and how that then gets managed after lodging a complaint.
Yeah.
So would that be a rough sum up of your main issues?
Yeah, I think it's just around, it's easy to kind of say things like, we're going to have a, complaints process or something, but it's like, well,
what happens?
What's really going to happen? Because historically, and I don't want to take up any more time, but historically it's not really meant anything.
Yeah.
You can pick up the phone or you can send an email to the council at 2:00 in the morning, like Derek Voss has received from me, saying, hey, I don't know what's going on. And, you find out the next day that a truck was stuck somewhere or, and everybody's all very apologetic. But then, when that happens kind of like once every, couple of days or week or whatever, and there's no consequence.
There's a loop. You need a loop back, don't you, to find out what happened to your complaint?
So given that when monitoring happens, it's often really quiet, I do have a question about, the noise limits and, it would seem that it's noisy enough to just reach the limit, but never seems to breach it. And it's because, what happens is when we make a complaint about something, the quarry would get notified and then everything would go very quiet for a period of time and everybody would comply and we would all think it was lovely. But then it would all go back to it. So there's no teeth in anything.
Yeah. Okay. No, thank you. That's very helpful. Thanks.
Commissioner Mark Brown.
A couple of quick ones. This photograph here with the dust.
Yep.
Is that looking at the access road?
Yes.
And is that when the access road's been sealed or before, when it's been sealed?
Yes.
Have you got the date for that?
I can get that probably from Cheryl, because I believe that's actually Cheryl's photo.
If you get the date, that would be good.
Yep.
And then my other question relates, you said your rock walls were damaged due to the blasting. So Did you notice that damage soon after a blast?
Oh, so it wouldn't have been like the next day. It would have
Yeah.
been like a couple of weeks. And this is the issue because it was winter.
Yeah.
And, you know, it had been raining and what have you,
Right.
and there'd been blasting. What I can tell you is, so we bought the house and not 6 months later, those two walls were down. You know, and that's, you know, they're rock walls, sure, they're not been engineered and they're not my house.
Yeah.
But it's just how, you know, with the runaround, that was the issue. Have been given the runaround to go and talk to this person and that person.
Yeah, no, I understand that. I'm just trying to ascertain. So it wasn't like a day after the blast, but it was within a couple of weeks of blast.
Yeah, when I went outside and had a look around,
Yeah,
you know.
okay. All right,
Oh,
thanks.
yeah.
Thank you.
Ms Davies, just two from me. First of all, what's the size of the land holding that you own?
5.4, I think.
Hectares? Yes. And that was purchased in 2019?
Yes.
Okay. And secondly, what's the primary relief that you and your husband are seeking from this panel?
So obviously we don't want the consent to be granted. But obviously I would appreciate an opportunity to look at the draft conditions, or Jep's lawyer to be looking at the draft conditions on our behalf. You know, I mean, I can't speak for my neighbours. They seem to have effects that are much greater than mine in terms of vibration impacts. I can't say that that will hold true for me if the blasting was to continue for 35 years. I mean, I'll be dead in 35 years. Personally, I won't be living at this property because I've got no interest to stay in a cycle of nonsense. I don't want to have emails about blasting. I'm one of the ones that I don't want to hear about it. I don't want to be emailed. I actually don't want to be on a community liaison group. Don't want to be writing emails for people. I don't want to be doing any of this. I never want to come here again. But it's quite a time-consuming thing. So, you know, ideally, we all go back to how things were before this was enabled to do something on a temporary basis. That would be ideal.
What I've written down is that your primary relief is that the consents be declined, but you're open to commenting on draft conditions.
Yes, thank you.
Thank you. Thank you for your presentation.
Thank you.
I'm just going to check.
Yeah, feel free. That one's clean.
Thank you, Ms Harrop and Mr Smith. 5:15. You indicated a restriction. Are you able to go slightly later if we need to? Yeah, absolutely. So if we went to 5:45? No, look, don't do that. Just, I guess the other thing I was going to suggest is we could come back, but you've indicated you've got problems with that, so you want to get it done today, don't you?
Yeah, it's not possible tomorrow or
I
Friday.
completely understand, but I don't want you to feel under duress to rush through your presentation.
Okay, we're good. Kia ora koutou. My name's Esther Harrop. I'm sorry for my attire, but I'm a colonel in the army and I came straight from work. And I'll let Steve, my lovely husband, introduce himself.
Kia ora, everybody. So my name's Steve Smith. I am a PE teacher at Taita College, secondary teacher, and run away today to come in here, of course. As you can see from the photo here, we'll go straight into it. Where we're looking at the sheep, that's looking from the back corner of our property, and we haven't got the little squiggles like everyone else has. But you can see our house, not the white thing in the right-hand corner, but the left, slightly to the left of that is a brown shape. That's our house, a cedar-clad house, 2 stories. Upper level is like hardy flex, cement board. House was built in 1993. It was built by Lynette Wharf, who owned a large part of Willowbank and the Quarry previously. So we bought it off her. It was built in 93, but we bought it off her in 2013. I'll just finish off these photos and I'll move over. And the one on the right there with the little calf, that's basically looking out our front deck off our lounge, and that's looking directly west, whereas the other one's looking north with the sheep in the background. And this is where the sheep are. That back corner will join Shamala Mika's place that adjoins their property. So we bought, like everyone here, we bought the rural lifestyle in 2013 to enjoy the peace and quiet. We'd come back from overseas and we'd had another child and another one in the belly. We've got 4 boys. So we thought, great, let's get some space and some land. And so they're now 17, 15, 11 and 8. And yeah, we loved it there. And we still do. Of course, what's going on, of course, doesn't make it pleasant. So what we've got 7.2 hectares. I think we've got 1.2 QE2 covenanted land, which is the forest you can see behind the middle sheep there. That was covenanted by Ms. Wharf, naturally occurring and planted. We have a spring-fed water source from up on Willowbank Farm. Goes about a kilometre or so up, or maybe a couple of kilometres up to Willowbank Farm, closer to the quarry itself. So that feeds one of our secondary tanks, drinking tanks. We've got a stream with native fish, kokopū and tuna and kura running out of our property. Originally, we shared the boundary with Willowbank, and then, of course, Shamala, Mika and Rob and Lauren and Nadine and Lee are across the road from us. So originally, we were one of the people who gave consent to the quarry being opened again. We were deemed an affected party, so I became good friends with Paul. I go to him for farming advice and that, and he's helped me out on numerous occasions. And we even had Charles came round, maybe invited himself round for, which we were open to. When we first arrived for a neighbourly catch-up, I think we had some scones or something, and one of the first things he said was, I never thought I'd step my feet inside this house. I battled with Lynette Wharf, and I battled to close the quarry down. And he was very passionate about, he closed it down on environmental grounds. And I was like, okay, great, yep, quarry's closed, brilliant. No hint at all that that's going to open up, of course. Further down the line, I don't recall when we actually signed consent, but Paul gave me a ring and said, come down, want to have a chat. So we'd often catch up. So I went down there, had a cup of tea, and over a cup of tea, Paul said, we're looking at opening the quarry up, as you all know, for a temporary period of 2 years or until transmission gully finished. Like everyone else, well, not everyone else, but we gave consent on the basis that it was temporary, national significant project, get it done. Everyone wants it done. The whole of the country wants it done. Get it finished, and what's the issue? It's going to be closed, right? And I believe there was also a condition, I can't recall the conditions, but everything was going to be remedied back to, good environmental quality. So I also signed that on the basis that Charles had already boasted about closing the quarry, so there's no issue there, and on the good relations we had with Paul.
Sorry, you might have mentioned the name Charles' surname?
Steiner, yeah, isn't it? The owner of Willowbank.
Okay, thank you.
Where are we at?
I think it's important to say that.
Okay. Yeah, so basically, because I guess as I've alluded to Steiner's previous stance on the quarry, we believe we could trust him and trust Paul, that the quarry would, there was no thought at all that it was going to go past what I signed. So I must say I feel cheated now that I'm not going to get emotional on it because it's not the place, but that it's now an actual thing that's going for consent and that sort of stuff. To me, it just doesn't seem right, but that's for you guys to decide. This thing here, push that.
Okay. So, given all of that, we believe that none of the original reasons that we provided our initial consent for the quarry exist anymore. So the negative impacts on our property, our lifestyle, the community and the environment have been significant from the previous lived experience and some proven experience and the submissions that have come to date. And that there's no reason why that won't continue for the next 35 years. So our position that the applications should be declined. So I want to say that up front because so we don't muck around.
So should I speak this one?
Yeah.
So we were away. We were overseas. Esther was posted with the New Zealand Defence Force. So the two of us and, of course, our 4 boys all took over overseas, and we went in December 2018, and we came back in February 21. So we were away when all the operations were happening. So, we did have some experience post then, but I guess we needed comment on our. Can you click it on? On our tenants, because they were the ones who were living the effects of the quarry. So I got in touch with them, and this is basically what they said. They basically said, it could be noisy. The noise seemed pretty constant. The register looks close. At night time, the noise can be heard upstairs in the bedroom and the toilet on the side of the house. And in summer, they'd hear the noise everywhere. So click on the explosions are there. Yeah. So sorry, we changed our slides up because we thought we had too many, but we have them anyway. So one of the comments which I think should be noted, which the lady who lived there, I think there was about 3, like a nana and granddad were there, and a couple of their kids, and their kids had a couple of kids. Anyway, she said the explosions, even with notice, are horrid. Feels like an earthquake as the glasses rattle in the cupboard. The poor children jump out of their skins. So unfortunately, it's hard to ignore and has impacted on a country lifestyle. So that was from our tenant. So that was her experience.
So I want to talk a little bit about that. I'm in the Army, 28 years. I've served offshore multiple times on operations. Okay. And my experience of the blasts since we've been back are very similar to Mika's. So even with notice, sometimes we don't get notice, sometimes we do or did. But even with notice, those blasts have a major effect on me. So I would need to leave the property if those blasts were going to continue. Not because I have panic attacks, but because it's an untenable situation for me to be involved in that after being experiencing blasts like that offshore. So I can say from experience that the blasts are not minor, they are not insignificant, and they are very similar to mortars and artillery that I've experienced in my time in the New Zealand Army. Oh, now I've lost my slides.
That's right, you get onto it.
Okay.
So we've only been for the tail end of, I'll get the tidy up part of it in 2021 of the quarry. So I was there studying actually at home when a few of the explosions went on, and I mean they're pretty loud, and the dog barks. And they're not the reason you go to a rural place. You don't go there to be blasted. And the crusher, you could hear the crusher. You've been asking before what it's like. So the crusher is pretty noisy. It's just an inconvenient noise that annoys you because it was never there before. So, and it was supposed to be closed. Okay, you got anything else on there?
Go to the next one.
Next slide. So damages. So these damages, none of these damages were in our house when we left, because we've got photos. I can show you all the time frames if you want from when our property manager looked after it. And upon arriving home, I slowly start discovering more and more damages. So alongside the door there's one, that's the front door. I don't know if it's to do anything with facing that side. All the damages seem to be on the side facing the quarry, so the eastern side of the house. And the larger one on the right is above like a sort of major support beam. Damages to our land. I know there's been plenty of rain lately. These are recent ones. The only time we've ever had a slip of these size was after the Kaikoura Wellington quake. So, I mean, I'm no seismic expert, but to me, it seems like the land is definitely getting more open to allow flood, water to seep in and slips occur. Environmental effects.
I guess just on that, just going back to the damage piece, and I'll talk about a little bit later about it, but the the lack of understanding about the effects and the lack of baselining means that, you know, none of this is easy to prove, and it won't be going forward if the consent is granted. So that baselining aspect that other people have talked about, we've said that we want that looked at, and I'll talk about that when we get to the conditions later on. But Steve's going to talk a bit about what we've seen and what our experience of the environmental effects so far have been, and admitting that we're not experts.
Yeah, so like I said, we've got the QE2 covenant on the right. So that right-hand photo is off our second story of our place, looking directly west, and the QE2 is on the right. The bird life, when we first came back, you thought it wasn't like it used to be, correct?
Yeah, but we noticed there's a lot of bird life, and you know, if you've got natives, 1.2 hectares of natives, there's a lot of bird life, huge amount of kiraru, waka, tuis, and other birds, and more so during the time that we were there before we went overseas. When we came back, it was absolutely noticeable, and that was during the time that the blastings had occurred, and following into our return, that the numbers of bird life was reduced. And we didn't count them, but we were absolutely adamant that that was the case. Now, this photo on the left was taken, there were 5 kiraru in a kowhai tree outside our house only about 2 weeks ago. So now they're returning, and I think that's because, like other people have said, that the quarry operations have stopped, the blasting in particular. You were going to talk about the stream.
Yeah, so we got a stream running down from the side adjoining the ridge which goes over to the quarry. I used to notice like kokapu, native fish, and kura, like the freshwater crays in the creek. I haven't done any, surveys, but just offhand, I don't really spot them anymore. I guess, that's the lack of having a baseline to start with would be helpful. In a previous life, before being a teacher, I was National Marine Mammal Coordinator for DOC. And so, of course, did a lot of work around marine reserves and that sort of thing. And we all know how important and ecological and significant the inlet is. So I'm concerned about what's going down there. There's already enough cementation from Whitby going into there, so let's not add anything else. Where are we up to? Yeah.
So this slide is just a summary of the adverse effects that we see and some of our experiences and our tenants' experiences. So obviously there's operational noise, everybody's talked about that, not just from the quarry operating, but then into the next point about truck noise and vibration on the access road and surrounding roads. The dust has been talked about. It's not just rural dust, that when the quarry's operating, we've seen photographs and we've been told that that dust is significant, so not just from the road but from the operation of the quarry. In our submission, we talked about our eldest son who suffers greatly from hay fever, and because of that he's got eye issues and respiratory issues, but also eczema. So we're really concerned about what the different chemical makeup of any dust from the quarry and the effect that will have on our kids and just on the air quality as a whole. But without any testing, we'll never know. The vibration from the blasting, we've heard from Mika, and definitely an experience for me and others that I've spoken to, and our tenants, that it's distressing and can cause mental trauma, and it's just an unnecessary evil that doesn't need to be there. Road safety is a big one for us. We've got a young driver, our eldest boy, and 3 more to come if we stay. And we're really concerned not about him driving on Murphy's Road. He's a good driver. He's been driving for a long time, but we worry about getting onto that main drag. And Mika described, when Mika was talking about that issue with her child in the seat on the other side of the car, I've experienced that multiple times, turning into Murphy's Road, coming from the village. It's a death trap, right? So the increased truck movements and the compounding risk to road users that takes on. We also have a lot of horse riders on our road. I'm not a horsey person, but there are a lot of horse riders, and I know that that should be something that's taken into account. Cyclists on the weekend, we get cyclists up Murphy's Road, believe it or not. It's like a challenge for them, the Lycra Brigade, and their use of 58 is obviously almost untenable with the truck movements and any increased proposed truck movements.
Yes. I don't want to interrupt, but we had a presentation this morning from Waka Kotahi, who outlined the upgrades to Stateway 58 between Flighties and Murphy's and Harris Road. Yep. Do you have any knowledge of those?
And we know about the
time frames it takes them to do things.
Yeah, sure, but we know about the roundabout at the bottom of Murphy's Road.
Yes.
And that's going to affect the bus stop, which is a big thing for us because we have kids that we drop to the bus stop. And Steve was out there a week and a half ago with his weed eating the bus stop because no one else does it, and our kids need to be able to see the road when they're standing at the bus stop. Just an aside, but yes, we've seen that there's a slow bay, there's a pullover bay, there's those kind of things are great, but until they're done, our suggestion is then the quarry shouldn't operate.
The facts that we were presented with, and I'll just share them with you very briefly, were roundabouts at both intersections.
Oh, right. Harris as well.
Yes.
Okay.
A wire median. Sorry, did I say Harris?
Moonshine.
Moonshine.
Oh, moonshine. Yeah,
Yes,
we knew
sorry.
about that.
Yeah, because if you have a car turning in, I'm sure people have said all this. If you have a car turning from the hut, coming from the hut, turning at the Flighties, and if you have a quarry truck going past, there's no room. If you're at the end legally where you can sit at the end of Murphy's, you'll get taken out.
Or if you're a child at the bus stop, you'll get taken out.
Okay, I'm just presenting the facts.
Yeah.
No, we
Waka
appreciate
Kotahi.
that.
So that just for your benefit, the inventory was those two roundabouts, some road widening, so a median probably in the form of a wire dividing device along the.
Do they specify time frames?
Yes, they did. Yes,
Okay.
we were told that funding has been approved.
Okay, that's great.
That consent will be lodged this year, and the aim was to begin construction in the 2023 timeframe.
That's great. Yeah.
So that's no evaluation involved, and that's the facts that we were presented with. We're also told that these works come under the banner of safety works as opposed to capacity works. So we had a senior member of Waka Kotahi providing that information this morning.
Yeah.
Okay.
No, that's really good, and we welcome all of those initiatives. However, they're not here yet. So that our position would be that the quarry should not be able to operate until those have been put in place.
Yes. What I would just add, and I don't want to sound like an advocate, but I just want you to have the facts in front of you, is that in terms of the long-term consent, there's a consent regime that speaks to a difference between those works being in place and those works not being in place. And that goes to the number of truck movements, the number of turning movements, that sort of thing. So the consent conditions that have been volunteered and by the applicant and commented on by Porirua City Council use the works being in place as a division between what can occur before then and what can't. And that is largely based on volumes of traffic using the quarry. That's a very simplified breakdown of how the consent conditions are structured. But again, I just wanted you to be aware of that.
Okay. Yeah. Thank you. No, that's all right. I'm a bit lost now.
Yes, am I.
So on your slides, our slides are different, sorry, because we had to cut them down to shorter.
We're talking about the bus. Yeah, we're talking about the bus stop.
So the bus, yeah. So we got through we talked about the bus thing. So road safety. Acknowledge that there are conditions around that. We still don't think they're enough. And we'll talk about the conditions later. Increased operational hours and the uncertainty and therefore the stress that's caused by this idea of additional hours as required, that just there's because of a capacity or because of a need, there was no from what I believed there was no thought or acknowledgement of that, the stress that would cause. So what determines a need, whose need, a business need, a national significance need, or what need. So the additional hours, but have real concern about. Direct effects of property, physical damage we've talked about. We're really concerned about and Steve mentioned it, the downstream wetlands and the effect that these operations, no matter what is put in place, could have on the Porirua Inlet. And I'm not sure that, in fact, I know because I was up until very recently on the board at the Pautahi Nui School, that there are many people that have no knowledge of the quarry whatsoever. And so I think that, and I talk about that later, that there's been so little consultation and so little publicity that that when it comes to fruition, there'll be a lot of shock. So I think I'm bringing that up now, but I'll mention it later too, that I think that the environmental effects on the use of the inlet and the enjoyment of the inlet will be affected. And I don't think it's been checked yet. I don't think there's been enough checking on that. The sensitivities and importance of that to mana whenua, and I don't know if you've had any submissions for mana whenua, but we've all got an obligation, PCC, ourselves as citizens of New Zealand, we've got an obligation to mana whenua, and I'm not sure that that's been appropriately addressed either. And the last one has been covered very well by Tracy and some of the others about the detraction to the amenity values. We too have plans on our to develop in the future, if permitted to do so, our property for the future of our kids, and unfortunately with a quarry on our doorstep, 577 metres away from our house, that's just not going to be possible. So these, in summary, are the. You need to click that.
I did. What?
Go back. Are our issues with the submission. So we believe that the baseline data that's been used to kind of justify all of this is uncertain. It's based on assumptions and modelling, but the actual effects and the lived experiences of our neighbours and our tenants during the worst of it should be taken into account. The impact on properties, neighbours, traffic and road user safety, air quality and lifestyle, and also the community have not been taken into account. We believe the environmental effects have been minimised and no ecological baseline was established to start with. No one came to our QE2 covenanted block of land and said, how many trees do you have here? How many birds are there? Let's do a survey so we can understand what the effect on that significant piece of flora and fauna is going to be from a quarry operating on your doorstep. We believe the draft conditions are insignificant to mitigate the negative effects of this. Insufficient, yeah. And they need amendment and some additions, and it sounds like you guys are in agreement of that. And we strongly believe and have experienced that the complaints process is insufficient, and we believe the required compliance and monitoring is weak. And the last point I alluded to before, and it's really important, the community consultation and consultation with neighbours and affected parties has been overstated in both the submissions and, in fact, it's been very poor. There has been no one-on-one consultation or communications with affected parties at all. So apart from the first meeting over a cup of tea that Steve had with Paul Nation, there has been no one-on-one consultation about this from Fulton Hogan as the applicant or anybody else. And if that had happened, everybody would have been a lot more informed. The neighbours would have been able to talk together more, and it's almost feels like it was done intentionally so that we couldn't exercise our kind of community right to get together. And in fact, I'll finish that one point by saying, because we were part of the initial consenters, these guys didn't talk to us for a long time and we didn't understand why. And then we found out that there were only like 5 people who were part of the initial consent for some weird reason. We didn't understand the process like Mika and Shamal. And so we we feel duped in that respect. If the consultation was as good as it's made out that it's been by the submitters, we wouldn't have had any of that. So we were not invited to meetings. And then when we asked, how come we didn't get invited to that meeting? Oh, sorry, we forgot you. We missed you out. Apologies. Or in another case, we asked the council to invite people, and those are the people that the council invited. So I've had one phone conversation with Simon Dine, which was very pleasant and very useful. But
you called him up,
he called me back because I was given his number and I called him. So I think that community consultation's been overstated. I'd just like to say that.
Just for the record, who is Simon Dine?
He's something to do with Fulton Hogan.
Right.
Yeah, Simon's the COO of Fulton Hogan.
Thank you. Okay. Is it D-Y-N-E or D-I-N-E? D-Y-N-E.
Okay, let's go.
Thank you.
Yeah.
Do you want to move to condition amendments and additions?
Yes. So I've given you a list of kind of the headings, and I've got a whole bunch of narrative which I'll quickly race through if that's okay. So we believe that the conditions need to be made public and kept current as they change through the drafts and through the iterations, so as to ensure the wider community knows and can ensure compliance with these conditions. On the subject of noise and vibration, we believe a condition should be imposed to ensure blast monitoring is conducted, and this should be paid for by the applicant. It shouldn't be the neighbour's responsibility. Non-compliance with that the blast monitoring should then be investigated and penalties should be applied. We believe a condition needs to be imposed that the applicant be made responsible for establishing that baseline building condition that's been talked about by other people, the condition of the surrounding dwellings in order to establish a baseline for the complaints to then be made against, if you like, if there was to be damage following that baselining. Around hours of operation, we believe that a condition limiting the hours of operation to weekdays 9 till 3 should be imposed to ensure minimal impact on neighbours' living conditions, and blasting should be publicly notified as well as via neighbourhood communications. So not just an email from someone at Fulton Hogan to a bunch of landowners that may or may not be complete, like Mika said.
So you mean a public notice in the paper?
Absolutely. Or any Facebook, PCC Facebook, whatever, as widely as possible, so that when that blast occurs, people are prepared and they understand what it is. There was some blasting the other day, I'll give you an example, and I sent Jenny a note and said, hey, we didn't get notification of that blasting. And Jenny came back and said, I'll find out from the council. So she wrote to the council, and the council came back and said, no, it wasn't Willowbank, it wasn't the Quarry. And I was like, well, what was it then? You know, I heard it was 2 blasts, it was at this time and this time. And we never found out. We still haven't found out. We just found out that it wasn't the Quarry, and we don't know what it was. And so that complaints process or even questioning process needs to be more robust, I believe. So to the complaints process, we believe the complaints process and register should be established and made publicly available. All complaints need to be logged and investigated by the council or their delegate. I know the council's really busy, so I'm not trying to put more work onto them, to determine that non-compliance or otherwise, and that action needs to be made public as well. We believe that these, I've talked about the baseline property surveys, but that would benchmark in order for the complaints process to be based, or from which the complaints process could be based. And then we believe the applicant should be required to establish a compensation fund in order to fix damages that result from the baselining, the blasting, and are determined to be linked. Regarding the community liaison group, we believe that the conditions should be amended or added to ensure that the community liaison groups has representatives from the affected parties and submitters, not just some randoms that are chosen out of the community, although they should be welcome as well. We believe that these people need to be selected and be representative of that group so they can appropriately represent the concerns of the neighbours and those affected. We believe that the activities of the community liaison group need to be recorded, so the minutes need to be recorded and made public, but they also need to be agreed to by the members before they are made public, so that they are a factual account of what happened at those meetings, and then published by the consent holder.
Yes, and earlier submitter, Mr. Neeson, raised those similar concerns.
Okay, yep, great. There needs to be some further independence to that community liaison group. So I've talked about having representatives from the affected parties. Obviously, the operators would be there, the council would be there, but there really needs to be some kind of overarching chair who's independent of all of those things, so that, not unlike yourselves, there would be a degree of rigour.
Yes. Are you aware that the condition stipulates that?
Oh, sorry, no, I didn't.
An independent chair be appointed.
Okay, great. I wasn't aware of that. Okay. Or if I was, I missed it. Sorry.
Thank you.
And lastly, that the members of the community liaison group should be compensated by the applicant for their time in forming that group and participating. Okay, and I'm getting there. Around the ecological impact, we believe that the applicant should be required to fund a study to establish a baseline of bird life in the QE2 covenanted block and other bush blocks of significance. As you know, there are others on Murphy's Road, including wetlands, to allow for monitoring so as to ensure appropriate impact mitigation is in place so that it can be tracked and understood. We believe that a condition should be imposed for the applicant to fund a study to do the same baseline of water quality and species in streams and creeks in the area, including the native and threatened species that are in some of the streams and creeks in the area, to allow for monitoring to ensure appropriate impact mitigation is in place. And this is especially with the impact of dust and potential overflow from the quarry. I know they've got these slush ponds or whatever they're called, so that overflow potentially from those in flooding. We believe that a condition in this one, based on some of the answers you've said to other people's, it might not be appropriate, but Steve mentioned earlier that many of the environmental stipulations about the quarry having to return to a baseline, environmental baseline, that was in our very original consent for the operation in the first place. We believe that hasn't happened, and we think that should be made to happen first before. And this kind of morphing into the next phase is allowing that to not happen, including the much publicised but non-functioning fish passage, that the only publicity that the community have heard about that is positive publicity, and we know that is not a functioning activity, and so we need to get the truth out there. And we also believe that the issues that were raised in the JEP-sponsored environmental assessment be afforded the appropriate attention and consideration, especially around the wetlands and Pautanui Inlet. Traffic. To the comments around traffic, to the conditions around traffic, we believe that the current conditions don't take into account all road users, and I mentioned cyclists and horse riders, but also pedestrians and children. We believe the bus stop is very dangerous for children in the morning, especially when vehicles are turning right into Flighties Road, and equally in the afternoon, children cannot cross the road from the bus stop, which stops on the other side at Flighties. A condition should be imposed to limit truck movement on State Highway 58, and I believe the expert transport person gave the same time frame, which was around 9:15 to 14:45, so that truck movement isn't moving outside of those hours to avoid clashing with school traffic and school bus stops and school bus route. We believe that the speed limit should be retained at 50 kilometres like it is now, and to the point about the works that are going to be done by Wakakatahi, we believe, as I mentioned before, that the quarry should not be permitted to operate until those works are completed. In closing, if it's not obvious, we oppose the applications. We are, apart from Mika and Mika and Shamal and Rob and Lauren, we're the closest house to the quarry. And we're also the oldest house that's close to the quarry. So we're single glazed, hardy flex wood house with lots of retaining walls. We ask that the quarry operations are ceased until such time as the remediation of the previous consent conditions are met, and that any further operations should cease until the roundabout at Murphy's Road is built and additional information is provided. We ask that the applications for consent be declined, and should the consent be granted, because all of the submitters that asked for it to be declined are overruled, we insist that it is for the short period only and with the imposition of the additional conditions that I've outlined. And I believe, and it speaks to this community engagement piece, that the applicant should be directed to conduct meaningful one-on-one consultation, discussion and information sharing with the affected parties and those living close by, as a good neighbour would. That's all. Thanks.
Thank you, Ms. Harrott, and thank you, Mr. Smith. Now, we could ask you a series of questions, but I think this is a very clear presentation. What I'd prefer to do, unless there's any pressing questions. Yes? Yeah.
Just a clarification for me, if you wouldn't mind. You were talking about the streams on your property. Do they originate from Willowbank and come through you, or do they come from another direction?
They originate from Willowbank.
Okay, and so do they originate?
There's two like little valleys.
Yeah.
On our, we've got 7.2 hectares.
Yes.
One of them originates from Willowbank and comes through Shamal and Mika's.
Yes.
And then down into our place, and then the other one on the other side only runs and it'll dry up in a dry summer.
Yeah. And so I'm trying to just ascertain is the quarry at the head of the...
The quarry's over the ridge.
Yeah, that's what I'm just trying to understand. Is so
it's not flowing.
The quarry's
from
not in the same, if you like, catchment as your streams.
No, but depending on what, of course, comes over from the quarry.
Yeah, no, I understand that. I just wanted to know if it actually came from the quarry. There are streams there that they're looking at potentially diverting and that sort of thing.
Yeah.
So I just wanted to know if your stream came from that, but it's not.
No.
Thank you.
Thank you, Commissioner Burge. We would like to visit your property also.
Love that. I'd love to show you around.
That's good, and we'll arrange a time that's suitable. We'll try and conduct those property visits on a single time so that we visit Rob and Lauren's and Mika's property also, and Shamal. That was the first matter. The second matter, in light of your conclusion, do you have an appetite for considering draft conditions when they are at a point where we could circulate them?
Absolutely.
Yes. So you would like to take up that opportunity?
Yes.
Okay, thank you.
However, it's written there that we want the consent declined. Yeah.
I always ponder about the wisdom of asking that question, because some people say no because we don't want to denigrate from our primary relief.
Yeah.
So, I'm asking that question to all submitters to get a response. So, in this case, it's the affirmative.
Yeah, absolutely. Yep.
Thank you. Thank you for staying on later. Appreciate that. And just before I close proceedings, we just get a sense of how tomorrow might go then. Yes. Yes. Okay.
Cheryl was the woman sitting there. She wants to come at 2 p.m. She doesn't want, because she can't come at 1. But
Okay.
She'll be here by 2.
So will you kick off at 1 then?
The Blakes? Well, I don't mind. Yeah, we'll sort that out. And there's the Steffens as well.
Yes.
John and the Steffens.
Okay.
Given that I've already had half of them before me, maybe we'll just do them all before me. But we're in your hands apart from
Certainly.
Cheryl. If you'd rather hear from me before then, we'll organise it.
No, I think we can do that at the end. Sorry, Sue, I've forgotten your surname. Sylvester, you were scheduled to go last, Mr. Sylvester, for the Stephens. You still happy with that? Yeah. Yes. Okay, and then once we've closed all the submitters, then we'll move to I think yourself, Ms. Walker's first of the rank. Yes, and your witnesses, and you have a definite time slot on Friday required for 2 of your witnesses. Is that right? Or is one on Thursday afternoon?
Definite time slot for Miss Ryan at 9 a.m.
Friday.
Dr. Greer is flying in tomorrow, and I believe he has to be at the airport tomorrow by 6:30.
Okay. Thank you. Okay, so he definitely has to be on tomorrow.
Correct.
And at a time. So what we could do is have a general introduction from you first up, and go straight to Dr. Greer.
He'll be fine.
Yes, and just work through your other witnesses, and 9 a.m. on for
Miss Ryan. Yeah, equality.
Thank you. And Miss Williams, you'll follow after that.
Yeah, so Porirua's all on Friday.
Yes.
I'm scheduled to go last, so all of our experts will go before me.
Yes.
The only expert with availability constraints, if it has to go to another day, is Mr. Button. He's away in the UK for 3 weeks after Friday, so
Yes.
he would have to go on Friday.
Do you happen to know whether Mr. Button and Mr. Robertson have had discussions?
It's my understanding they have, and that they were looking to come to a joint sort of position.
Okay.
I don't know where that's landed at this point.
Yeah. All I would say is where we've encouraged that to happen, and there is a joint position, that should be the starting point of officer presentations in terms of that issue. Yeah. There's no need to relitigate how you got to that point. Present us with that point, and then focus on any areas of disagreement. That's the most economical way.
And there has
proceed.
been considerable narrowing, obviously, in the ecological space as well.
Yes.
So I think there can be some real condensing of the time that
Yes.
Porirua City will require.
Yeah, to the extent that it assists the planners that are involved, and this is yourself, Ms. Williams, Ms. Walker, Mr. Baker. Clearly, conditions are of importance, but I don't want to undermine the importance of policy considerations. That's where our focus will be, and within the conditions, the duration and timeframes will be critical too. So that probably affects Mr. Baker and yourself, Ms. Walker, more than it does yourself, Ms. Williams, with the exception of the time frames in terms of the 6 a.m. to 7 and 6 to 10. So I'm not trying to second guess what your recommendation might be, but at the moment, duration's not even a consideration for you, is it? In terms of the 42A that was submitted.
Correct. The duration being recommended is 35 years.
Yes.
Yeah.
Okay. But your recommendation, as notified, was for decline of the application.
In the 42A report.
Yes. Thank you. Okay, Mr. Matheson, was there anything arising from that as we tick over 6 p.m?
No, that's fine. Just to note, we will circulate tonight a proposed project in Pauatanui regulatory review condition. A draft has been sent past GWRC. They have views on it. I just thought it would be helpful for anyone who wants to read it before we commence tomorrow afternoon. It's for discussion. It'll be tabled. It hasn't been agreed to by anybody, let alone GWRC, but we just thought it'd be useful if you guys wanted to have a chance to have a read of it before tomorrow.
Yes.
So,
will you circulate that to Ash?
Yeah, we can do that. And it's a starting point, but I think it's helpful rather than to put it at the end when no one's had a chance to comment on it. So
well, it's an evolution.
Thank you.
Just what time does the meeting finish? 1. Yes. No, it's fine. Okay. So just a reminder, we need to vacate today. We cannot enter the room tomorrow before 1 p.m. So might be a slightly later start than 1, but I just encourage you all to be ready. Oh, sorry, stand corrected. Possibly between 12:30 and 1. But we are alive to going later. We talked about 6, but we'll just see how we go, and if it's any later, if there's some sort of method of us making Friday easier, we'll do that.
If I may, just one more expert availability comment. Mr. McLean isn't available Friday 10 a.m. until I think roughly 11 a.m. or later.
Okay. Is he planning to attend via Zoom or in person?
He was planning to attend in person and will be attending tomorrow, but he's local, so it's not as much of an issue, I think.
Do you think there might be a possibility we might get to him tomorrow?
I hope so.
Okay, let's keep them on standby for that. Thank you, everybody. The hearing's adjourned for today. See you tomorrow around 1 p.m.